Dear participants, you're welcome to the first Riga Justice Leaders Forum, Responsive Justice 2022. And the forum is a place for regular discussion of justice in Europe, in the world, in Latvia, and we are planning this event to be annual, discussing about our goals and challenges, representatives of academic environment, forum as a leadership test, as an opportunity to search for questions we have at hand and react to the war in Ukraine. And now I would like to welcome the Minister of Justice of Latvia, of the Republic of Latvia, Jānis Bordāns. Ladies and gentlemen, honorable guests, dear colleagues, friends. This, indeed, is the time we live in, and it is challenging. It is challenging time, and it is no formal words. All the events that have occurred over the last 5 years show that justice leaders and justice needs to think about shifting, changing the environment and also the environment in the world in order to restore justice. It can only be done by leaders, and leadership has to be undertaken, this role. We cannot force someone being a leader. Either you are, and it has to be motivating for oneself. I hope and I believe that you have voluntarily come here, so you want to be the leaders. And as justice leaders, as you all wish and we wish to talk, to discuss, search for practical solutions to the challenges we face currently, right now, in the world. And they are one of the most important questions we're going to talk about. With the fundamental changes in the functioning of the society, it is clear for us also that each separate institution has to go and change with times and be able to also adopt. Otherwise, our citizens and how they trust our decisions and decision makers will decline, and there will be threats to the legitimacy of administration. Not only drafting of legislation and policy making must keep up with times, but also other administrative activities. Moreover, not only nationally, but also globally. Not only in individual countries, but in international organizations too. Justice sector is no exception. Quite the contrary. Justice systems in different countries in the world are the basis of secure and prosperous society on any continent of our planet. Without a fair and effective justice system, and also one within the framework, which operates within the framework of generally accepted international law and national constitutions, without the justice system, we cannot imagine prosperous and safe states. Unfortunately, not all countries are like that. There are those who violate international law and use their justice system to carry out repression, both against other countries and their own citizens. Such country is modern Russia. For them, it is not enough to have attacked a peaceful, democratic state for no reason. It also represses their own citizens who have been able to keep a clear head in the stream of propaganda lies. This is why one discussion panel at the conference will be devoted to discussions on how to end Russia's war and hold the occupiers accountable for the evil they have done. We will look for legal ways for all free world to rebuild Ukraine together. We need to restore international legal order. We will look at the Ukrainian panel as to whether there are mechanisms in Europe set up after the Second World War, and are they sufficient to bring the justice back to those responsible for crimes committed in Ukraine. I can already confirm that the Ministry of Justice, where I am the head, which have thought about and they take care about justice in Latvia, and we have thought about how to help the whole world in this context, and maybe we're very close to finding internationally acceptable solution, how in compliance with international law and national constitutions to confiscate or expropriate the property of belonging to state, to physical persons, to legal entities. And I wish everyone a successful conference, and let this be a beginning of a tradition of annual Justice Leaders Forum, and together we will win.
Jā, paldies, Bordān kungs.
Thank you, Mr. Bordāns. And it is also possible to follow the forum online on YouTube channel. And I would like to remind that today we have two working languages, Latvian and English. And
Second for Latvian. Bet mēs sāksim ar pirmo paneļa diskusiju, un kā jau līderi.
we will start with the first panel discussion. As in a leadership forum, we also for this panel discussion have the leader, who is Mr. Māris Vainovskis, representative of Official Latvia, also Mr. Aigars Strupiš, Chief Justice Latvia, Mr. Ramin Gargunbanli, President of the European Commission for the Efficiency of Justice, Mrs. Elza Pilichovsky, Director of Public Governance OECD, who will join us online, Mr. Georg Stava, former judge, consular for Southeast Europe, Federal Ministry of Justice, Austrian Embassy, and Mr. Rolands Lapoķis, more technology advisor to the President of Latvia. And so the discussion will be about innovation and strategical management for responsive justice sector in 2022, leaders' perspective. So please, Mr. Vainovskis, the floor is yours. Is the mic already okay? Yes, it is working. Yes, thank you very much.
Latvia, Minister of Justice of Ukraine, Minister of Justice of Croatia, ladies and gentlemen, all the dignitaries, but first and foremost, friends of the justice system, friends of innovation, friends of the progress. So it's my real distinct honor and pleasure to be leading this discussion today among such esteemed ideal leaders, visionaries of the system, and I think it is extremely important and worthwhile because, I'm practitioner over 20 years and working in Foreign Investors Council together with a lot of you. And I know that each one of you, apart from your daily duties, you invest a lot of time thinking about growth, thinking about making our justice system more efficient and making it simply a better place. So, and I'm so also pleased just to give a little bit of intro for our session. I like the word in the panel discussion title, responsive system. And the question comes, responsive to whom, right? So again, in my practice, so who are the clients of the justice system? I mean, it's the people, right? So it's the persons, it's the legal entities. Several legal entities are like qualified users of the system, like they know what they, the big companies. But then what about small and medium enterprises, their access to justice, their experience, their daily experience with the system? Of course, there are also some clients of the system, especially from the criminal law, who are not so willing to be, served by the system, but they also need to be dealt with. So therefore, when we speak about court efficiency and efficiency of the system, first and foremost, I would say keeping the focus on the users, the user experience, the people, the businesses. I would say that seems to be the core of it. And then, of course, we live in this, digital era, right? So, a younger persons in my own organization, they say basically, Maris, it's we are already digitalized. It is already like the fourth industrial revolution is already ongoing. So therefore, I would also like to hear your reflections on that. Are we already fully digitalized in our system? Your vision, and what is also very important when we think about development, one is, of course, leadership, the ideas, the vision, which will be represented here. But at the same time, I think the system usually faces certain barriers, right? There are certain things to be crossed, things related to attitude, to perception, maybe fears of innovation, because any innovation is in a way a disruptor of something current, right? So there is certain pushback, there are certain barriers to be crossed. And in order to cross a barrier, you maybe need to install an incentive, and how to do that correctly. So therefore, without further ado from my side, just setting the tone a little bit, I would like to give the word to our Chief Justice, Mr. Igor Strupiš. I know, Mr. Strupiš, that you are, you have diverse background. You basically come from academia, right? So working as a tutor to students. At the same time, you have also been an expert, right? So basically working with the businesses. And now you are the Chief Justice, the person which sets the tone, or let's say is the tone for the judges. It's very important, very worthwhile to hear of your, let's say, reflections on today's topic. And Mr. Igor Strupiš will deliver his remarks in Latvian language, a language which is so important for us, so important for our legal system, our treasure language. Thank you, Mr. Strupiš. Please, your reflections.
Good morning, dear guests and dear colleagues. Right now, in 5 minutes, I have to reflect and include all my vision. You see, when we speak about the court system and the justice system, first of all, we have to understand two basic things. The first one is that generally the court is the last instance of justice where the society and the public can look for protection, also against the free choice and free activities of the rest of the institutions. It is also the main mechanism against the corruption in the country. And so if the court doesn't fulfill their functions, these two aspects are endangered, and also existence of the state is endangered. And this can be very well seen with example of Russia, where nobody is able to stop the totalitarian leader. And the result is as we see it. And the history keeps repeating. This is nothing new, what we see right now. Therefore, the court has to be totally and absolutely independent from the rest of the institutions. But the court cannot be independent from the society in the widest sense. It cannot be independent in making the judgment. But at first, we have to understand that the responsibility, the court is responsible in front of the public to ensure justice. And the second aspect we need to understand is that the court cannot be involved in the political discussion, except for the court policy questions and issues according to the legislation. So it means that judges, as you already know, they have some human rights limitations to the freedom of speech. And not all the judges, basically, they cannot express their opinions about political issues and questions, especially in the areas which might come to the court. For example, judging and bringing justice for the war criminals, and also other policy and political aspects. Talking about the court system and justice system, how it works in Latvia, I must say that it is in a good condition, and also the attitude of the public, research and surveys show that this situation is keeping and improving all the time. In the last few years, the Justice Council has defined their priorities as to the effectiveness of courts, and also making the courts closer to the public, and also making them more understandable for the public, also training for judges, and also selection for judges. We have a totally new selection order and criteria, and the first results are very, very promising. So the selection of judges is the one which actually forms our justice system for next 20 and 30 years. And all that we can also see reflected in the public attitude, because during the last years, the trust of the public and also support for courts has increased by 10%. And also we have seen that the evaluation and assessment of the public in relation to the court independence has increased. The public considers that courts are more independent now than sometime before. So those are very good indicators, and we believe and hope that we will keep growing and improving. The absolute numbers are not so excellent. We see that this trust increased from 38 to 47%. But considering this chronic distrust in all the institutions, which are characteristic in all post-socialist countries, this is a big gem. And in comparison with other public administration institutions, this is 2 or 2.5 times higher. So I believe that courts in Latvia are on the right path. As to which direction the court should develop, it's, like I said, attitude towards the public, because today's justice and judges have to understand that a judge today is not a judge 100 years ago, when there was a formal authority, and a judge with his formal authority was able just to take on a robe and put all these accessories, and they were able to make a judgment, and everybody listened to them because they were the state and authority. Today's public is totally different. In today's public, you need to earn the authority. And this is what we are doing in the Justice Council, to earn this authority, to earn this by human attitude towards participants of the case, also by understandable attitude towards participants of the case. We are working to improve the quality of court judgments, because the court judgments in the ideal option, they have to be understandable for everyone, each educated person, not only those who represent the legal sector. So that also improves and promotes understandability. And also professional quality of judges. We have several problems that these competitions for selection of judges end without any result. And that points out to some other problems in the area of legal education, or also partially this is remuneration of judges due to that factor. So in 5 minutes, I was trying to outline all the field, what I see. I will not speak about innovations, but I believe that this issue will be also raised during the discussions later.
I think the key words which is, efficiency and responsibility of the system towards the society through attitude and through clarity. Because if the society will understand what the judge writes in its opinion, then through clarity, hence adoption. So that's extremely important. Now, may I switch to our next esteemed panelist, Mr. Ramin Garagurbanli. And so I think you're an active judge in Kazakhstan, of course, in Azerbaijan, and you are the president of a very esteemed international organization. And maybe you can just, let's say, reflect on your vision based on your experience in the like president for the European Commission for the Efficiency of Justice, bringing together basically experience from so many countries and so many members. And what is your current vision? What is the route for the efficiency of the delivery of justice to the people, to the societies in various countries? What are the trends, developments, and key challenges, maybe?
Thank you very much. Dear ladies and gentlemen, prominent members of the justice community, dear Minister of Justice, first of all, I would like to thank you for active participation of the Latvian delegation and your personal involvement in the celebration of the 20th anniversary of establishment of the CPEJ in Malta. We celebrated it a few weeks ago. At the same time, I would like to thank the organizers for having invited the European Commission for Efficiency of Justice, with acronym CPEJ, to this forum. It's a great honor and pleasure to be here in a country with a rich history and with a strong devotion to the European values in the field of justice. Today, as you know, the contemporary society is changing very rapidly, and this has a subsequent impact on our day-to-day life. Nowadays, even the justice systems across the world faced with unprecedented challenges. And in this perspective, all these systems, of course, should be ready and responsive to these challenges. The organizers very wisely named these challenges as a national and cross-border challenges. And in these unpredictable circumstances, it's obvious that the responsiveness and the readiness of justice systems are very important. I'm representing in this forum this European Commission, which is responsible for increasing the quality and efficiency of justice in 46 member states. It was 47, but because of the violation of the fundamental human rights, democracy, and the rule of law, this is the three cornerstones of the Council of Europe. The Russian Federation was excluded from the membership in the Council of Europe and accordingly in the CPEJ. So we accommodated the professionals of justice from all 46 member states and tried to offer to the member state the more sophisticated methods how to improve the efficiency, but taking into account the right of citizens and legal entities to fair trial. So, as you know, we in the CPEJ, we are collecting the statistical data from all the 46 member states, including the members of the European Union. And by this biennial report on evaluation of judicial systems across the 46 member states, we have the picture of what's going on in the member states. And according to the recent reports, we identified the main trends and challenges in national legal systems. And based on our observation, I would like very shortly to draw your attention to main two directions. The first, this is the COVID-19 pandemic caused significant influences on delivering of justice in member states and on public service of justice in general. The secondly, this is the chaotic implementation of ICT, especially uncontrolled usage of transformative technologies in the justice system, could jeopardize the main principles enshrined in the European Convention. And also it's worth to mention the problems with migration, land claims of different countries like Russia to Ukraine, energy dependence, security, which also have significant impact on the overall economic development, social life, and sustainable development in member states. Very shortly, I would like to mention that the CEPESH was very active even during the pandemic. We established a special block, collected the information from all the member states, and came to conclusion that the countries at the beginning of pandemic were not ready to respond to these challenges. They were not ready to organize the justice properly for the needs of the users. And we established the special declaration on the lessons learned and challenges faced by the judiciaries during and after the COVID. Because the COVID, we call it COVID-19, but it can be the other pandemic in the future, and this is the main principles which should be adhered to in order not to violate the main guarantees. When it comes to the digitalization of the justice, you know that the pandemic-19 also demonstrated the very high need to focus more on the digitalization. And we drafted a special document called guidelines on how to drive change toward the cyber justice. And in this document, we identified that the information technologies tools should be implemented for improving the performance, the efficiency, and the promptness of the justice, but should not undermine the main principles. It's independence of judges and judicial system, its main principles of adversarial procedures, and so on. At the same time, we adopted the other documents, guidelines on using the video, like the ICT tools in the video conferencing in judicial proceedings, because as you know, during the pandemic and aftermath, the needs for the video conferences is increased, but we cannot violate the main guarantees enshrined in Article 6. Also the guidelines on electronic court filing and digitalization of courts. Also we established the European Cyber Justice Network. So like concluding my speech, I would like to say that today this is the era of digitalization of justice, but the judges cannot be replaced by the artificial intelligence. We also was the first organization which established the first European Ethical Charter on the use of artificial intelligence in judicial systems and the environments. And this is the main 5 principles that any application of AI should be under the user control. When we talk about the users, we talk about the citizens and the businesses. Because without the businesses, without the small and medium enterprises, we cannot talk about the future developments of economies across Europe. And so I wish the fruitful discussions. So this is the main ideas which I propose to focus. Thank you.
Thank you very much, Mr. Garagurbanli, for your reflections. I also can I highlight that you emphasize the importance when we talk about the digital development, basically balancing it out with the quality, with the independence. So that was one of the key matters, and you also highlighted the importance of the looking at the client of the system, basically also especially those smaller and medium enterprises. So the client-focused legal and justice system. Thank you very much. Now, may I switch to our next esteemed panelist, Elza Pilichovsky, the Director for Public Governance, OECD, obviously esteemed public governance expert, and you have worked on so many international projects on the implementation, on the costs of governance, on the human resources. Would you please share your reflections on the key challenges in the justice sector right now and in the coming 5-year period? But I also wanted, using this opportunity, to thank OECD for the support of reforms and developments in Latvian justice system. I know that OECD supported the development of the idea of economical courts in Latvia, which is now, after 1 year of operation, there are basically thumbs up from the businesses. So thank you so much. The system works, and the efficiency is also one of the key matters that businesses take into account when they take investment decisions in which country to invest. Ms. Pilichovska, your reflection, please.
Thank you very much, Mr. Wajnowski. Can you hear me well?
Yes, we hear you very well.
Great, fantastic, and thank you very much for the feedback on the projects that we've been running together. It's very important to hear it, and I'm very glad. So my sincere thanks to all the justice leaders here and to the Latvian government for the kind invitation. Let me say that this event is just, sorry, I've been sick and no COVID, but let me say that this event shows once again the international leadership of Latvia on justice issues, and which we very much welcome, and which is of great help to everybody. So thank you very much. Let me start by saying that this conversation is particularly timely because just yesterday we launched the survey, the report on the survey on the drivers of trust in public institutions in OECD countries, which shows that just over half, 55.7% of people on average in the 22 OECD countries that are surveyed trust the courts and the legal system today. So the results are quite good for the justice systems. The results are, I would say, for the whole of trust in public institutions, not entirely satisfactory. But there are two conclusions from this survey that I think are important for our conversations today, is that citizens on average across the 22 countries, and there are big differences across countries, are reasonably satisfied with the quality of the services that they have. And what is driving trust down in institutions are issues related to participation, representation, and responsiveness. And I think it has been said already this morning, and I think that I very much take for all of the OECD what this Chief Justice of Latvia said earlier about earning authority or earning trust. And today it's not enough to be just delivering good services, but participation, representation, responsiveness have become core issues of trust. The survey that we have represents the voices of more than 50,000 people across 22 countries, and we will run that survey every 2 years. So while the justice sector fares well compared to other public institutions, the results remain reflective really of the need for governments to better understand the needs and expectations of citizens, interact with citizens, and respond to citizens' needs. Of course, respect for the rule of law and responsive justice systems are really core elements of vibrant democracies, and it is really therefore important that justice systems ensure they are effective in this trust framework, if you want, in the framework of trust between citizens and their government. It is one of the core issues. So what does this mean in practical terms? So it means first today, advancing the digital transformation of justice systems. During the pandemic, a number of countries took steps to simplify selective justice and legal procedures with an extended use of digital tools in communication, court filing, and case management. These measures also help improve the responsiveness to users by replacing lengthy proceedings and complex processes with digital, rapid, and easy-to-use methods. Second, it also means designing evidence-based justice responses to deliver justice services where and when they are needed. Surveys are really an important tool to identify the legal and justice needs of people, including the most vulnerable groups, and also develop appropriate responses such as triage, referral, and prevention mechanisms. It also means empowering people to uphold their rights. And I think, again, this is one of the core things that we can draw from the trust survey for the justice systems. So for example, community-based justice services use a combination of tools to help people address their legal problems, including legal literacy programs, legal information, and targeted advice. And finally, it means also developing appropriate governance enablers for people-centered justice. This involves establishing a whole of state and whole of society engagement and coordination, fostering, access to technology and data, driving justice system simplification, empowering justice personnel, and maintaining people-centered innovation and accountability. So we will continue at the OECD to work on these elements. We have the OECD framework and good practice principles for people-centered justice that provides countries with a series of critical elements for a government-wide strategy for people-centered justice. We are working presently on a legal instrument, a recommendation of the Council, in the same sense. That should be, we hope, ready before the end of the year. And of course, the OECD Justice Roundtable provides a forum for policy dialogue on people-centered justice agenda. We are once again grateful to the government of Latvia for hosting the next edition of the roundtable in Riga in September. Thank you again for your leadership. And let me say that the setting that you have today makes me think really that I am in the room. So it's a very, very nice digital setting. Thank you very much.
Thank you so much for your reflections. And what was also very appealing that you highlighted the importance of the when you implement the digital solutions, when you implement the systems, like strive for the clarity of the users of the systems for much, much better adoption. I mean, this dialogue at the implementation is so important, because IT specialists can of course, develop a software tool, but the specification for this IT system should be developed hand in hand with the direct users of the systems, the judges, the court personnel, and other, of course, stakeholders involved in the system. Thank you so much. All right, so we are proceeding very well, and may I turn to Georg Stava. You are also former justice, right, and employed extensively with the Ministry of Justice in Austria. And so you have also worked on and work on projects related to development of systems. And may I also just make a small note that when we talk about the Latvian collection of judgments, of court rulings, also pre-war system of Austrian, you have this evidence bureau, right, in the Austrian system, who collects the jurisprudence, systemizes for better work, right, for the judges, for the jurisprudence to be more stable, deliver justice more clearly to the people. And that was the Austrian example, was basically at the core also of the development of what is currently in the Supreme Court, a very strong basically department of jurisprudence and research. So that's basically a little bit reflection on the Austrian leadership. But that was already like pre-war and maybe 15 years ago. But what is your current vision on development? Again, maybe key challenges and opportunities here. Mr. Stava, please.
Yeah, thanks. Thanks a lot for the nice reference as an intro. This evidence bureau is something like an analog judicial Google in times where Google was not even invented, and is providing the on-point information if you're interested in any kind of judicial on judgments and finding those judgments which are worth it. Yes, indeed. It reminds us also, I will come back to what our colleague from OECD touched before, that solutions should be user-centered, as you say, or on reflecting the needs of the court users. Why is this? I may start with reflecting a phrase the Excellency Minister of Justice of Latvia yesterday in his speech at the dinner gave when he started his speech citing that the future of justice is uncertain. And with all the respect, I may disagree firsthand in the way that the future of justice, I think, is too certain, and therefore it is uncertain. Because we take all that kind of framework for granted simply because we put it in our constitution and simply we selected distinguished colleagues who apply the law. But if you look closer, we learn, unfortunately nowadays, that a lot of things we thought are granted maybe not. And it doesn't need much to switch those kind of things we took for granted. And this is a reminder if you think about justice and the justice development, because justice is a little bit, and as you talked about the church and the church law, I mean, it's very close. We have something in common with the church and the religion, because rule of law also just works because people believe in it. If people would stop believing in the force of rule of law, everybody would start to get the bigger TV set from the neighbor and will discover that no one can stop this if everybody is doing. So we, as the church, we live a little bit from this kind of belief of society and trust of society into the system which is granted then, of course, in the legal framework. And this I think we should not forget. Whatever we do every day, working in the courts, delivering decisions, solving the problems of people in our societies is to prove this kind of trust. Making the society believe that we are the ones who decide about disputes, we are the ones providing social peace and not the man with the longest gun, who is maybe stronger, but definitely wrong. And when you raise the question how to develop the system and where the story is going, and this is, I think, hopefully we discuss later, Dennis, of course, any kind of development has to serve that kind of society at the end to serve the needs and gain the trust to ensure the peace in our wonderful European societies. Meaning, when we deliver something, when we develop something, it is to step out of our box. We still think that applying solutions which were invented between 150 and 200 years ago is still serving the purpose of solving disputes, and I may become here a little bit provocative and say, no, it is not. If you look on the fact that we still apply the procedural law of the late 19th century, which is genius work of the lawmakers from late 19th century, they today, if they would sit here on the stage, would burn their own books, would grab the mobile phone and would think of something which is real digital, which connects also to the other topic we're discussing here, digitalization. If I hear digitalization and look then into our systems, and I can tell you that 90% of what is sold as digitalization is nothing else than changing that horse we used to write to the court via a scanned PDF, yeah, and then send it by a secure email. I mean, what? This is not improving, this is improving the timeline a little bit, but making then quick court decisions of 4 to 6 months, we are proud to deliver then a solution of a problem which, in a society who thinks I'm impolite if I'm not answering your email within 24 hours. Yeah, even this shows that there is a little bit of a mismatch. And I say a little bit provocative that judicial systems are close to failing realizing this kind of new need, and that means others will do it instead of us. If you look on real digital solutions, which is how to name it, to book and to pay and order a book at Amazon or to buy an airline ticket, imagine we would apply our procedure to buy an airline ticket, and it would take 6 months on discussions with the sales agents if you're allowed, and then you get a written decision that at the end you have a ticket to fly to Paris. We would fail immediately as a company. And still we have no real digital solution on which is providing dispute resolution on a digital mean within, let's say, a mobile phone and 2, 3 or 4 days with low fees. And when I say others take over, then I mean that fine that big digital companies, citing eBay, who is also sorting out disputes between their customers, is solving 60 million cases a year. This is approximately the size or bigger the size of the German judiciary. If you put eBay as a judicial system, as a dispute resolution system on the map of Europe, it's likely the biggest judiciary in Europe. Fine, and I hope that the Californian law, which is likely to be applied, is providing same guarantees like our European framework. But I would love that European systems are providing digital solutions which I can address the court in Strasbourg at the end if it is not to my guarantees of law. And this is the things we are missing. We are opening a gap, a vacuum, where someone else is doing our job, and what is left is then the complex cases. There are, of course, long and costly cases, which you invest time to do it, but I think that we miss more and more the user who is not going to the court for, hopefully not for 500 euros, not likely coming for 2,000, but maybe from 5,000 upwards. But the reality of life of the ordinary people is below of this story. Or last example, and then wrapping it up, anybody offering a solution for this kind of flight cancellation fees you get from European law between 250 and I think 700 euros, no state system is offering support, because you say then, yes, you can come to the court to get a payment order, but who is doing this for 500 euros? It's wrong. It's the wrong instrument. It is private organizations again, private lawyers, private platforms who are providing a fee and a solution. But I would like the state offering this to ensure the rule of law is granted by the public. And I would like to encourage us to step out of our comfort zone and to think in a new way about judicial services, about judicial systems. To gain this kind of public trust, we definitely need to grant the peace in our civil societies.
Thank you much for these very useful reflections, Mr. Stava, and you also emphasize that this challenge that development and let's say in terms of the systems, in terms of digitalization, in terms of the artificial intelligence, it does not come like naturally to the justice system. There needs to be definite like focused involvement, right? Clear thinking, adoption with the end in mind, improvement of the service, simply not digitalization for the sake of it, but for making it more efficient, but also including, I would say, would you agree that it's also not just the system, it's also a wider thing, a more, quicker system is more a resilient system. It's also actually more environment friendly, probably, right? So not printing out everything in paper and all of that. Do you see also certain, these add-on effects of digitalization for the general environmental thinking, for instance?
I don't agree that digitalization as such is always this keyword and solution. Yeah, fine, at the end it might be a nice tool, but I would like everyone who is starting with the word digitalization to put the digitalization aside and first think of improving the service and the procedure. Improve the procedure first, maybe afterwards make it digital, but think about analog solutions which are much more effective maybe. I saw solutions which are definitely having an effect without any kind of digitalization. The Croatian colleagues did time frameworks, making them public, telling the people simply how long it will take to solve the case. On this court, they did it in Karlovac. The Ukrainian colleagues are doing vetting in public of having public hearings, showing what is happening with the colleagues who are then applying the law. And in Serbia, they simply mark the files with a big red plastic tape if it is pending longer than 12 months. It is screaming at you if you enter the office. It doesn't need digitalization. It does not need 10 millions. And I'm a little bit also sometimes, and sorry for the donors if they are here, I like the donors and their engagement in all the reform ideas we have in Europe, but sometimes coming in first with 10 millions and saying we have to implement 10 millions and digitalization is a good idea is maybe the wrong end of the story. So I'm more advocating that let's focus on what really we should deliver. Let's improve our, so to say, product and rethink why are we here. And yes, if digitalization is fine, okay. Environment is not our task. Yeah? I'm also advocating that let's focus on our core stories. Core story is solving dispute resolution. This is our main product, deciding and deciding quickly. And if maybe fair deciding and if correct deciding, even better.
Yes.
And let's keep all the frills around.
Okay, clear. So digitalization where it should be, but nothing will really replace the need sometimes for the real person in a real courtroom, a real witness looking into his eyes. So we don't replace everything with screens. We do it where that is needed.
Or we do it digital way. It is a 10 minutes experts meeting. If the judge is meeting 2 lawyers and an expert, please do it digital. Yeah, nothing.
Yes, no need to travel for that.
It needs the stage to show also.
Clear. Thank you. So, and definitely, not least, Mr. Lapute, you are a smart technology advisor to the President of Latvia. I know you have vast experience in the diplomatic sphere. You have very technical education, very exact education. Right, so at the same time you love music. So right, so all of that experience combined, you definitely have, let's say, you have wider experience across the sectors. Now, would be very interested in your perspective, like what is your message based on all your experience to the development of the systems in the justice sector? But what are your, let's say, observations? And I would exactly want to hear your observations, which are, let's say, the key barriers and how to try to tackle them and like get over them in terms of reasonable advancement, which makes sense.
Well, thank you for inviting me here. I'm probably one of the very rare non-lawyers here. And if you're mentioning music, I will start to think maybe I should be singing more than talking here, because I'm not sure I am the most competent person. But of course, I heard already a lot, and I'll start maybe with one word. If we're talking about the obstacle, all strategies are very good when they are overall, but they are always a first problem when they are confronted to one factor, and that's human being. And that it gets complicated at this stage. You were talking about uncertainties. Uncertainties is certainly one of the most destabilizing aspects of a human being. And I was hearing lately some debates from, I think it was by a philosopher, what is intelligence? And one definition they agreed upon was it's the capacity to deal with uncertainties. So here we are talking about how intelligent are we to solve all these uncertainties we are confronted to. I have noticed that when I was ambassador, representative of Latvia at the Council of Europe, I read a book, La Déconnexion des élites, the disconnection of the elites. It was about a journalist had tried to make a study on exactly internet, the influence of it, and she was searching for people interested in participating in such a study. Well, there was one researcher, Marcel Gauchet, and there was one maybe politicians, but most of the people were avoiding it. They were not interested. Well, that's 7 years ago approximately. And so one first aspect we have, it's that the incapacity of a lot of politicians, because look at us, I am certainly too old to make decisions about technologies, modern technologies, is that the lack of capacity of judging, of understanding what is at stake. It would be also one political aspect. What can change that? Well, we'll see. It was mentioned already. Some crises. So the pandemic was really helping in Latvia at solving things. I am more dealing also with the digitalization in the justice system, but also mainly in the biomedicine. And now doctors can have consultations at a distance, and it is not always bad. It is certainly good. So one of the first obstacles was psychological. It turned out in Latvia that the legislation was adaptive enough not to be an obstacle to go over or to overcome this aspect. Secondly, I would praise our president, who, at the very beginning of the crisis, invited the 5 constitutional institutions of Latvia in order to put or to establish a frame of functioning of the state, so that even the parliament is able to work at a distance and things like that. To me, it was very important strategically and also psychologically. All institutions were then able to work in spite of of uncertainties, I would say. Another thing is what the elite is not informed enough, and then this is what I recognize. I was a bit smiling when I was, our colleagues from other ministries had got money from the European Union to install 4G. And I was thinking, well, why do we need 4G everywhere? Not everybody is using. Well, it turned out that when the crisis came, all schools in Latvia were able to receive enough information. So we are talking here a juridical infrastructure, a technical infrastructure that was in place. The third aspect, which is not in place, and that has been mentioned, it's, I think you said, the comfort zone. Comfort zone of justice persons is the same as medical doctors. Well, I am very competent. Why should I change? I mean, I know what I'm doing. Let me, leave me at peace. And you know, I am overloaded anyway. I can't work more than what I'm doing. So I don't want to go digital. And it's like you have read about the 19th century when the train was invented. Everybody was afraid of this monster that is totally inhuman. Well, now we can say the same since the big revolution of 2007. And that means the iPad, the iPhone, where it's not only a mobile phone, well, everybody, we're all using it anyway, so it is, we are there. One aspect there I would like to stress is also some psychological issue linked with the administration. And there I would like to mention one book that I saw at the Charles de Gaulle Airport in Paris in 2019. I saw it because of 2 reasons. The title was The Collective Intelligence, and the author John Stone, and I knew very well his father because it was Yuri Stone, a very intelligent Latvian refugee in Paris who was too intelligent to be very fruitful in his active professional life, but intellectually he was almost a genius. And this book was one of the aspects I will mention only is that he described the activity of one of the biggest Moroccan companies. And so I know a bit Morocco because I was a non-residing ambassador from Paris to Morocco. And the biggest exporter, well, Morocco is the biggest producer of phosphate. So they have a big company with, in those days, 7,000 people. And they established, in the years 2000, it was losing billions a year, which is totally stupid. It's the biggest exporter. 70% of the phosphate in the world are in Morocco. So why should it lose money? Well, because there was a wrong administration. Morocco, the king of Morocco is also the commander of the believers, so it's different mentality. So there is still even sometimes feudalism in some attitudes, but mainly there is the modern type of administrative work with the CEO, and it's so the whole hierarchy is under it, and it goes up. The decisions are made, and they actually were not progressing, and they invited somebody to be the new CEO, and he introduced something that when I read the Riga Justice Agenda, I find it there. And it's linked with collective intelligence. They ask people to find common themes to work on, and independently from the hierarchy. So if you are at the bottom of the hierarchy and you have a good idea, you find your like-minded people within the other layers of the hierarchy or outside of the system, and you bring this idea to implementation. It goes so far that some of it became then a department. Well, it changed the whole thing. And one of the main results, I remember that they went to France to study this free university, free in the sense that you have Orange, the telecommunication operator, free university. They went in January, and in August, they opened a university along the lines of the free university, and where people from all over Morocco, young people, were actually going into IT in a very modern way, men and women. When you know Morocco, you see that it is a huge progress. So this is what I would say. You were talking about adapting. I mean, technology, yes, is not needed everywhere. You have to see where the human being is more important than technology, because as a neuroscientist, I'm convinced that there is the cortex where we think, the common sense. I prefer the Latvian is sound sense. I prefer it, the common sense. What is common, I'm not too sure, but in French, bon sens, it's better than in English, but it is very far from the emotional brain, which is the limbic system, and an intelligent people with 3 PhDs will never overcome a crisis of jealousy. There he becomes this beast. So let's be humble, let's see that we are human beings, and let's work together. So this, from the agenda, this is one aspect, I think, change the administration, change part of the mentality.
So thank you very much. What I get from this in summary is that basically, like, don't be afraid of the diversity of platforms, don't be afraid of diversity of ideas. This all combined gives basically a road to collective intelligence. Like, also, don't put yourself in a box.
I'm not exactly saying that, because the people who have this character, they're doing that anyway. Right. I would more say, if you are afraid of it, well, don't try to interfere too much. Don't block it. Let it go. Trust that those people maybe will achieve something.
Yes. Yeah, just some final thoughts, because we are short on time, but just a very few reflections maybe.
I just want to reflect briefly on this being afraid and who should step out of the box story. Don't forget, and as a former judge I am allowed to say that judges and prosecutors, so the main pillars of the usual judicial systems, are selected to be conservative people. They are selected to apply the law. They are not a creative director who should find a new solution every day and have every day a different opinion. No. So don't be surprised that we are conservative people. So the bodies of judiciary traditionally are conservative. So do not stop to nudge us and to move us out of that box. We are not afraid of new things. It is just that we are usually following the rules which are already to be applied for good reason. But it needs this external impetus from the outside to show up new solutions, and then let's get the judges on the move.
Exactly. Yes, of course.
And it was very interesting approaches from all the speakers. Just very shortly, I would like to say that in the whole world, in all parts of our society, the digitalization is priority. The justice cannot be a part, because the justice stimulate all the public relations. And in terms of the exchange of information, for example, this is very crucial to have the digital tools in place in court systems, in justice systems. And my colleague mentioned about the confidence in justice. This is also very crucial. And this confidence only can be achieved if we pay more attention to the expectation of the users. Sometimes, for example, from OECD, when they run the meetings, they always pay attention to the people-centered justice. Now we a little bit move to the user-centered justice, because when we talk about the users, we talk about not only these people, but also about the businesses. So, and the main expectations when we drafted our documents in the CEPEJ, we focus on the 5 directions. This is the accessibility of justice, this is the promptness of justice, this is the efficiency of justice, cyber justice, and predictability. Predictable, the justice should be predictable. The application of law should be predictable. This is the most important. Thank you.
Thank you very much, Mr. Gurbanli. I think, this is very, very, worthwhile summary. And also, I think it paves the road to settle incentives, because through what you mentioned, I think this is the way to cross these barriers and actually to move forward. And thank you so much for your reflections, and thank you so much for the perspective and the help from Azerbaijan, the colleagues. We very much appreciate it, and thank you so much, dear participants, Ms. Pilichovska, Mr. Garagurbanli, Mr. Stava, our head justice, Mr. Strupish. And of course, Mr. Lapute. I think, summarizing up, I would say just a couple of things. I think it was a common theme that the output of the efficient justice and innovation shall be directed to whom? To society, to the users. I think that was a common topic, and one, I would say, a leading topic. Digitalization and technology development is there. We cannot take it for granted, but we will not it is here. We are now talking about how to implement it in a way that it actually helps, that the people understand it, that the judges understand it, and that it actually facilitates the efficiency of justice. But now a little bit but what we need in order to achieve that, we need people, right? We need talent. We need people like you in this room who will actually go back to your offices and think how to improve the system. And I know that altogether we have invested hundreds of thousands of hours of, I would say, out of scope, pro bono, or let's say work to the development. And I am very sure about the visionaries, the ideal leaders here in the panel and in the room, that together, by ourselves and by attracting talent, and I would say that's a challenge for the next panel discussion, how to attract talent, how to get them involved, how to deliver on the joint efficiency of the system. So thank you so much, and I would say it was very worthwhile discussion, and we look forward to the continuation of the forum.
Thank you. Paldies jums. Liels paldies runātājiem.
Thank you very much to the speakers. Thank you to the previous speakers, and now I will invite the next panel, and this is going to be directed by Jānis Pleps, Legal Policy Advisor to the President of Latvia, and his colleagues today, Ivan Malenica, Minister of Justice, Croatia, Maija Āboliņa, Member of Board, State Control, Johan Galea, Permanent Secretary Justice, Malta, Laila Mediņa, Advocate General of the Court of Justice, and Pēteris Zilgalvis, Judge at the General Court of the European Union. Mr. Pleps. Thank you, Mr. Reiders.
And lawyers should obey the rules. Excellencies, ladies and gentlemen, it's indeed my big pleasure today be with you here and moderate this very competent and very influential panel in these discussions. And thanks a lot for my dear friend Māris Vainovskis and his panel, who put for us these big challenges. We are living indeed in uncertain times, and I would like to say the 21st century will be, it seems it will be at least so the same challengeful and provocative as it was last century, 20th century. And it seems that there will be a lot of room for lawyers to do, and lawyers are in the center of this legal system, of course. We are the main actors in legal systems. and also our responsibilities for society. And I would like to say that we today are working in the right place for this Riga Justice Conference here, in this house, in this building, and this hall. Because here was a very important historical event. In 1921, here indeed was signed a peace treaty between Poland, Soviet Russia, and Soviet Ukraine. It was deal about the Ukraine with aim, target to get peace and in our region. And we remember how it finished in 1939 with the big war, and so compromises with potential aggressors and potential figures who don't respect the rule of law never ends very well. So we should stay on these principles of rule of law, and I really enjoy this remark that it's something like religion, that we should believe in rule of law, and rule of law will work and will be effective. And speaking about the leadership, I would like today remind to you one professor, Professor Vasily Sinaiskis. He was born in Russian Empire. He became influential civil law professor in Russia. He was professor in Kiev University, Ukraine, in the beginning of 20th century. And he escaped from Soviet rule illegally, from Soviet Union to Latvia. And he built one more time here in Latvia his academical career, his life, his authority. He became one of the most spiritual teachers of new generation of Latvian lawyers. His favorite student was Professor Konstantin Čakste, leader of our national resistance movement, who in the right time stays and said that we should fight for independent Latvia, we should fight for democratic order, we should fight for the rule of law. Professor Čakste died in Nazi concentration camp for his ideals. Professor Sinaiski escaped one more time from Soviet aggression, occupation to Belgium, and he died in exile. But he, with his skills and authority of leadership and responsibility of lawyers, lives in our memories and our textbooks of law studies. And today I thought that it's the right point to put this Sinaiski's perspective, which are bringing us all together in our belief of strong rule of law, strong court independence, which is necessary for Europe and for our states. And I invite our colleagues, which are here present, to discuss the necessary skills, competencies for lawyers as leaders of legal system, as leaders of society, those one who spoke when it is necessary. When others maybe stay silent, but lawyers should speak about the rule of law, about the principles and our values. And so I invite as a first speaker here, Minister of Justice of Croatia, Mr. Ivan Malenica. And Minister of Justice put as his goal for the cadence in the office to put public administration, judiciary system to service for society. And also he is running very well for digitalization of the systems. So I'm sure that you will give us perspective how it looks new times and what competencies is necessary for new time leaders in legal system. Please, floor is yours.
Thank you. Thank you, Yanis, for the invitation for this event. I think it's really important today that we talk about some new ideas in judiciary system and that we share good practice because we need it. We need to change and we need to prepare a judiciary system for the fourth industrial revolution. When we talk about Croatia, I could for the start say that we have around 4 million people and around 1 million cases on our court every year. And that is a really big challenge, how to deal with all these cases and a lot of active cases on our courts. We have around 1,500 judges on our courts. So of course, there's for us is really important our national development strategy and strategy for the judiciary system for the next 10 years, because we are preparing a lot of good things, and we are changing our judicial system, how to respond not only for this situation like it was COVID-19, but also for the future situation. And of course, it's very hard to change a mindset of our judges and our administratives on our courts. But of course, COVID-19 pandemic speed up a digitalization process in our courts, in our judicial system, and I think it's now easy to continue with the digitalization process in Croatian judicial system. And of course, we use our recovery and resilience plan. There's around 1 billion of, it's 150 million of euros investment in judiciary system in Croatia, and I think we have done a lot of good things and prepared a lot of good projects and reforms regarding judicial system. And of course, we know what is important for judicial system, what it is important for the citizens, that we have efficiency, we have accessibility in our judicial system. So we plan reform regarding these important issues. When we talk about leaders, and one of the important issues of this summit is how to become and how to be a good leader in a justice sector. I think that new generation of leaders in the judiciary will be only those whose priority will be to build solid and independent national judicial system, primarily by strengthening judicial institution, functioning of the judiciary exclusively based on the human rights and fundamental freedoms, rule of law, equal availability of judicial system and judicial institution for all citizens. Of course, you need to follow and independence of the judiciary and institution from any external pressure. So these are key challenges also for Croatia, and we are preparing changes of a lot of legislation and a lot of acts. So I will mention Court Act, Administrative Procedure Act, then Criminal Procedure and Civil Procedure Act. I said that we have 13 reforms of 70 reforms of Croatia that has in a national recovery and resilience plan, because the main challenge is how to make the judicial system more efficiency and more accessibility. So we are trying to make some changes. You know, you have mindset of the judicial authorities and judges and administratives from the courts that they don't want changes. So of course we need to use the COVID-19 pandemic to speed up digitalization process. We need to use national recovery and resilience plan to additional digitalization of processes in Croatian judiciary system. So there are a lot of challenges, and of course we think that judicial system can need to be one of the more important pillars of the society. Because you need to have people who are satisfied with your judicial system, and we are doing a lot of things in that way.
Thanks a lot for your remarks, and I see that there is a lot of things to be done and which is done still. And I would like to make a short remark for my side that I also very high evaluate Croatian legal academia. You have very deep traditions in these Kelsian legal theory roots, and for example, the best concept that law is artifact is elaborated in Zagreb University, Faculty of Law, even there. So it seems that it's possible to participate in worldwide development of legal systems also from our national universities. And now I would like to continue with person who is, I think, very well known in Latvia. Maija Aboliņa, member of board of State Audit Office, but I would like to say that Maija is also a very active civil society participant. So she acted for the better education for our children. It was her initiative, and she participated a lot in different projects to provide better education in our secondary schools, to provide better potential future for our children. Thanks, Maija, and for this job, and I think that you will share your experiences and feelings concerning the necessary skills for new generation of lawyers. Please.
Okay, thank you, Jānis. Yeah, indeed, I raise my own children, and sometimes I also teach law students here in Latvia, and I also sometimes hire people who have made their decision to work for the public sector, and I'm always very glad about their choice and readiness to contribute to the common good. So today, I think my contribution to this discussion would be from the perspective of an advocate of newcomers to the public sector, and I purposefully chose the term newcomer to cover both young people as well as experienced professionals who have made this decision to change the private sector for the public sector. And what I see in those people is that the work nowadays is not only a duty and a necessity to earn a living. More and more frequently, people nowadays combine this duty and necessity with their passion and true interests. And I think that this is the greatest benefit to others and the society in general. I mean, this genuine motivation to change the things for the better and to contribute to the common good. Regarding young people, I would like to emphasize their natural and inner resistance today to any hierarchy and social ranking. I mean, no one today can demand respect and authority just because of their position. Position itself does not influence, does not impact. Who does? The personality. Other people see the leaders through the activities, through their competences, through their decisiveness and power intelligence. So the new leaders need to have this inner sense of power and authority because the leader is as powerful as he feels, and it matters most when we come to using the power well. Leading effectively, influencing persuasively so that other people around the leader naturally alter their behavior correspondingly. About young lawyers and young leaders, what is needed to start their way to become a leader? And I would say that the answer is a well-developed understanding and system of values. And lawyers judges actually are privileged between the leaders because these in-depth studies of constitutional and democratic values, legal principles, are already an integral part of their professional qualification. The next point I'd like to mention is that many laws have not been written for today's circumstances. Be it COVID pandemic or the Ukrainian war, challenging the most existential values of today. And therefore, a very critical skill of a lawyer is to read between the lines and always with the values in mind. And the last competence I'd like to mention is the ability to steer any legal procedure or trial effectively and decisively. And that's what we see also from the audits performed by the State Audit Office in the judicial sector, that in this context there is still potential for further improvement. And I'd like to conclude this by quoting a philosopher, Karl Popper, who in 1945, and this year is not a coincidence, formulated the paradox of tolerance, saying that unlimited tolerance leads to the disappearance of tolerance. If we extend unlimited tolerance to those who are intolerant, if we do not defend our open and tolerant society against those who are intolerant, then the tolerance will be destroyed. And what we should do, we should claim whenever there is any movement preaching intolerance, that first of all, this movement itself places it outside the law. Thank you.
Thank you, Maya, for your pointed out these main competencies or skills necessary for young leaders for the legal system development. And indeed, we have one privilege that we have also in our panel as a catch person with a teacher's background. Big experience in the secondary schools, and I think he will know from his own experience about what we need to discuss and think about about these issues, and also big experience and different positions in civil service. So, Permanent Secretary of Justice of Malta, Mr. Johan Galea. Please, floor is yours.
Thank you, Yanis. Thank you, Yanis. Thank you, Minister for Justice, for the invitation. And this is exactly the right forum, the right initiative that I think that we should be doing. When COVID pandemic hit back in March 19, I think it hit a panic button that showed how fragile our systems can be, and the fragility that is inherent and also that comes along with the justice sector was very much highlighted. I remember that one of the first things that happened, because Malta is an island, we are a small island, not a large population, we are at the lowest part of the European Union, one can say, and we have sort of the mentality that sometimes problems can pass us by without being actually touched by them. So COVID-19 was a panic button, it hit us, and when we started doing legal changes to adapt, it highlighted exactly the challenges, the three challenges that I believe are very much in tune at this point in time. I believe it's the digitization of our systems, but not digitization for digitization's word. It's the flexibility, because we need to be flexible. And I believe that it is not just the legal system that needs to be flexible. It is not just the administrative areas, but a whole round approach. We are not living in one silo. And also, not to lose sight of what we are doing. The challenge is that we lose sight of what we are doing, the relevance, and for whom we are doing all this. I remember with lockdown coming up, when it was set, all the heads, all the leaders of the different stakeholders in the Maltese justice system gathered in my office, and that was the signal of how we should work. That while the system is fragile, that is the way forward of how one should work. In my opinion, at this point in time, leadership in the last 5 years has undergone a strong and huge evolution. This is also very much felt in the justice sector. I believe gone are the times of those kind of leaders who are sitting on a podium, are literally being just a role model. The time of what we used to consider to be a strong leader is no longer the case. Today I believe that to be a good leader, the evolution of having a good leadership is the one where you create networks, where you create the chance, the opportunities, the day-to-day possibilities of the different stakeholders, from the lowest to the highest, to be actually able to work together, to have that access. If that is not present, then we can have the best IT systems, we can have the best. In reality, we are not algorithms. Leadership should not be made up of code. We can have the best code, we can have the best chatbots, we can have the best AI systems, but in reality, we are still made up of people. People who need to communicate, people who need to talk to each other. But to do that, we need to create that possibility. So you need to have the right fora, the right legislative structures, the right processes. And when you actually start to change, when you actually start to do something which will result in change, you need to have everyone on board. The top-down system that sometimes used to work does not work anymore. Neither does a horizontal system. Because a horizontal system, you will leave some people out, you will have complacency, you will have people trying just to respond, when here it's not that. You need to have a spider's web, in my opinion, which we all know how fragile it can be. But at the same time, it can hold the weight, which is much bigger than itself. The justice sector cannot work on its own. You need to have the education sector, the political sector. It's a whole system, it's a whole network. I come from the educational background. I have been working in the justice sector since 2016, permanent secretary of the justice sector. The first thing that hit me was how traditional the justice sector is. And it's breaking down those silos, those barriers. The judge in his robes who is up on the podium, isolated from the rest. Yes, in a practical way, the judge is as good, as much support, as good as the support that he has. If the judge is not given the right support, is not given the right possibilities, if the judge is so confident that alone he can push forward, just pull up the quota necessary to show that he's efficient, then I think we are in the wrong direction. But moving forward, digitization, in Malta we have just, with the help of the SAPEJ, the Council of Europe, we are implementing the first digitization strategy. And it's the bringing together of all stakeholders into that strategy, which is helping us bring on the views of everyone, from civil society to the judiciary to all other stakeholders. We could not wait to have the digitization strategy in order to implement changes. So you have to be flexible. You have to adapt, bring everyone on board. It's around, sometimes, even bringing everyone on board, literally around the same table. And trash problems, sometimes face to face. Video conferencing is good, but we all know, we all went through the Zoom period, which was the obligatory period. But it's this kind of then initiatives like this, because I believe that these forums are ideal, so I congratulate this initiative even more. Why? Because a network of professionals should not be limited to one's own country. The COVID showed how much a global issue it became and how much it hit us globally. The war in Ukraine, it's not on Malta's doorstep. It is on this country's doorstep, but it is on the European Union's doorstep. And the effect is felt even in Malta. So what happens in one part of the world creates a challenge in somewhere else. A network of professionals which is alive and kept alive, and people know each other, and people know and have learned how to work together, is vital, and I believe that is the way a formation of a new leader, of future leaders, is the path, that they are given and taught the tools of how to work together. The time of the Caesars, the way we imagine a leader has to be, is long gone. And I think the justice sector, with its fragility and with its traditional outlook, needs heavily to adapt and also to learn to go out of its silos and to communicate. Because sometimes there is a problem in communication and people understanding what actually rule of law is about. And that brings me to the close of my address.
Thanks for your contribution and valuable remarks. And I saw that some people mark something in the phones or notes. And also I also fixed the word networking as a common competence for those things that we can manage everything together. Learning each from other, working together, moving together to the common goals which we need to get. And from this, I think that the Riga Justice Forum is the right place for sharing experiences. And your remarks on Malta background was perfect and necessary. And I think in the coffee break we will have some detailed discussions on this. So thanks a lot one more time. And if we are moving to next speaker in our panel, that there should be teachers who giving knowledge, and there should be those who evaluate, who putting marks and saying, are you a real lawyer or not? And Laila Medina is a very remarkable figure in Latvian legal system, I would like to say. One of her hats, I would like to say, it's to be a president of state committee who puts evaluation of state lawyers exam. On her depends the questions on exams and also, I think, outcome. So who gets diplomas or who don't who stays for the second year. So Laila Medina, also Advocate General in the European Court of Justice, and we are very all proud that you are there, but also that you are keeping your responsibilities also about our legal system here. Please, Laila.
Thank you, Yanis. First of all, I would like to say thank you for inviting me. It's really nice to come after a while being outside Latvia to come back. So thank you, Minister of Justice, Mr. Bordans, for inviting me to come. And this time being a little bit outside of Latvia has given me a possibility to reflect, because for quite some years I've been deeply involved in justice sector, and I think it was rightly mentioned that you need to sometimes to step out to see what's happening in your own country. But that being said, As already Jānis mentioned, I have kept my ties with Latvia, and when I was invited to chair the committee for state exam for young lawyers, I accepted actually with a great pleasure, because I thought perhaps that I can do something to help the new leaders to come up to Latvia and do something good for our country. But when I was thinking of today's few remarks, I can say the first thought which came to my mind was the leaders of today. We are preparing the soil for the future leaders. So, and that led to me to one very famous, I guess, Latvian saying, ko sēsi, to pļausi, or the quality of seeds determine the quality of yield. So that means that if we want to have good future lawyers, we need to think already today, and not maybe of the law students in university, but of our children starting the school today, or maybe going to kindergarten. But a little bit setting the bit bigger background and connecting the new leaders with democracy, with the rule of law, that's a really powerful idea. Democracy, the rule of law, we all see that that's the only way we can resist the challenges of the terror, the challenges of the abuse of power, and that's the only way how we can protect our freedoms, our fundamental rights. And that has been said, I think, for centuries ago already. That's the only way how we can also, as private persons, feel happy, because that gives us a safe environment, we feel protected, and we can pursue the thoughts or the deeds we want to do, and that makes us that we can feel happy. So for being us as private persons happy, we need someone who leads us, someone who protects the democracy, someone who not only talks about it, but someone who is ready to fight for that, to work hard for that every day. So there's not only rule of law in paper, in law, or somewhere in lovely law books, but it's in our everyday life. Whenever we feel threatened, there is someone who is ready to protect our rights, being it a politician, being it a judge, or policeman in a street enforcing the law. So, and then answering to the question the organizers put to us, how we see what could be those new leaders in justice sector, I came to three thoughts in my mind. And I think that I will come to one point more in details, but there are three thoughts I want to stress as the headlines. The only way how a person can be a leader, a person must have a vision. What I can do as a person to pursue those bigger global goals of democracy, of the rule of law. We can't do everything. We can do one specific matter. In academia, in policies, in judiciary, it doesn't really matter in private sector. But everyone who wants to be a leader must have a vision, what I can do for democracy, what I can do for my own country. The second thing is education and knowledge, and there I will go a bit more in detail as being the chairman of the state exam committee. But the last point from these 3 points which I wanted to make, it's not only the vision and knowledge. A person must have ambition to lead and skills to lead, because one person cannot do a lot. A person needs a team, and for a team to be there, you need to lead. You need to know how to get people along, because one should never neglect a team. Without a team members who want to work together with you, the job cannot be done. And now more specific about the knowledge. So I made 5 points into my notes, which I will touch very briefly. How, in my opinion, what needs to be done so the new leaders which now go to school, so they can grow up and be really leaders of justice. The first thing which comes to my mind, and I think it really reflects to what you were saying, that is the knowledge of languages. Because if we can't speak different languages, it's difficult to communicate. We can only talk with the people here in our own country. We cannot go outside our country and talk to other people. And it's not only the ability to speak and be involved in networks, it's also reading. Because for being a good lawyer, you must read not only the legal thought of your own country, you need to read what is thought in other countries, how they are solving the problems, what they are doing in US, what they are doing in completely other different legal systems, so you can compare and choose the best for you, for your own country. So All the new lawyers who are studying right now study the language as well. English is, in my opinion, absolute minimum. French, German, Spanish, that's something, there are no limits to languages one can learn. The second topic is to think about the fact that law changes. The world changes, so one should never stop reading, learning. So to be able to follow what's happening in the world, one has to never stop reading what's new. The third aspect which I wanted to mention is that it's not only law books we need to read as lawyers, because the law regulates so many different complicated areas. To understand why the law is so, or how to develop law, one needs to read also about economics, about technical matters, wherever our interest leads. So expand your horizon and read more than just a law book. The next aspect, and I think there I really touched to what I saw as an examination member of the examination committee, that today it's impossible to be a specialist just in one law area. The law is overlapping, the different areas are interconnected, and if you know only criminal law, you can't be a good lawyer, because you need to know the theory, you need to know the basic legal principles. There are areas where without knowing both criminal, civil, and administrative law, you cannot come to the right solution. So for that aspect, I think what should be taken from the universities law students study, that those years at the beginning when we study the basic principles of the law, of different legal areas, where we study theory, where we study the interpretation methods, are the most important years of the law study, because then we build the basis, which then can be used whenever we need to work in our special areas of law which we choose. And the final little note which I have written to me, so if I have been talking about that one needs to read, then what to read? I think the first thing is to start to read it first. Any book, whatever, law book maybe can be the second choice. But don't forget that what is written in law books, that's already 2-3 years old. So follow the court judgments, being that national courts, international courts, EU courts, doesn't really matter. Your chosen area of law, read what is brand new, because that shows where the law develops. And my absolute final note, and I promise to finish right now, is to say that we need these core values, being thirst for the knowledge, to work hard, but as lawyers, we also must show the high moral values, strong backbone to fight the principles, and open mind for being flexible. Thank you, Jan. I'm sorry, I think I exceeded my time.
Thank you, Lyle. It was remarkable as always, and I get feelings that just now Lyle put for us new definition of functional usefulness of lawyers. We should practice to make more people happy. So this connection between the happiness and lawyers' work was something new and trendy, and I think we should a bit think about it in coffee break. But before the coffee break, we have last but not the least speaker in our panel. Judge of at the General Court of the European Union, Mr. Pēteris Zilgalvis, and I would like to mention that he have impressive background, study law in the United States, practice the European Union law, and he was also one of the legal policy makers of the European Union law, and now judging cases in the General Court of the European Union. So. Big background for the, I would like to say, for final comments in our panel. So, Judge Zilgalvis, the floor is yours.
Thank you. Thank you very much for this very nice introduction. I thought to raise some of the upcoming digital economy issues and what judges, lawyers, barristers can do to get ready to be able to address them. I'll talk a little bit about central bank digital currency, blockchain and non-fungible tokens, and law in the metaverse. The central bank digital currency is a digital form of central bank money that can be issued to individuals or licensed financial institutions denominated in the national unit of account. It is a direct liability of the central bank. More than 70% of central banks are now experimenting with central bank digital currency. aiming to improve financial inclusion, digital trade, payment efficiency, access to safe central bank money, as well as addressing the dwindling use of cash as people use more and more electronic means of payment. China has started a large-scale pilot of its central bank digital currency. Smaller countries like the Bahamas already have small-stage rollouts. The Federal Reserve in the United States, the European Central Bank, together with the European Commission, and the Swedish Riksbank are exploring introducing a central bank digital currency soon. There are some very important issues coming up for both lawyers and for the courts. A key legal issue is privacy. Who has access, who controls the data, the movement of these tokens of the central bank currency? Will the use be made for money laundering, terrorist financing, surveillance? When I was in the FinTech Forum of the International Monetary Fund, the Deputy Governor of the Bank of China, when advertising that they were starting this rollout of the central bank digital currency, he said they would have controlled anonymity. So this is probably something that is perhaps less in the spirit of Europe and the West. There will be a limitation of holdings of the digital euro, for instance, in order to protect the commercial bank sector, because there's a worry that people might take all their money out of the commercial banks. Then we wouldn't have the commercial bank system to give loans to small and medium enterprises, etc. But how do you do this? How do you sanction people who take more of their money out than allowed? What is proportional? These will be upcoming issues. There will also be technological choices, how decentralized to make systems like this. This will be linked to the legal frameworks that are chosen. Now I'll move on to the changes of the internet. And one thing I'll underline here, that in any great technological advance, there's obviously a lot of hype. People say this will change everything. I'm old enough to have been present at the internet boom and the internet crash, where on one hand, unfortunately, people were saying the internet will end all wars, perhaps less necessary, the internet will end all physical borders. It hasn't, but it has done quite a few interesting things. You also had naysayers who said, well, no one's going to use the internet, that's not interesting. So with these new decentralized solutions, probably the route will be somewhere in the middle. You will not have a complete revolution of everything, but you will have probably some very useful applications. It's sometimes called Web 3. So Web 1 was a decentralized internet, ARPANET and NSFNet, which came interestingly very much from defense funding in the US, and was actually one of the reasons there was a boom in Silicon Valley, this financing of civil applications alongside defense. And in our world of today, when defense is obviously very important, it's useful perhaps to learn from some of these lessons. Now we're in what's sometimes called Web 2. Big tech, the collection of data, commodification of data. And Web 3 proposes a user-based decentralization using blockchain, non-fungible tokens, artificial intelligence, simulated reality. Again, you'll probably have some medium between the hype and with some useful uses coming out of it. The word metaverse, which is being raised more and more, this was already coined in a book in 1992 by Neil Stephenson, Snow Crash. He said he's in a computer-generated universe that his computer is drawing onto his goggles and pumping into his earphones. In the lingo, this imaginary place is called the metaverse. Web 3 legal issues, there's actually quite a bit that's coming out of European law already to address these new technologies. On crypto assets, stablecoins, cryptocurrencies, they're addressed in the new regulation on a market in crypto assets, MiCA. Smart contracts, which is the way that you run a lot of these applications, will be addressed by the Data Act, which is a proposal for regulation on harmonized rules on fair access to and use for data. Self-sovereign identity will be addressed by the new Digital Identity Regulation. and an opportunity for startups to be able to compete against the so-called gatekeepers, the dominant players of Web 2, is foreseen in the Digital Markets Act and the Digital Services Act. Digital Markets Act and Digital Services Act will probably produce a lot for national and European courts eventually. A few questions that are raised by law in the metaverse, which is this virtual reality, making use of technologies that are being developed right now, for instance, for medical uses, whole brain simulation, but then making copies also for commercial or fun uses. The metaverse is foreseen to be a way for teams to work together, networking, not that we want to go back to the old complete Zoom world of not so long ago, but it's foreseen more and more possible for teams to work together. This will be with very much of a simulated reality, not simply with a vision of someone. Companies have been experimenting with virtual reality at work. But which legal framework applies to a decentralized digital workplace? We heard about eBay and the California law. What if the company is in California, in Europe, in Brazil? I mean, we have tools and we have principles to apply in these kinds of cases, so it's not at all terra null. We are able to address it, but we'll have to address it. Then these avatars, which are the simulation of you or me, or even a completely newly created person that we might make who assists us at work and so on. Do avatars have a legal identity? What if an avatar is harassed? And this is actually already happening. And what if an avatar is discriminated against? Also, privacy and data security. A lot will utilize biometrics, which we already use. Who will own the biometric data that is harvested? Governance of the metaverse. Will this be done by corporations? The question of eBay deciding. Will it be done by programmers? Again, quoting Neil Stephenson. And we have a small, extremely literate power elite. The people who go into the metaverse, basically who understand that information is power and who control society because they have this semi-mystical ability to speak magical computer languages. So will it be again, division between those who are very advanced and those who are less advanced? And then I'll say a few words on what we can do to address that in education. Simulated realities and democracy. One simulation, one vote. In a simulation, in different simulations. Citizenship, would there be a balance between simulations of real people and the simulations who have just been created? What happens, and then this is an interesting link to the medical applications of these technologies, for instance, whole brain simulation, which is a branch of artificial intelligence, but can also be used to kind of guarantee, you could say, immortality, that a copy of your brain lives on after you do. But what if a whole brain simulation is destroyed? What happens if while you're alive, it's perhaps a loss of your property, your investment? What happens after you've died if you use this in order to achieve this quasi-immortality in your thoughts? Destruction of the pure simulations, the ones that aren't based on real people. Are there legal and ethical consequences? War and war crimes in the metaverse, and we have a real war and real war crimes, but this is a new frontier that we should start thinking about already now. And then finally, I'll finish up with a few words on what we can do to get ready as lawyers, judges, barristers for some of these new challenges. I mean, one thing I can advertise, and Lila didn't mention it, we're having a summer school on European and international law this summer in Latvia at the Riga Graduate School of Law, where the Advocate General Medina, myself, and Judges Ziemele and Rein, as well as the judge on the European Court of Human Rights from Latvia, Martin Schmitz, are going to be speaking, and I'll be speaking, and perhaps in even more detail, on some of these ideas and these possible solutions. So this is an example, not simply on technology, but across the board on EU law, international law, and including the issues of war crimes and the invasion by Russia that we're facing right now in Ukraine. Another interesting application is computational antitrust, which is the utilization of artificial intelligence to support both authorities enforcing competition law and also being used by courts to either balance experts, because we all know often an expert either represents a school, for instance in competition law thinking, or has worked for or is working for one of the parties in a broad sense, or a group of interested parties. So this will be an interesting development. This is at University of Amsterdam and Stanford, Thibaut Schreppel, a professor there who's French. And it's a transatlantic initiative, but interestingly coming very much with a European initiative. An interesting article which is also putting up some of these issues by the same Thibaut Schreppel and Vitalik Buterin of Ethereum is blockchain code as antitrust, how decentralization, computer code could be used to address some of the competition law issues that we're facing. And finally, and something that I think we could try to copy in a lot of jurisdictions, a very, very useful course which I finished, Computer Science for Lawyers at Harvard Law School. It's actually learning programming and computer science, cryptography, but on a level that is needed for lawyers and linked exactly to the legal issues. So you go in more deeply than simply thinking, okay, here's a web page, somebody made it, but how that works. But again, on a level that is appropriate for someone who's a lawyer, a judge, or a barrister. And with that, I'm happy to finish my presentation. Thank you very much for your attention.
Thank you, Judge Zilgalvis, and indeed you show that future will be complex, but indeed you show us also some tools how manage this complexity. And at this moment I will finish our discussion saying big thanks to every one of you who share your ideas and concepts. And we have in the system of democratic society ruled by law, we have freedom and liberty to discuss, to share our ideas, but we also have rights to have breaks and right to have coffee breaks. So now we are very, very close to coffee break, and I'm giving my authority back to Gundars for closing remarks. Thanks a lot.
Thank you, Jānis, and I would like to thank participants of both panels for your input, for your thoughts and ideas. I would like to thank Māris Vainovskis and Jānis Plebs for your excellent leadership in the panels. And now we have two things. Press briefing downstairs will be held by Ministers of Justice of Latvia and Ukraine. This is after just some minutes. And for others, coffee break. And we are meeting here at 12 o'clock, let's say, yeah? Okay. At 12 o'clock we are coming back. Thank you.
Więc.
Cienījamie fóruma dalībnieki, mēs pavisam pēc īsa brīža sāksim mūsu nākamo konferences daļu. Tā kā lūdzu lēnām.
We will resume the work very soon, so you're welcome back.
We are about to start our next part of our forum, our next discussion. So you can take your coffee and come and sit here. So we are ready to start. Mēs sākam pēc 2 minūtēm.
So we will start in 2 minutes.
Mēs esam gatavi turpināt Rīgas.
So we are ready to resume after the coffee break, while the ministers of justice are still answering journalists' questions in the briefing. We are ready to start the second part, and our first panel discussion is going to be on successful change. critical factors for successful change, to be exact. And now I would like to invite Anders Miltan, Deputy State Secretary from the Ministry of Justice, who will be the leader of this panel. Felix Steffek, Professor from the Faculty of Law, University of Cambridge, Diana Pia, Professor of Political Science of the University of Bologna online, Chloe Levier, Head of Justice Unit in OECD, and Daiga Ziutiņa, Foreign Investors Council representative, as well as Kaspars Kauliņš, International Business Development Director at Tilde. Please take your seats. Kaspars, as a gentleman, is managing and providing seats for ladies, and Anda, the floor is yours.
Hello, everyone. I hope you are back from the coffee break, and we are ready to start our next panel. In the last intervention of our previous panel, we heard about what awaits us in the future. That future is going to be very unpredictable, and there is going to be the metaverse, and there is going to be digital identity and all the other things behind artificial intelligence and things like that. But at the moment, we are still living today, and we need somebody to bring us to that future ahead. So today, in this panel, we are going to talk about the technologies, changes, management of changes, and the leaders who can bring us to this future, and the criteria and facilitation for this leadership. So today we have a very broad geography of our panel, and our panelists also are with very diverse professional backgrounds. So I hope our discussion and our interventions will be also very diverse. Due to ever-changing nowadays world, people are very obsessed with innovation. We say about innovation in every corner in our life. We now have internet, we have metaverse, artificial intelligence, blockchains, and you name it, and it's coming and it's coming. On the other hand, lawyers and legal profession is very conservative. We like to talk about it as something very conservative, and as a proof of that, we know that most of European countries still live by civil law that was written in Roman times, and it's good enough. And this law was good in economics of slavery system, in feudalism. It was good in capitalism, and we believe it will still be good in the new economic formation, the Industry 4.0. So, what is actually changing? Is it law changing? Or everything about and around the law is changing, but law is staying the same? Maybe. And if we keep this thinking ahead, so everybody who works with law, so lawyers, everybody who follows his field know that also legal changes come very frequently. In the last 20 years, this is what we do. We change law. There's amendments and amendments and amendments. So law is changing, but as somebody also from previous speakers said, that law, it's not like a written text. Law embodies some kind of core values of society. And at the moment, we think that the core values doesn't change. So what is embodied in law, the core values, they stay. They are relatively unchangeable. So what changes in law? Is it the core value that changes in law? Or is it just some attributes that change, something irrelevant change, but law stays unchanged? So I hope we're going to talk about the changes and technologies and everything that changes about the law, but who is going to bring those changes about the leader? And leadership can have many definitions. And at the moment, my favorite one is that leader is a person who can create a world to which you want to belong. And more than 1,000 years ago, there was a lawyer called Irnerius, and he decided that he must start to teach a law, and he must do it in Bologna. And by this decision, he changed the higher education and also the jurisprudence forever by his decision. And since that time, we have known many leaders, lawyers. Since today is the 14th of July and a day of French Revolution, I must mention that also Maximilien de Robespierre was a lawyer. So also he changed the world immensely. And there are a lot of nowadays lawyers, leaders. You can name a lot of presidents and prime ministers and ministers and judges, starting from Barack Obama and ending with Ruth Bader Ginsburg. You just name, there are a lot of them. And we still live in a world that they create. On the other hand, somebody would say, well, the lawyer is not the one who should be in a spotlight. It's not the essence of legal profession. Lawyers, they work in back office. It's a very humble profession. They are not in a spotlight. They need to work, and they need to work to deliver the justice. So I believe that many of you have read the book of, and remember the book, To Kill a Mockingbird, or have seen the movie. And so the Atticus Finch, he was a leader, but he was not the role model who are on the front pages of magazines and who wanted to be in a spotlight. He just saw that there is a moment for him to act and to bring justice. And he brought that justice somewhere in far, far south, somewhere in little town, in little courtroom, somewhere far away. But he did this decision to change something very specific for the society, and he showed leadership. And for many lawyers, Atticus Finch is the role model for a lawyer as a leader. So there could be a different perspectives also for the leadership. So this discussion, now I open it by saying that we are going to talk about the technologies, changes, bringing changes, change management and leadership. And since I already mentioned the University of Bologna, it would be only fair if I give the first floor to our professor from University of Bologna. She is representing the academic institution with biggest heritage in our Western hemisphere. And so now I say, Madame Danielle Piana, the floor is yours.
Thank you. Thank you for giving me the privilege to open this very stimulating and important session. And let me start first by congratulate the Ministry of Justice from Latvia for organizing this day, in which I think that a very important keyword has been put in the title, which is responsiveness. I have basically 3 points that I would like to share with this important public and audience. And the points are the following one. First, the link between innovation and leadership. The second is how to make change into a success. And the third point is about responsive justice in changing times. It will be just, but on the basis of keywords, of course. So innovation and leadership. I think that we have been speaking a lot about innovation, and today it is time to move a little bit forward and to focus on leadership and what might be the leadership to lead the innovation and to make the innovation into something different from innovation, because sooner or later innovations should stop to be innovations as such and must become part of their reality. And I give you just an insight from an experience of applied research that we have been carrying on in Italy on the basis of a comparative analysis that myself and my team, we have been doing for many years. And we built a toolkit to empower the leaders within the justice system in order to have them really capable to follow, to monitor, and in the case it is needed, to revise the trajectory, the path of the changing processes on the basis of data. You know, the digital transformation provides us a lot of data, but the point is not to have just data, is to make from data, you know, out a knowledge that is usable for those that have to make decisions. So this is one thing I think that leaders must be today really put at the core of our policy agenda, to be empowered, because if we want that they are leaders, we need to have, you know, them empowered. It doesn't mean necessarily that leaders in the justice system must be seeking for consensus. This is something that, of course, in my understanding, must not be the case. Second point, how to make, you know, the changing processes into a success. Two concepts. The first one, I think that we need to move forward from the simple, so to say, understanding of the resources that are today put into the system, the justice system, from what I call resources in use. Because the point is not to have resources, for instance, in the budget line, but is to have resources that are really used by the organization. And the second concept is to transform, in particular, the human resources in something that I would define an organizational capital. So the fact that you are staffing the judicial system is very good in itself, but what we want is to have this as the first step in a virtuous dynamic, which is triggering processes in which the organization is going to get benefits and durable benefits. So this is, you know, the chain that I would like to see. Now, last point, responsiveness. I think that there are, as always in human history, risks and potential enormous benefits from, you know, the historical period that we are living. Now, the point is to make this changing, you know, process responsive, but responsive to whom? In the very end, this must be responsive to the fundamental rights, to the rule of law, to the values that are, in a way, you know, embedded in the justice system, in a democratic justice system. So in order to have a responsive changing process, we need to incorporate into the governance of the justice systems a moment in which the applied research, and I'm not speaking for my own sake, I really mean it, a monitoring process that provides us regularly the empirical evidence that we do need to have, you know, the effect, the impact of the changing process, transparent, readable, also for the public, for the lay people, for the society, and not only for the inner, you know, actors working and serving within the justice system.
Okay, thank you, Professor. So I heard that leaders need more power to make consensus. Okay,
exactly the opposite. I've said that they do not seek a consensus. They need to be managerially empowered. There are two different things.
Okay, thank you, Professor. So now it is always interesting to talk about law and legal aspects with somebody who is not a lawyer. And I'm the next person who I'm going to give floor to is Mr. Kaspars Kauliņš. He works in Tilde, and Tilde is a technology enterprise which works with language, law, and other very smart things. And we hope that Kaspars is going to tell us now a lot of, from the perspective of non-lawyer, about the technology and about the lawyers we hope to hear.
Okay.
Please, the floor is yours.
Thank you. The mic is on. So I will start with a disclaimer. It's a somewhat strange feeling, of course, being one of the few male persons in the room without a tie. So I hope that still you will consider me somewhat seriously and what I'm going to say. Second, I need to build some credibility around Tilde because most probably the people outside the Baltics do not know us. So Tilde is a language technology company with 30 plus years of history. And we are very, very well known. We are one of the European leaders in developing different language technologies. We are servicing European Commission, governments of Finland and Germany. So we are developing different language technologies. And last disclaimer is that, of course, my part here will be about a very different aspect of a change or leadership in the legal domain, as we call it, and namely how technologies can help tackling different types of challenges that judicial systems, judicial institutions are facing. My introduction will be somewhat hectic, so I have some thoughts. So I very much hope that at the end we will have some time for discussion and you will have some questions. So let me start with that we are actually building bridges between now and tomorrow. In terms of technologies, and since you yourselves admitted that legal industry or legal domain is somewhat conservative. Of course, this is very challenging, actually, how you can introduce new things, new technologies, new approaches, new ways of working in the industry or in the organizations working for an industry that considers itself a conservative environment. But nevertheless, there are ways and there are also precedents already. And one more note, there is actually quite, to my understanding, quite a good similarity or quite a similarity between how we develop artificial intelligence technologies and how judicial system works. It's based on precedent and past experiences and past actions. So artificial intelligence, to the large extent, as we know it now, is basically built using examples of behaviors, using examples of actions, and using examples of decisions made by people in the past. We are actually mirroring, in a way, the activity of the human brain. Yeah, and it's based on precedent. Yeah, and there is a long discussion on how to address ethical and legal issues related to that, but that's not the point today. The point today is that I will talk about only few technologies that can help addressing actually two main challenges. First challenge is efficiency. In order to make the work of people working in judicial industry or judicial domain more efficient, there are multiple technologies that can be used. And since I'm representing language technology sector, I will only talk about the ones that we are working on. So let me start with machine translation. Yeah, it was mentioned in one of the previous panels that important part of learning new things is actually that people have access to content in different languages. And here I can say that machine translation is the technology that can help a lot in terms of providing access to content in different languages, also legal content in different languages. And actually, legal industry is one of the industries where where machine translation technology has been developed to the highest quality possible. I am not going into the reasoning why, but basically there is a very high quality of machine translation possible for legal content, and it's widely used. And it somewhat addresses the other challenge, but I will get back to that later. Next technology, and we have solutions, machine translation solutions that are custom made or custom adapted for the use in the legal domain. Second technology is speech recognition technology. And the speech recognition is widely used in different areas, and legal is not the exception. So based on Tilda's experience, 2 years ago, we built the speech recognition solution for Estonian courts, and we are hoping that we will do that in Latvia and Lithuania as well. But so all the court hearings in Estonia are actually transcribed using speech recognition solution, which helps. Of course, there is still a human, there is still court secretary doing post-editing of those transcripts or making some notes during the court proceedings, so that the output of this joint work of a human and a machine provides the best and useful quality of court transcript. Yeah. Second area where speech recognition is widely used is if you have audio recordings or video recordings with audio sound, where you have interviews, where you have some other procedural actions done by law enforcement or courts, and you would like to make this audio content searchable. Then you use speech recognition as a technology. So you basically you have transcripts, and those transcripts can be searched. So those are like typical. And last but not least is the use of speech recognition for dictation. So instead of writing a document, a person can do dictation, and the algorithm helps to put this into written. So that also can improve efficiency. So I'm still talking about efficiency. Then next technology that is also quite widely used in courts is content analysis. Yeah, so we have experience building also algorithms, and there are a lot of other providers that have built algorithms that help actually help analyzing or doing different types of research of a written content. So you can go back in past, analyze millions of pieces of documentation doing different types of searches or analysis. Then there is this opposite process. This is the novelty thing, which is basically a content creation. So there are algorithms that help designing or writing content, new content. And of course, I'm not saying that a machine will take away bread and butter for lawyers, but to some extent, I truly believe that legal documentation, documents, like laws, procedures, can be drawn by a machine to a very high degree of good quality. Because again, because it's based on precedent, because it's based on examples, yeah. So I truly believe that this is somewhat the future, but helping humans, not taking away their bread and butter. And then the second challenge, and I will finish quickly. The second challenge is accessibility. And here again, I will start with machine translation. So machine translation technology helps accessing information or content in another language for people who do not speak that particular language. Yeah, so this provides multilinguality in a discussion, and we can use machine translation not only translating documents or snippets of sentences, but also integrating it into our emailing, integrating into our chat solutions and products. So machine translation is active. We have solutions where people are having in-company chats using machine translation. So there is a person who is writing in Norwegian, and there is a person sitting in Lithuania, and they can chat in real time using machine translation in their own language. They do not need to learn the other language. So this accessibility issue. Another accessibility issue is related with people with special needs. So basically, people with hearing impairments need, again, this speech recognition and automated captioning or automated subtitling. And we have, again, the technology is there. We have possibilities to do the automated transcripts and automated transcript translations into other languages already. Yeah, but we are building and developing new tools based on that. And then for people who have sight impairments, who do not see, or who have dyslexia, who cannot read, we use another technology which is called speech synthesis, so that the content has tools that can actually read out loud what is put down as a text. So that is accessibility. And last but not least, and this is a different area that is called conversational artificial intelligence, which is best represented by people know it by chatbots or voice bots. So this is also an area where there is a development ahead, and Tilde already has experience with a few startups developing chatbots that can do like simple type of legal counseling. Replying to typical legal questions or queries by people, so that actually, again, it's helping lawyers. It's not taking away their bread, but because then they can focus on more complex issues, more delicate issues probably. So that's the future. Thank you.
Thank you, Kaspars. As a person who is very much involved in legal drafting and drafting law, I was very intrigued. I would like to see the first project drafted by artificial intelligence. I'm very looking forward to it. But now the person sitting next to me is also a professor and representing the University of Cambridge. This is Professor Felix Staffek. And we are very much hoping to hear from you now. And as you're coming from Britain, people in Britain usually have a very different and much more pragmatic view to the things that we in continental Europe sometimes see as very highly estimated. So, Professor Staffek, the floor is yours.
Thank you. So thank you very much for the kind invitation. It's a great pleasure to be here today. And as you may hear from my accent, I actually do have a continental heritage because I was born in Germany. So I'm actually not sure then from that perspective what I really represent. But I do hope that I can tell you something that is of interest. Because I would like to report from a study that colleagues and I have done together on procedural justice. These are my colleagues, Professor Ben Bradford at UCL and Naomi Kreutzfeld at Westminster University. And the study is relevant, I think, because it's the first study ever in which we empirically tested the relevance of procedural justice. In other words, we try to find out whether procedural justice matters if we look at the users of justice institutions. Of course, probably all of us have an intuition that procedural justice matters. And probably also all of us think that it has a moral value. However, until this point, this very important aspect of our justice systems has never been proven with data. And that is what we set out to do. Now, our study investigated the Federal Consumer Conciliation Body in Germany, which in German is called the Universalschlichtungsstelle. And this ombud scheme is competent for consumer trade or disputes all over Germany, where there's no other ombud scheme that has priority, for example, the ombud scheme on public transport. Now, for example, consumers can go to that federal body if they have ordered something on the internet and they are not happy with the goods that they have received. The decisions of this ombud scheme are not binding. Now, our study is particularly reliable in terms of data because we have over 1,000 responses from consumers, how they experienced the practice of that ombud scheme. And we have, in addition, more than 7,000 case files where we have all the objective information of how that case went. So the particular information that makes our study so robust is that we have the subjective perception of people of the ombud scheme in addition to the objective information what actually happened. So, first of all, how did we measure procedural justice? We measured it by asking a number of questions, such as, was your opinion heard? Did you feel taken seriously? Do you think that the ombud scheme was neutral? Did you feel respected by the ombud? Was the staff consistent in the decisions that they took? Did the staff understand your problem? Now, altogether, in addition with other questions that, as mentioned, we have more than 1,000 answers to, we could then measure procedural justice as perceived by the users. And now here are our results. We found a strong correlation between procedural justice and satisfaction, between procedural justice and the experienced duty to obey the suggestions of the ombud scheme, and also between procedural justice and the perceived lawfulness of the procedure. In other words, if the procedure was just, then the users would be more satisfied with the procedure independent on whether they lost or whether they won their case. Or users would be more likely to obey the suggestion independent of whether they won or lost. And they thought that justice has been served, again, independent of whether they won or lost their case. Now, in addition, because the perceived obligation to obey a decision and the perceived lawfulness are measures of legitimacy, we can now also show empirically that procedural justice improves the legitimacy of justice in institutions. In other words, we can show that the perceived legitimacy of a justice institution does not depend on whether a party wins or loses, but whether the procedure is fair. And this means that a fundamental building block of justice in our democracies, that is procedural justice, really matters. And as we had the intuition so far, we now for the first time can show this based on strong data. And that is in particular important because democracies very often cannot satisfy the wishes of the parties in justice institutions. We could also, and that is interesting, show the opposite. And that is, if users think that the procedure is not just, then the outcome becomes more important to them. In other words, if the procedure is not fair, then the parties mainly look at the result in thinking whether justice has been served. Now, our findings have practical implications for the design of justice institutions. Our research suggests that the following design approaches can help build and maintain users' perception of a just process. Make sure that users are heard with their facts and their wishes. Take the users really seriously. Make sure that the people, the governance, the finance, and the rules of a justice institution ensure its neutrality. Respect the users of justice institutions at all times. Communicate clearly throughout the entire process. Keep users up to date with the status of their case. ensure that like cases are treated like, and that the various staff that communicate with users always send a consistent message. And really try to understand the problem that the user brings to the table. Now, ultimately, this will encourage them in accepting the outcome reached and be satisfied with the justice institution, independent on whether they win or lose their case. Thank you very much. I hope you found this research interesting, and of course I'd be also happy to discuss later. Thank you.
Thank you, Professor. Not to talk about just the technology, but also touching the core values of the justice system, the perception of justice. My next speaker, I'm going to propose the floor to somebody who is not working to facilitate or to create the system for justice, but who is a user and I would say the customer of the justice system, person who is representing the investors in Latvia. So this is Ms. Daiga Zūtiņa, and please, the floor is yours.
Thank you for kind introduction. I'm representing the Foreign Investors Council in Latvia in this forum, and at the same time I'm practicing lawyer and partner of the law firm and leading our disputes team with experience and observations about developments in our court system. Digital transformation is one of the key priorities of the Foreign Investors Council, and it includes better access to courts and strengthening digital capabilities of courts. And during the last years, FISTIL has urged public sector to introduce changes in digital format, and keeping in mind that only part of society is able to adapt to these changes and be able to use them, and other part would need more time for learning and also support. During last couple of years, during pandemic, our practice, experience, and attitude has changed considerably, and what we resisted and hesitated to use in previous years now is becoming routine. And I would like to talk about modernization as routine today, that leads to innovations. And this correlates what we had heard already regarding developments in technology sector. And when we have used to remote court hearings, electronic submissions, and different behavior and attitude from the parties involved in court cases, we have already desire and need to have better tools, for example, navigate through our court files, or to have one joint electronic court file, numbering of pages, and an ability to navigate through audio recordings, or have parallel translations in remote hearings as we have used in courtroom hearings. And we hear that all these opportunities are technically possible already, and it means that lawyers and business society should work very closely with professionals from technology sector to introduce these all opportunities step by step. And I would like to mention good examples of our neighbors. Our Estonian and Lithuanian colleagues, they have forgotten already about the paper format files, and they are using electronic cases, and they are navigating through these cases very easily, and they have adapted to this. And these are very good examples which are tested and which could be introduced also in our regulations and our practices. And currently, it looks that we are translating existing procedures into digital procedures. And we see that attitude and behavior of people is changing. And for example, I would like to mention the best examples, what we can observe in courtrooms, that remote hearings are becoming shorter, that parties are better prepared, that submissions are timely submitted. Of course, these are the best examples, but those examples could become the new normal. That could be the new addition to the new regulations and the new standards. And of course, investors, they are interested to reach the result very quickly and with smaller resources as possible. And this is the area where the business community, legal community, and technologies sector could cooperate and to go step by step to reach these desired results. And in conclusion, I would like to say that this is a very creative time when we are living and working, and that brings also a lot of opportunities, but also responsibility. Thank you very much.
Thank you, Daiga, for bringing our attention to the technologies which will not exist somewhere in the future, but which exists now and is in our hands, and we just need to go on and use them. So, last but not least, as we say today, for the last panelist, so I'm going to give floor to Chloé Levrière, and she represents OECD. And by intention, she is our last speaker because we see that OECD connects the most developed countries. And if you work for OECD, I think you have like an eagle-eye view on everything that happens, on the best experiences and best that world today has to offer. And we hope that you will share just a little bit today with us, with your experience. Please, the floor is yours.
Many thanks. And it works. And first, let me thank you, the Ministry of Justice, of course, and the court administration for their kind invitation. I'm really honored to be here. And indeed, I represent the OECD. We have been working in this area for many years. And we recently, last year, launched the framework for people-centered justice system that represents and has been consulted with many of the OECD countries, but also partner countries. So we do hope this is also the way forward. It's also a framework that has been launched during online, but hosted by Latvia during the Global Dialogue for Justice Leaders, where the Riga Justice Agenda has also been adopted. And as such, many things have already been said when we are talking about critical factors for successful change. And of course, the first one has been the role of what change do we want? What is the objective? It is, of course, better access, better performance, more effectiveness, but also it's also serving all the people and all different groups, whether they're human beings, whether they are corporation, etc. And so this is, with this in mind, I would like to share with you some factors, some items on how to make it happen, and importantly, how to establish but also to sustain such change. So first, as it has been mentioned many times, it's the importance of a committed justice leadership that will maintain a clear purpose and also a culture of a justice system that places people at the center. And here, this is a very testament of such leadership, also because we are in a room full of like-mindedness, people who are people who are committed to transform the justice system. And such justice system will need to have the clear roles and mandate of all different actors of the system, whether it's the judiciary, the ministry, the NGO, community-based justice services, but also parliamentarian and central government. And that's what we call a whole-of-government approach to the justice system. Of course, it needs a clear strategy, and in order to integrate such vision and the concrete goals and expectation of the different actors. Importantly, as it has been mentioned by Daga very recently, and of course during the first panel, the COVID-19 crisis has shown that people-centered justice require adjusting institution and policy so that they are adaptable and are able to respond to the new situation and challenge. So the future is indeed uncertain, but we can, and justice system should also mitigate that kind of uncertainties. And how to do that, for example, by developing and incorporating crisis management plans into the justice frameworks, and also integrating a people-centered lens, justice lens, into the national emergency management strategy. So what are also the main implications, and what are other steps? As mentioned, so not only we are looking at it's important to foster the commitment of all the actors of the system, but also of all the stakeholders, the users and the groups. Could be legal professionals, businesses, trade unions, civil society as a whole. We have been mentioning that Mr. Stava has mentioned the rule of law as a religion. Justice is also seen as a religion, as a system of belief when we talk justice with a big J. So justice, serving justice. We want justice. This is a system of belief, but we can make it concrete. And this is thanks to you, thanks to advancing such transformation of the justice system. It's also, of course, important to identify key leaders. Our moderator rightly shared a definition of the leaders, but leaders can be identified at all levels of the system. We call them champions of transformation, and they will be committed to overseeing the development and the implementation of the different policy. Comes, of course, when there's different actors, there's a need for interagency cooperation. This is, of course, a very big challenge when also between the different actors and in all countries, so whether we are talking about public or non-governmental entities, or community service organization, and of course the private sector, into integrating them into the justice delivery schemes. And importantly, one of the factors is also to strive towards improving the quality and performance of the justice services at all time, to maintain such vision, to maintain such culture. And we will, and I will finish with a couple of two very concrete points. We've been talking about the growth of ITC and artificial intelligence that are holding much hope for improving access and transforming the system. But I really want to highlight also the role of the need of good data and of sound and transparent governance of the data, which will help to make the system more effective, more evidence-based, and also allocate limited resources in the most efficient way. Of course, many countries are now facing some financial constraints, so how to make investment the most impactful, and data can help with this. And importantly, the responsibility and the capacity for developing and providing the different data sources will have to be distributed among across the whole range of government and non-government actors. And in doing so, the responsibility is spread, but we also need to ensure that there is a sufficient commonality and interoperability of the system. Some countries are developing very good practices, whether it's also here, but also in neighboring country. And this is, of course, remains a key challenge for many other countries. But we believe that this is a challenge that can be met by government that are taking a key role and leadership role in transforming the justice system. Of course, comes risk as well of using all this data. No need to, or I will highlight, of course, that data we need to ensure that they are safeguarded and that data are used in a respectful way, to protect people's privacy and personal data. And finally, importantly, we talked about human beings and change, transformation and change could not happen without human being. And as I mentioned, identifying some champions, but also the whole, it's important also to invest in the whole of and all the different people working in the system. So revising maybe curricula, updating training, creating some teams that are responsible and feel that they are empowered to implement such changes. And my last point, when we talk about transformation, we also mean change. And change, we highlighted many times that the justice sector is a conservative sector, so change could be threatening, and it will be important in any reforms and going forward to integrate policy of change management. There are many we can take. There are many examples in public governance areas, but maybe this is also could be a very good way to ensure that there is buy-in of the system, there is monitoring, planning, monitoring, and evaluation of the transformation. So really thinking about the transition and the change through change management policies. Thank you very much.
Thank you, Chloe, for bringing our attention to the fact that in future the justice systems should be more responsive and more flexible to the coming crises. As we witnessed lately, crises are coming more often than we expect them, so we must be ready for them. And now we have quite a time for the discussion in our panel. And so there is a full democracy in our panel. So any panelist can ask any question to other panelists or give any replica. I encourage you to do that. But as a panel leader, I will show a little example. So my question will be to Kaspars, Daiga, and Chloe. And it goes like that. As we have heard recently, so there are a lot of changes, and we hear about digitalization already some 15 or maybe 20 years. And at this point, almost all the countries have some kind of a digital platform or IT tool platform for the justice system. And still we talk about digitalization as some kind of innovation, as a way how to move forward. So in your opinion, how could we distinguish the situation where the IT platform just continues normal evolution as it goes, as it should be, and when there comes some kind of crucial thing that we can say, this is the innovation, this is the game changer. It's not just the future steps as we could predict, it's like evolution of something. But this is innovation that is the game changer in this digitalization of IT platforms. Well, what would be your opinion? Well, democracy, who is ready then starts to talk.
Thank you for this question. I would like to refer back to the continuous learning process. And it's clear that we are involved in this learning process. This is very, very important. Then the next question is how to bring together people from various fields to work together, to create the best result. And currently, I'm involved in ODR project, online dispute resolution project, together with Felix and Chloe. And we are trying to find these responses to similar questions. What are the current procedures? And how these procedures should be changed and how they can be changed, and what will be the benefits for these procedures. And from the investors and corporate perspective, of course, these benefits would be speed, costs, resources, less resources which are needed for this, that simplicity, understandability, and of course, some kind of predictability. And finally, that would make the desired result that the clients, companies, individuals, they are willing to use that result. They rely on that result. That would be my response and comment.
I will then take the chance to respond from technological point of view. I would start by challenging your statement that there is a platform in place for technologies. I believe that different countries are in different stages of technological development or digital transformation, and in terms of the ecosystem, so everything, IT ecosystem, I mean, or technological ecosystem, its legal domain is not actually in the very leading leading position, but nevertheless, considering the question to where the innovation starts, so where the evolution turns into revolution when we talk about any process, I believe that the main criteria should be related to, first of all, the novelty of this new approach, technology, process, and of course the result it brings. So just to give you an idea regarding revolutionary change in artificial intelligence. So artificial intelligence as a concept has been around for almost 70 or even 80 years. But the very recent change in 2015, 2016 was when scientists started using graphical processors for machine learning exercises, for data analysis and data modeling exercises. So basically the graphical processors also have been around for a while, but the very fact that this already existing technology was now used in the new way, in the novel way, actually provided for exponential development of different AI-based technologies. So that's introduction of new of a novel thing that actually provides a new functionality or increases significantly efficiency, accessibility, or any other aspect that technology can help with.
Thank you very much, and let me add as well, like identifying a game changer. Well, I mean, it's a very if I had the answer, I mean, we would be implementing in all country. We would be modernizing many countries at the same level. But it is a difficult challenge. But I'd like to quote Felix from a dinner. Who I think it was also a quote from one country. Who a leader said, like, you need to test, you need to try to innovate, and if it fails, well, we will learn lessons, and these are these lessons. So identifying a game changer, innovating is about testing, failing, experimenting, and lesson learned. And second is also about sharing this lesson learned, sharing this experiment, and peer learning is very important. It's one of the core methodology at the OECD, and we really promote this type of mutual exchanges. And of course, whether it's at the OECD or here in Riga today, it's very important to continue the dialogue between different countries, between different level of justice, between different institutions that are servicing justice and people and groups and businesses. Thank you.
If I may, I would like to kind of come back to the theme of innovation that, Chloe, you just addressed. But also, Anna, I wanted to pick up, on your introductory statement, because you started to think about who innovators are. And, making this panel a real democratic panel, I'd like to include the audience and ask to everyone, who do you think was the greatest legal innovator ever. I think this is a great, pastime discussion with friends. And I did it with some friends, and it was quite controversial, I must say. And now I'd like to offer kind of two candidates. Looking at the entire history of the law, I would say probably my number one candidate would be Gutenberg, who invented the printing press. Why? Because that made law accessible to everyone. Now my second candidate would be Aristotle. Why? Because he taught us as one of the first that we need to think about the values of law and that we can design the law according to these values. Now, if you looked for legal innovators, then probably, those perhaps who drafted the first civil code in a country, or, national and I think international lawmakers are great innovators too, and candidates. Or from the professions, Daiga, those inventing the virtual law office, or perhaps those inventing law reports were great innovators. Now, while this is, I think, a fun pastime, perhaps the more serious question behind this is, and that connects back to Chloe, like, how do we value innovation at the point in time when it happens? Because quite often at that point in time, we don't really know where it leads to. So do we think about innovation as perhaps the aggregate of value created in a society? That then raises the question, how do we measure innovation at the point that it happens? And that kind of probably connects us back to our values of justice systems. So when we think about innovation, I would say a helpful way is to think what it will do to the values and how they're implemented in our justice system. So I'd be interested maybe later in the break, to hear from some what you think the greatest legal innovator ever was. Thank you.
Maybe we can do it right now, and maybe we can take some questions from the audience who is ready to ask and make any remarks. Minister Bordans. Okay, we just pass you a mic. Just 1 second, I'll give you a mic.
Yeah, if I may offer, maybe one of the greatest innovators was Montesquieu, could be, and maybe there are parallels with today. Nowadays, we are looking for new, let's say, world international order, how to restore it. Yeah, thank you.
Well, somebody else? Well, at least 2 or 3. 3 is for good luck from the audience.
If I might just very briefly respond, I think Montesquieu is great because I had overlooked this in my thinking about it, because you're talking about governance of justice institutions, which is key, of course.
Vēl kādam jautājumi? Mums vēl vajadzētu vismaz.
Oh, we need at least 1 candidate or 2.
It's a professional interest. Please raise your hands who believe that at some point in time soon, there will be an algorithm who will be able to draw laws. Think about it, think about it. Hands are still getting up. Well, please keep up hands, because I need to... Okay, I assume the others are in the opposite opinion. Okay. Yeah, thank you.
Well, it was also, I was raising my hand, and well, we still have a time for discussion, and I prepared the next question for panelists, but also now from everybody from the audience. Can you imagine about any tool that we need in near future, similar to those who were mentioned by Kaspars Kauliņš, so that we can use in court as machine translation, as speech synthesis, as a dictator app and things like that. I stood and I thought about that, and I came to conclusion that whenever my relatives or friends receive some kind of document from institution or judge rulement, they are really suffering to understand it. However, I pick it up and I read it, and I cannot understand why they cannot understand it, because I understand it. But of course, I see that the context and professional background and life experience for people are different. And I think that the chatbot is like relatively simple and relatively already wide-known artificial intelligence type. And I thought it would be nice if we could create a chatbot who could explain to person their legal documents that they have received from some institution or some judgment from the court. It would really benefit the everyday life, and this is the technology that is not like very far away future. It is something that we could do in reasonable time.
It actually already exists, I believe. I can refer to Tilde's experience with the European Space Agency. So we have jointly developed a chatbot that is helping young scientists to navigate the databases, very sophisticated databases of European Space Agency. So if you are a young scientist and you are doing a research in astrophysics, for instance, and you need to get some kind of visuals from some space expedition or some visuals, some photos made by a telescope or whatever. We have created a chatbot that helps you to define what kind of data you need. So it leads you through the process of thinking, narrowing down your inquiry, and ending up with a request. Like the system makes the request towards the database, so you receive the data at the end. Yeah, so that's just one example. And once you have your data, and the availability and openness of data is critical here, of course. But once you have the access to the data, both for training artificial intelligence or machine learning solutions, and also data to be analyzed, data to be used as matter for analytics, then you can actually have very good algorithms that can do the job, very complicated job of inquiries for you and help you to find the right piece of data or compare different types of data, different sources, and so on and so forth, which could not be humanly possible if you do it by yourself.
I see that very many replicas, but I think Professor Piana wants to come in with a comment, so please.
Thank you. Thank you. I like this scenario that you just depicted, and because this is something that exists. It is not in the near future, it is in the present, and goes back to this idea of making innovative justice also responsive to the needs of people, to the needs of the society, to the needs of the companies. So to have a sort of a bridge that creates an understanding, an intelligibility, which is very important, also to reduce complexity and to make justice more effective in delivering the response. And this goes back to the fact that when you have leaders that are taking decisions, managerial and organizational decisions concerning innovation and changing processes on the basis of a highly sophisticated system where artificial intelligence is integrated, algorithms are properly used, nonetheless you need to have an overview vision of which is, the way you are going, the path you are taking, and the spillover effects that your changing process is going to provoke. That's the reason I think that you need always to have in the governance of the justice system this combination between human, organizational, and artificial intelligence that must be, kept, really preserved.
Thank you. So.
Just one, drawing on my experience also as a judge, I was, of course, the efficiency of online trials, online video conferencing, etc. But there have been some voices against, and which we should also hear about them. And I was thinking, how to try to ensure online video conferencing and and mitigating this need of human touch. And I was thinking, why not create tribunals or courts with holograms? So the defenders are holograms, and they're not just on the screen, but they are in front of you. So I was like, it would be, even as a user experience, whether you're the judge or the defender or the litigant, being in the court, you still have the experience of being in the court, having this human touch, but also making the most of the technology. So holograms, I was thinking about.
You have a question or remark? Yeah, I'll give you a mark.
Thank you for this exaggeration, and I found it very interesting. I just wanted emotionally to interfere as a former judge. I feel convenient with online hearings if there is a bunch of professionals, as I said before, the 2 lawyers, maybe an expert, there's a technical discussion or a remote witness, which is not problematic, then please do it on the screen. Nothing harm, but no judge in the world will be crazy enough to do something which is sensible and where you need this human touch, where you need to hear the witness, where you need to treat and deal with a victim of sexual crimes online and not in person. Yeah, this is, I can guarantee this is no one in Europe would be that crazy enough. And there also I would draw the line with the hologram story, because the hologram would give you an impression that someone is like an avatar in front of you, even if the hologram is taken from the original person. But at least spontaneously, emotionally, I would draw the red line here and say, no, yeah, I don't want to. I want to have a human being either in front of me or it can be the screen, but I do not want to have anything which is like an avatar, and then I draw wrong conclusions with my human brain from the reaction of the hologram and the avatar. This is then where we hand over it to the machine and not anymore dealing it with the judge's brain. But I also encourage us to ask exactly these kind of questions, because what I'm missing is a proper red line framing on what we consider is appropriate and what not. In COVID, a lot of countries were very exaggerating with this and did things a lot. Some of them rode back. The Austrian president of Supreme Court then said, you know, court hearing is not a yoga lesson, so we don't do this anymore on screen. It's also a little bit too extreme. And on the other hand, you have Ukraine with the pressure of doing a lot of online thing and thinking, okay, people are moving as they are moved out the country, they are on the road, etc., due to the war, so of course online. Then the court is also not existing anymore because maybe destroyed, so the judge is doing it from another location. But why then the judge has to sit on the courtroom at all? Is it possible to have all of them somewhere, and is this then the virtual courtroom? And some scenarios sound familiar when we say, okay, the judge is sitting in the court, and we say, yeah, super. When the judge is sitting somewhere at home, then some say, no, it's not. But all this is totally not defined as we are living in the situation, and I would love to get a little bit more also scientific approach and professional discussions, what is possible and what we shouldn't do. This is at the moment not happening.
Thank you. Anda, do we have time for another remark from your boss?
Yeah, sure.
Yeah, okay.
No, please remember that this is discussion and discussion about ideas, not about hierarchy. And I would not, so I recall to talks, so ideas regarding artificial intelligence, maybe not just online dispute resolution or holograms, but I'm just looking on pictures and paintings on the walls. You see there and there brave people on the horses. And I just imagine that in that time maybe somebody tried to invent a car with engine, and the guys on the horses would say that, you know, this is quite dangerous, and we have this emotional touch with the horses. They are human, not human, but they are living beings, and this is for our health also important, and for traditions and for our values, and let's not invent the cars. And maybe that disputes about how far we can invent artificial intelligence in court procedures and in work of judges is there are some similarities with that dispute, not invent the cars. Because artificial intelligence will be invented, and mostly we are discussing maybe about like now how to psychologically to switch to that possibility. But there are this is the bright future. Future is good, and the future for the horseman is good because they are driving Ferrari, or they are walking their home they are walking, or they are sitting and working through computers, and they don't need to jump by horse to meet each other. So, and the same is with and they are using their brains, and we will use our brains for something more important. And what is this more important? We will find out. So what is more important to think about it? Maybe not to think how to put our ideas on a paper, or how to preserve the paper, or something else. Or maybe how to formulate our ideas, but artificial intelligence will help us, but we will use our intelligence for creating ideas, as example. And that is why we need our brains and our intelligence, not just like if we would be Smith in all these times, and using hammer also. Now they can use modern technologies. Thank you.
If I may come back to this idea, using artificial intelligence to push the borders. I would like to report to you another interesting question I find that I had from an AI project that I'm doing together with computer experts. And so my computer expert friend asked me, Felix, we have limited time. Tell me, if we use AI, what is the holy grail for lawyers that we could achieve using AI? So then I thought, my answer was, if we could use AI to predict the outcome of court decisions. Why? Because if there is no conflict, then usually we don't need the law, because people cooperate without a problem. There's no need, not even a need for a contract. Now, if there's a conflict, if you would know what the outcome is, then you could very easily find an amicable solution. There wouldn't be a need to litigate. Or if the other party wouldn't still not settle, you would know what the outcome is, whether it's worth litigating. And then thinking about this, I think, if you think about, is there any benefit on citizens not knowing what the court will do? I don't see any benefit in citizens being surprised in the court. So that is perhaps kind of my offer in that sense, kind of responding to your question. But as well, I think, of course, this is easy to say on a panel in 2 minutes, but we have to think through the complications. I don't want to hide that, of course.
So thank you, Felix, for the last remark in this panel. And if I can just say one short sentence to summarize all this. We actually need another conference to continue talking about this. I think there was the big interest, and thank you also for the public and your questions and remarks. So.
Paldies. Liels paldies visiem.
Thank you to everyone. Thank you to everyone participating. Thank you, the leader of the panel, Andis Miltāne, and panelists. And now I welcome the next panel, whose lead will be Ilona Kronberga, Parliamentary Secretary, Ministry of Justice, Dzintra Balta, Deputy President of the Judicial Council, Adrija Kasakovska, President of the Association of Judges in Latvia, Viktors Vadash, Deputy Director, European Law of Academy, Kristīna Strada Rozenberga, Dean of Law Faculty of the University of Latvia, and Jānis Rozenbergs, President of Bar Association of Latvia. This is when we are ready to speak about what our objectives are for working in digital environment and how this will be better than working in digital environment. Thank you. Can you hear me? No, not really. Considering that, taking into account that we have spoken a lot about the things which are more technical in a way, then now I would like to focus my attention to another topic, that innovation is not just technical solutions. Innovation is also for humans and for people from the people. This is where they go. This is the direction, and innovation is something new we create for one or another thing to be better, to be more successful for us. And everywhere there's a human behind. And here we had high flights of our ideas and minds we expressed. And if there is a person who in reality can realize the soul, if comes no such person, then we remain where we have been so far. And this is why, and this is not according to our objectives, and this is why today we're going to speak, because this is before lunch, you know, you are all tired and actually expecting the lunch, but waiting for it. But this is very important. This is important. This is about people. And as we are ready with this topic, then I think we deserve lunch. As we have finalized a topic, then we will take the big break. I would like to say the following. We are looking at a clock, and we have exactly 1 hour. This is what I will take into consideration by leading this panel, and how we will do. The format be as follows. The experts we have here, they are going to express their opinion practically like once. And then we reflect on the questions you ask, and we will ask each other also about the things the colleagues have elaborated on. This is how methodologically we're going to do, so that it's not boring. Listening to the previous panels, I also took notes and what I understand from those discussions. We are talking about what the methods are and what are the objectives we can reach for our legal sector to be approachable, to be accessible, to have safe environment, to have entrepreneurs that can rely on the rule of law in a particular country, etc., etc. But of course, the legal professions and the broader context of them, I will not name them all. But even though I think every lawyer at some point thinks to themselves, I think they think being a judge, or they are judges. It doesn't mean that other legal professions, advocates, lawyers, attorneys, that they are lower. But the judge is a symbol, and we cannot deny that. However, judge is also a person as each of us. And here on stage we have judges too. Rather serious experience. And the result of the work of judges is very much related to the performance and output of other legal professions, regardless of what is the proceedings. It is investigator, prosecutor, etc. And then it comes to the judge and their work. So the judge is like a leader. And if we look at leadership being one of the questions and topics we discussed today, thus we understand that with the leadership, we go to the leadership we get through the process of changes, which is what we are aware of. We do it consciously. In our democratic system, we aspire to reach not one authoritarian leader and everyone is bowing in front of them, but we will have goals inside ourselves. We will have a lot of educated people, emotionally intelligent, very smart and very skillful. And we will have a lot of leaders, and we can reach our goals by those leaders being horizontally and vertically cooperating. We love the technology, and as I said, innovation is not only technology. However, the technology cannot substitute a human being. Always a person, a human being, the center of things. We can just make some time for them, or we can make room for some time, or make it more convenient for them to work, maybe some technical things related to innovation which maybe there's something we shouldn't do, and in turn do something that is eternally serious and significant. However, the role of a human will be actually growing over time. So these are the thoughts I just wrote down. Why, for example, rule of law is important for the person to be happy. Okay, one of the ideas, but when is the person happy? One of the first needs of the person is the security. For each of us, individual, who constitute the society, and for the society as a whole. And as trivial as it may sound, the security is something which includes the rule of law. If we do have justice, then we can rely on it and know for a fact that it will be as it is said to be. Regardless, professional development, work, politics, there's a word, and the word materializes itself. And the security of the society, it's not just you come there and you say, well, everything's fine without justice, you're safe. That's all. There's nobody like that. But they would say there's nobody who can do anything bad. There's not such situation, because we have people who breach something, violate. We go towards, we cannot announce that people are safe and secure. People can only feel the security. However, if they do not feel it, we can tell whatever we like, but they just do not feel safe. And this is why you say Kronberg is lying. Well, judge for yourselves. Whether you feel safe yourselves or not. The human nature is very interesting. And so there are methods with which we work. And this is what I'm going to ask to the panelists. The people will forgive what you just said. The people will forgive what you just did. But they will always remember how you made them feel. And this is what remains. And this is what they expect. This is what they will remember for the years to come. And this is the key to it. This is the salt, the essence, is the feelings we leave behind, and it is the feeling of safety, of justice. It is the feeling in the community and in ourselves, in each of us. So that's that. The time of changes, and we have had the 21st century will go into history. Well, you know what? Colleague Plebs said this, but it brings us not only comfort, the century, or maybe prosperity. It gives, but it also requires, and it takes. And this is what we now understand, that everything we gained, everything we received, it's not for free, and everything that's going on in the future, it is going to change ever more. Then the requirements, the expectations. This is what all of us have. It is both the prosecutors, the judges, all the lawyers, and all non-lawyers and human beings. It means that it's not only knowledge, it's skills, it's human skills. And here we also heard today that the justice system is conservative. And now imagine, what are they asking from us? I'm talking about all the lawyers. It's leadership, it's formal education, it's emotional intelligence, it's languages, not only English, so language skills, as we, for example, spoke in the morning, maybe we need Spanish and French too, because they are also commonly used. And in literature, as Madame Medin said, and we need to develop throughout all our lives. Now, what else is required from us? Making decisions, ability to make decisions, even if it's hard, even if everybody's just expecting, but it's difficult, but you have to be able to make a decision and to explain your decision and explain it in a way that not just everybody thinks, you know, you're very smart, but for everybody else to think, oh, okay, I understood. Well, that is a great difference. And that too is innovation. How we make this explanation, how we formulate it, and everything else, everything required from the judge. It is the management of change. They have to lead the court also, for example, the courthouse, well, or the court sessions where there are various people, various backgrounds. So, altogether, what do we think? How is it really conservative, our justice system, or is it like a stream where the water is constantly changing? Now, from this, I ask my colleagues, panelists, please answer the question. Answer 2 questions. We will give them 2 questions and time for replicas, and you will be able to ask questions then afterwards. The first one I would like to hear from you is, we understood that everything I just said, to achieve everything I just said, we need a formal education. We need lifelong education whose integral part is a continuous education after formal education. Now we need to divide it into the stages, etc., and we have prepared a lot for the Ministry of Justice too. The Academia Model Introduction Project, it's not yet approved in the government, but it's very close. It's on the way. So all these things require a common understanding and action. So how do we make it for the academic environment to give us the people who can then, going into further education, understanding the lifelong education that we needed also for the changes, constant changes, what is the role of judges and what is the role of the decision of judges in this education, because they are one of the users. The prosecutors are one of the users, and attorneys are one of the users. And we do understand that the second question is, if we say just the opinion on what there is, then we say, okay, we like everything, we do not do anything else, or we go further and find some solutions. So the first question is where we are right now, and the second one, where we are heading in order to reach the objectives of an ideal judge, of an ideal prosecutor, of an ideal attorney, ideal investigator. How do we get there? Considering the fact, all these things which we have at hand right now in front of us. And so at first, I would like to give floor to Kristina Strada Rosenberg. She is the dean of the Faculty of Law. She stands there. She's standing there. She's creating the new leaders, the new professionals. So what is missing now? What is the next step for us to reach the objective?
So I would like to start with expressing gratitude to the Ministry of Justice and the Minister for invitation to participate in this forum. And yesterday the Minister said, and also today said, that this is a symbolic event. And in some sense, I would like to say this is also symbolic for the academia. I will speak about it a little bit later, because rarely do academia institutions are invited to participate in such professional events. we are more or less standing aside, and us who belong to this academia, we sometimes feel kind of useless for nobody. Of course, we have this common sense, and we understand somebody need our work, but in this public opinion, somehow we are somewhere aside, because we are not formally in the system of justice. Also, the system of education somehow is not so much focused on lawyers. Sometimes it's even the contrary, especially in today's situation. Probably I will represent the minority, but we are putting in focus sciences and these subjects. And of course, I'm not against it, but next to these social sciences, there also have to be next to these science and biology and those subjects, there should be also a social science, especially in these current events, the war, which were caused not because people didn't know how much is 2 added to 2, but because they had lost the main value, which is a human and a person. And also in knowledge of jurisprudence and law, it is important to have artificial intelligence and so on and technologies. But if we lose a person, a human, then I don't think it's going to be great. And thinking about today's task, we can see this title behind this, Critical Factors for Successful Changes. And looking at this title, what can we see there? We see a process. It's not about the result, because changes, it's not a result, and it has never been a result. Changes is something which is done if there is a need to change something. So first of all, we have to understand what do we want to achieve with this. And here we make a huge mistake, possibly in education and also in legislation process, because we quite often see this means as a result. Technology, which have to be as a means, is considered as a result. And the speed of the process, which also has to be a means, is considered as a result. And then we lose ourselves with some charts, with crosses and ticking the boxes, and we are answering how efficiently we do something, how fast we do something, but not what result we achieve. And this characterizes our educational system and also our legal practice. So if I had to answer the question, what are critical factors for successful changes? First of all, I would explain what I see, what is successful changes. So successful changes is improving human well-being. And with well-being, we understand a lot. This is legal security, feeling of justice that people get in the processes. So this has to be human-centered attitude. Second, the reforms are implemented with a responsible manner, because when we lose this responsibility, we lose the rest. And the last is that each reform has to be knowledge-based. So without enough knowledge to start implementing something, and especially to do something and achieve something, is impossible. And then the question is, where do we get this knowledge? We can get knowledge in various ways. One of the central questions, of course, is education, and also education in law. We could talk about it in several levels, like Ilon already mentioned. So first of all, this is this basic legal education. So when a person gets and receives the lawyer's qualification, then the next level is vocational education. Then, for example, a person who wants to become a prosecutor or a judge, so this specific training for them. And then the last layer and level is lifelong education. And usually one of the central questions is the form and the content. So what kind of form we will have to implement this education? And next question is the content. And also, who is going to do this? Who is going to be the educator? If we talk about the form, then I assume that in Latvia we have come to the situation, to the moment that looking at the basic legal education, we can discuss whether we need to extend this these years of training, because looking at those 5 years, having the restrictions set by the state, can we get all the knowledge which is necessary in those 5 years? This could be one question we could discuss about. If we stay with this 5 years model, then the next one is this professional training, which has to be institutionalized, which has to be long enough, and also grounded, well organized. If a person wants to become a prosecutor, it's not. We are not talking about 1 month or 2 months. 1 year or 2 years we need for a person to be purposefully prepared for the prosecutor's work. And even more, this is binding for judges. And if we speak about lifelong learning, this is a permanent process, and the state also has to involve, and that cannot also be included in days and months or something, because then again we go to these charts where we just put a tick that he has listened 10 hours of training and everything is fine. But it is impossible, of course, to include this in charts. And now we return back to the question, who is going to do this? And in Latvia's situation, this is a very critical moment, this academic environment, and representatives of this academic environment. Because this little bit separateness from the system of justice has created a situation that in several aspects the representatives from academia are esteemed not very highly. They are lowly assessed, and we are not included in the constitution. We cannot say that we are constitutional institution, so we need a specific remuneration. But the state has to be aware that there should be somebody who is providing this education. Maybe we can turn to this discipleship, that a prosecutor of a higher range is training the one in lower. Okay, maybe this is possible, but this is not sustainable. So in lawyers education, there has to be a link between practitioners who provide this practical knowledge and also the persons who represent the academia. And this is also linked to the last aspect, and this is research. So without a high-quality research, we will not have a high-quality education, and neither we would have also the high-quality development of the sector. And here we are at the stage where we have to ask a question. Shall we have this high-quality research on national rights law? And next question, whether it's going to be in Latvian language and whether it's going to be independent. My first question was because looking at the system, none of the training manuals, monographies in Latvian do not provide anything for this chart where we just tick the box. So we don't see a lot of these training manuals. We see short articles in scientific journals, which is a good indicator, but there is no in-depth analysis. So the question is whether we will have this science if the justice sector wouldn't support our researchers saying that we need in-depth research at the national level. Next question, whether they're going to be in Latvian. It's also related to this because none of the international journals publish anything in Latvian. And this is also a question about our national self-respect. We want to keep Latvian language and also to develop this national science, which has always been a value. But right now we have a threat that it would lose. Yesterday, for example, we were talking in non-formal conversations with students that our teachers are reading students' work and they feel like that this is not Latvian language. It seems like this is a translation from English. And I'm not talking about plagiarism, but the fact that our young students don't think in Latvian. They don't have Latvian literature. They don't read. And here we get not only to the law, but also protecting our national interests. And the third issue which I raised was about independence. And now we see that existence of academia is endangered here. Of course, we are happy that a lot of our academia representatives become practitioners. Some become judges of institutional court, some go to the Supreme Court and so on, but we lose them. Most possibly they will have not enough time to spend time for the research. And recent years have proved it. And yeah, they have some articles, but they look at the jurisprudence. And there is no criticism, because who is going to criticize their colleague? And so we lose the independence of academia expertise. And why is it necessary to have a view from a side also for rule of courts? So I would return to what I said in the beginning, that each process, each reform can be good if it's done in a responsible way. Because we humans are the ones who rarely see our own mistakes. And we see our mistakes when somebody points at them. But if nobody points at some mistakes, if there is no analysis from a side, then we might get into the problems that the system doesn't see their mistakes by itself. So therefore, in the end, I would like to say that, yeah, we are all good at stating problems, but what to do? What are the solutions? So I believe the solution could be closer cooperation between the sector and academia, and not only that the sector expects results from the academia, and also talking about students, we cannot educate and get a practitioner if there is no possibilities for internship. And we have 26 weeks of internship for students, but the question is how practitioners are preparing those students and working with those students. So closer cooperation, not only expecting result and a product, but also supporting academic activities and also educational activities. If we as academia for a long time are not supported, that could pose quite a lot of problems. Thank you. Thank you, Christine. We see quite a few things we have to look at. I didn't also emphasize in my speech this extremely important side of this topic, research, and how our legal literature is evolving and developing, and how sure can we be about the quality, so that we don't just limit ourselves with some foreign foreign literature, but also to have high-quality literature in Latvian. And without research, the development is not possible, because this is the way how we see what works and what doesn't work. This is extremely important. But we also have to speak about lifelong education. If we look at this professional direction, this is also one of those future issues to be solved. And that will be solved in the context with the new approaches for continuous education and how it's organized. But about lifelong education, what we have and what we are striving for, I would like to ask Adria, Mrs. Adria, who is closely related to the judges' continuous education, and the same questions to Adria. So what do you think, where we are now, and what would be our goals we have to achieve, it's mandatory, and what has to be done today in order to achieve those goals? Yes, thank you very much to the organizers of this forum for this great idea, and also to the organizers for this opportunity to present and to be part of the discussion in this forum. Education and learning process, lifelong education, those comprehensive terms which are which became topical in Latvia in the 90s, in the last century, when we turned to the lifelong education. And continuing Laila Medena, who said one Latvian proverb, which was you sow what you sow, you reap. And I would also like to remind to the national participants and also foreign participants that we have another saying, which is you live your life and through all your life you learn. So those are very simple words, but all the essence is included. So this learning process. And so what is lifelong learning for a judge? So they start when they are about 30 years old. They need to have some experience and knowledge to become a judge. But this is just the beginning, and continuation is during all the career. So for several tens of years, continuous learning. And thinking about this process of learning and also being inside of it, I was trying to find answers to the question. So what was the beginning of judges' work, and what are requirements? What were the technical means, equipment? What was the training? And how they learned. Just a very simple reality. So when I started work, my judges' work tool was very innovative. It was a typing machine. Most of my colleagues were writing with a pen. Then next stage was a typing machine with a correction line. So you were able to erase the line which you had made, and you didn't need to rewrite all the page if there was something wrong. So that was the past. What do we have now? Right now you have a laptop. All the systems access, irrespectively of the place, location. Also e-cases, platform. In my office, 2 additional monitors which facilitate writing the judgments, and also that can be used in the work process. About the system of training, learning system. If we talk about systematic learning, we can speak about it since 1995, when the Training Center for Judges was created. And this is not a state institution. This is an establishment. And how the training was organized. There was a united program and periodic training, posting judges to these trainings with little choice what they want to study, and also the offer wasn't very wide. And the form of training was very traditional, a lecture, and we also had the international cooperation, German Stiftung, that provided the international cooperation. And imagine 2 judges a year had a chance to go to Germany for exchanging experience for 3 weeks. And that was an achievement. Today, what's our point of reference for today? Among our participants, we also have Solvita Kalniņa, who is a leader of the training center. And today, looking in the training information system, we can see that per 1 year and 7 months, we have had 200 events. And more than 100 of them were international events. The training forms were various lectures, webinars, working groups, practical training. Various acquiring legal languages, English, German, French, also various EU institutions and courts. We could speak about a lot facts, how it was and how it is now. But you would agree that it really shows our growth. And therefore, it's very complicated to ask today, what are the vision for the future? What are challenges for our continuous education? On the one side, this is the support from the state, There is a project about our institution becoming a state educational institution. Also, the Justice Council, one of their directions is development of continuous education for judges and other specialists. But I believe that the second part is even more important for today and also for the future. And this is awareness and understanding of a specific person, a lawyer, a judge, a prosecutor, their involvement and responsibility for this training process. And that cannot be achieved by some legislation or regulation. That can be achieved by the person themselves. Of course, we can stimulate and facilitate the environment, but nobody instead of this trainee would participate in this training and would really learn. So I believe that this forum is a good point of reference. I also wanted to highlight the role of the international experts, which is very important because we live under one roof of the EU system of justice. Of course, each of us in their own room, but and this view from another room can help us and to direct our way into the better dimension. And what I wanted to say as a conclusion and finalizing my remarks, when I was listening to Mr. Zilgal's vision and also the vision and ideas of the TILDE representative about future technologies, I don't think that this is something like impossible. In comparison with the situation when I went to Germany and in the court sitting, I saw how participant of the case was able to remotely get to know the case materials. It was 20 years ago, and for me it was like going into the space. Today we are in a totally different situation, different points of reference, but I believe that we will continue and we will approve what was mentioned yesterday by our president, Mr. Levits, to have this forum as a tradition, knowing that without looking into the past and without assessing the results, it's impossible to make steps towards the future. And I look at this as with big hopes. Yes, thank you very much, Adria. Adria, I heard what you said, that you look through the glasses of a judge, and that's, of course, normal. You're wearing judge's glasses right now. And right now, I'm looking at Jānis now. We also have the representative of the Bar Association. Like I said in the beginning, in ensuring justice, we have a lot of involved parties. The judge is not only one. Judge is the end stage. But one judge cannot fight against everything alone. There are a lot of participants in this. And for other participants, continuous education and professional preparedness is as important in order to get a good result that could give us this feeling of security and justice which we want. So, Jānis, the same question to you. What do you see? What do we have for now? And what would you like for us to do to have the better future tomorrow?
Also from my side, thank you to Mr. Minister for initiating the event. Thank you to the organizers for inviting me. We were sitting in the room and looking at the headline of our panel discussion, Critical Factors for Successful Change. I think that one of the critical factors and also a risk factor is change for own imagined goals. So we have to be innovative As Christine Schrader-Rosenberg mentioned, we should start with defining goals. There is a risk to get engaged in change for the sake of change, because change is initiated by the public development, by social processes creating the need for change. Then, if everything goes according to the plan, we can deal with the change and we can implement it. I was asked about how it is now and how it will be in future, but I will start how it was yesterday. What has changed in an attorney's work during the last 20 years? I've been discussing this question with other colleagues who have much longer experience than mine. So I could probably even look back to 30, 40 years ago. Most probably a person was sitting at a table with a typewriter, a telephone, a wired telephone with a dial, and a shelf with books. And what did attorney do? He was speaking to clients, reading case files, and going to the court to persuade judges that he is right. The essence has not changed during 40 years or even a longer period. Maybe now an attorney has a different design desk, has a big monitor or even several of them, has one or several smartphones instead of a wired telephone. An attorney is still speaking to clients, still reading documents, still going to the courtroom to persuade that he and his client is right. The essence has not changed. Tools have changed. Judgments were sometimes written by hand and later with a typewriter. All those are just technical details making our life easier. We can do more within a shorter period of time. We can do better things. During COVID times, we learned to use technologies which had been available for a longer period of time, but were not popular in the legal environment. We couldn't imagine we could just connect remotely to a courtroom. But it turns out it's possible and it's quite convenient, and I hope we keep to this routine. The essence will not change anyway. These changes were forced by social and other factors prevailing in the society. As regards artificial intelligence, since I graduated from university, I've known that something new is coming and changing our life. I have spoken to my older colleagues in Europe who say they've been hearing about it for 30 or 40 years. Nothing new has come changing the daily routine of lawyers totally. Okay, we use new gadgets, new devices, making our life more convenient. As regards artificial intelligence, colleagues from several countries were approaching our Estonian colleagues in a legal experts forum, and our Estonian colleagues thought for a while, and artificial intelligence, maybe it's speed cameras, so that's one demonstration of artificial intelligence, and another demonstration is entering data electronically to a file in small scope claims. Finally, a judge's ruling is still received. Well, maybe at some point of time we come to something else. There were also questions about education. Of course, education, lifelong learning is totally necessary. Nobody disputes it. Educational measures should be focused, targeted, accessible. But as regards lifelong learning, I wouldn't call it like a solution to everything, to all quality issues in any legal profession. It's not so that attorneys or prosecutors don't do a good job and we can buy more training and everything is resolved. Let's remember the limit of capability. Each person has his or her own limits of capability to analyze, to use, to do something. Of course, we can achieve improvement with lifelong learning, but most probably we will not solve all the problems. Then we have to speak about accepting new colleagues in any legal profession. Now it's so that a very complicated exam has to be passed to become a judge or an attorney, and most people don't pass it at the first attempt. The prosecutor's office has simplified their procedure a bit lately, but still there is a question about involving new colleagues. It's important for us to balance, to achieve a balance, because definitely each legal profession wants to attract the best ones. There are several universities in Latvia providing training of lawyers. And then the legal professions start competing for the new talents. And the range of new talents, it's quite limited. Not everybody can, not all the professions can attract the best ones. So we can we can define a very high threshold and define that we will only accept the best ones who are able to engage in lifelong learning. But the life sets its own rules, and this threshold should be balanced with the real situation to be able to choose the best ones from what's available. I would never say we should lower this threshold, but at the same time, the criteria should not be so high that most of applicants cannot comply with them, cannot satisfy with them. And so there is a question to all legal professions, how they can become attractive, sexy for new talents, so that young people would be willing to join those professions. Lawyers, it's not just conservative, stable with 100-year-old traditions. Those arguments cannot be used for attracting young people nowadays. We have to understand their psychology, their system of values, what's important for them, so that's remote working opportunities, an opportunity not to wear a suit and a tie every day. So there are thousands of details which may scare away young people from legal professions, and they choose to found their own companies and to deal with innovations. So legal professions, including attorneys, we have to understand young people, we have to understand what they are interested in to secure that the best ones apply for these professions and we can accommodate them. And then we have to take care of the lifelong learning. We have known remote training for a long time. It's not so that all the training processes were personal before COVID. At the same time, training of lawyers and higher education of lawyers was done personally because we thought that, well, some simple training can be provided online, but serious knowledge should be mastered in person so that there is direct communication with a professor. During COVID times, remote learning became the new normal. It's quite okay. It's possible to attend more training events. My observations as regards the quality, from the point of view of professors, everything is fine. Those classes are of high quality. They are interesting. But what's happening on the other side? I know that there have been remote trainings for attorneys. Also, the prosecutor's office has spent quite a lot of money for remote training opportunities. I think there are also better examples than what I've seen. But quite often, when an attorney goes to a prosecutor's office, this training can be seen somewhere in the background. So, and I get an answer, well, it's important that it's there in the background, and it's important that my name is registered there. It's just for the purpose of statistics that a high number of people have participated there. This is also a waste of resources when training is perceived in this way. So we have to return to the issue about the maximum limit of capabilities. One has to want to learn something. If there is no willingness, then this training is provide just background in the office, and it's not important whether it's a radio or it's a training. So I think I already exceeded my time. Thank you. Thank you, Jānis. As regards examples, yes, I have also participated in training where people find an opportunity to leave early. But if a person knows he or she needs this knowledge, well, then there is motivation, because otherwise you are just stealing from yourself at this moment. But this is quite characteristic for people. As soon as I get in a classroom, they feel like students, and it works also with adults. But this is what we have to think about. I'm afraid we are close to exhausting our time, but I would like to address Victor. He is well known to us. He is Deputy Director to the European Law Academy. He has huge experience in organizing international training. I know that the Academy has close cooperation with AGTN. They are very good long-term partners, and they provide training on the European law, on international law. Therefore, these are well-established international approaches to be able to implement the rule of law on the European level. Victor, you have heard what we were speaking about. What do you think? What would be important on the international level, on the European level, or maybe you have some observations or recommendations? And then I will ask Zintrach to conclude our discussion.
Thank you. Thank you for the invitation for this conference. I was wondering that 20 years ago it would be very awkward for a Minister of Justice to organize an international conference on justice where half of the speakers are from an international background or representing or coming from an international institution. But it's totally adequate now to do so, not only because we can learn from each other always, learning, sharing our experiences, but also because the European Union is a legal union. The European Union is a community of democratic values and a common legal culture based on rule of law. And in this European Union, the legal professionals, they have a very special role because they need to enforce EU law. Sometimes, if there is a collision between EU law and national law, they need to enforce EU law above the national law. So I can tell you, because I was a judge for 13 years in Hungary, it is sometimes very difficult to do that, but it is our role because we need to provide efficient remedies for the citizens. We need to provide the enforcement of the EU law for all litigating parties. That's why, because the legal professions are so important for the European Union, that's why the European Commission has a European judicial training strategy. And the last training strategy, which was introduced in 2021, and it's for 3 years, from 2021 to 2024, it has 3 pillars, 3 strategic aims. The first one is to promote the rule of law, because of course, not only in a few countries, but also it's widespread among member states that there is a general decreasing trust, public trust, and there are threats in some countries to rule of law, and that's why it's important for the European Commission to draw the attention with training, the attention to promote rule of law. The other strategic aim, the second one, is to uphold human rights. I was recently looking at a picture which was taken in 1952, where the founding fathers and founding mothers of the European coal and steel community were sitting in a very small room. And that reminded me that what was the whole aim of establishing this community? What was the aim? What were the roots? And the aim was to preserve peace. And the upholding human rights has something to do with peace, because if the citizens expect, the governments, the citizens expect the state to respect their human rights, in this case, this is the best way to avoid radicalization. This is the best way to preserve peace. And the third pillar of this European judicial training strategy, that was the digitalization. And of course, in some lucky situations, the decision makers can have a vision, can build up a strategy, can plan, and then enforce, can implement the plans. But in other situations, life is making us to react, and we don't have the chance to work on strategies, but we need to react immediately. And this is what happened in 2020, when because of the outbreak of the COVID pandemic. And one of the reactions was the digitalization, and we covered that by many speakers mentioned this, that this gave a huge boost for digitalization, not only the justice, but also digitalization of the judicial training, because one of the responses to this situation was to adopt online training methods, hybrid training, and the e-learnings or blended trainings, where part of the training doesn't need the presence of the participants. The other thing what we have learned, and the other thing that we needed to respond because of the COVID is the mobility. That there are a lot of cross-border procedures, and of course it's important that we realize that if not necessary, we don't need to summon a witness from 1,000 kilometers, because there is a cooperation between the member states. Moreover, there's not only a cooperation, but that's why the cross-border and cross-professional training is very important, because there should be a mutual recognition of all judicial decisions, and which is based on a mutual trust, and the training is supporting this mutual trust. Last, I would like to give you some good examples from Latvia and from the Academy of European Law, because as you mentioned, yes, we do have cooperations, not only one, but several cooperations with Latvia. The first one, we have an agreement with the Latvian court administrations, and with under the framework of this agreement, there were, since 2018, we organized 49 seminars for Latvian judges. Altogether, we had 2,419 participants. Of course, there are not so many judges in Latvia, but a lot of judges were taking several courses because these courses covered various parts of EU law. And even the pandemic did not stop us to continue with this, because after 2020, it continued online. Almost half of these seminars were implemented in an online format. Another agreement, because not only judges are important, but also the attorneys, the private lawyers. We also have an agreement with the Latvian Bar Association, and we are not only cooperating with EJTM, but we are also one of the founding members of EJTM. We're also member the Latvian General Prosecutor's Office and the Latvian Judicial Training Center, whom we also have a very flourishing cooperation. I think these are good examples how we can enhance mutual trust, how we can support the national judges of implementing correctly and on a high quality the EU law. Thank you.
Thank you, Victor. I'm glad to hear. I have also been among the lucky ones to participate in your events. And those are always very interesting events where people can share opinions and meet people whom they wouldn't meet in any other circumstances. Thank you. In conclusion, before the lunch break, I would like to give the floor to Dzintra, not so much as the deputy, as the judge of the Senate, but as a representative of the Judicial Council. And the last speaker always has a great opportunity because she has heard everything. I will ask a separate question to you. You deserve a separate question. What do you think? What we've been discussing here is a direction we see that we go together, move together for improving education and qualification. Of course, this system will be integrated. There will be the international dimension, which was presented by Victor. It will be important for judges, for prosecutors, for attorneys, and all of them will have to contribute to it. How do you see it? Will it be successful? Will we succeed? And from the technical point of view, what could be the technical solution? Because when we speak about innovation, yes, this will be an innovative system. Thank you very much. Thank you for inviting. Very glad to meet all of you. So I will try to be brief to comply with your fundamental right to have lunch. We cannot speak about technical solutions or technical innovations because, as it was emphasized here, the basis are the values, understanding, and a person. Because innovation, that's something new. And something new does not mean we have to reinvent the wheel. We can also look at our basic values at the roots and start from this. And actually, we have great roots. We have fantastic bases laid by founding our state. We have the values of our constitution, which are so much universal, that our innovation is to say how we are going to fulfill this at this moment according to the current situation. What has happened? What has the Judicial Council done? We have attempted to define, well, maybe it sounds very technical. This is annexed to the procedure of selection. These are competences to be possessed by an ideal judge. maybe not an ideal judge and an ideal lawyer, I would say, because it covers a broad range of competencies needed to be able to maintain the values, the rule of law, the democracy, so we can fulfill this as modern lawyers of today. And what is education? This is not a technical measure. This is a method to make those values living values and to bring them to people. And we can do it, and I hope and I believe we succeed that we do it jointly, because sometimes we say that Latvia is a small country. No, Latvia means everything to me. It's not small, maybe it's compact. And due to this compact nature, we have to work together. We have to involve everybody from academia, from practitioners. We have to work together with prosecutors and our European colleagues as well as society. And education should be the system tries to say it's becoming more open, but it has to be more open also in education. And education is not just the classic way when somebody comes, delivers a lecture, and that's it. Education, it's also training others. Judges have to be able to speak to the society, and they have to be able to train their colleagues and to cooperate with other sectors. So it's also interdisciplinary cooperation. That's the key to success: openness, cooperation, and the way we shape this leader of justice. It has to be a leader by himself or herself, able to develop own personality and to keep democracy alive. We have to practice democracy via education. And it's also very important if we look at the current external situation, we see what the risks are if a country has not been able to do it. So values, that's important, and education is a way to make those values live in people, and we have to bring them forward and to maintain them. And the new training center could be where all those components meet. Of course, we take the basis we have. We involve academic and professional experience and jointly form this value within a person. Thank you very much, Zintra. I was even trying to make some notes. A lawyer is a leader not only for others, but for himself. I think those are very true words. And I think those are golden words. We have a lot of gold in this room now, and this will help us to move ahead. And education is definitely what adds to our value. Dear colleagues, I cheated you because you will not have an opportunity to ask questions to our panelists, but you can use the lunch break for this. They are smiling. They are all very nice and great. Thank you to all of you, and they deserve applause by us. Thank you. Thank you also to Ilona Kronberger for being a great moderator. Now we have a lunch break, and after lunch we will have another discussion panel. And I will repeat the saying about being intolerant to intolerance, and then we will speak about the Ukrainian war, the war crimes, the sanction mechanisms, but this is all coming after the lunch break. Let's meet in an hour.
Sveicināt visiem! Mums vēl ir 5 minūtes līdz sākumam.
We still have 5 minutes until we recommence the last stage and the most topical of our discussion.
In 5 minutes. Cienējamie fóruma dalībnieki,
Dear participants of the forum, we are ready to continue and recommence with the most topical issue and question, speaking about today, about Ukraine. Every day war crimes are being committed there, and they are noted there on some mechanisms of sanction, prosecution of war crimes and sanction mechanisms to restore legal order in Ukraine. Many issues, many unanswered issues, and I believe that this panel will be able to be as a leader and come up with new solutions as to how to move forward, speaking about meeting sanctions, confiscation of assets for rebuilding Ukraine. And the panel leader is going to be Mr. Jānis Bordāns, our Deputy Prime Minister and Minister of Justice, as well as Denis Maļuska, Minister of Justice in Ukraine, Katrīna Kaktiņa, who is the representative of the Republic of Latvia, an ambassador in United Nations, OSCE, Juris Rubenis, the Prosecutor General of Analytic Department, Edgars Pasters, Finance Association of Latvia, and then Andrew Adams, Lecture Capture Task Force Director, as well as Gabija Brigaita Daugir, the Vice Minister of Justice from Lithuania, as well as Ineta Ziemele will join us online. She's a judge at the Court of Justice of the European Union. Let us start and let us give the floor to His Excellency, Mr. Minister. Hello, everyone.
Everybody feels comfortable after our lunch and after such, I would say, interesting and fruitful discussion. For lawyers, it's not very typically, by the way, I think there were sometimes we thought that we are thinking still standardized and still looking for and talking for our just for lawyers interesting things, but I believe that if people from outside, and I hope there will be lots of them who are listening us, they will be surprised that lawyers are thinking about, and we'll try just to make a little bit, so I'm not hearing a translation, that lawyers are talking about issues which are absolutely topical for us, and also we discussed about challenges. And thank you, Mr. Reders. You also named all our panelists for this panel discussion, and almost all of them I know personally, shorter or longer time. And what is I would like to mention that it's truly my honor to be with all the panelists, because each of them are really experts and professionals as lawyers, as professionals in their daily work and positions. And I also have to say that all of them are the persons with highest moral values, and they represent that. This is very important because we are talking about not simple. We will talk and speak and discuss not only about simple one crime or theory on international laws or theory about criminal offenses, but now we have to switch to largest criminal offense that is going on right now, which is in long term, more than 100 days, and soon, unfortunately, it's closing to 200 days of each day crime of international, so offense of international law, and crime against individuals, crime against civilians. And our aim is to find out really practical, not in theory, but practical solution, how to not less than how to stop this crime, how to stop the war, and that would be also would be my question to firstly to my colleague, distinguished my guest, Denis Malyuska, Minister of Justice of Ukraine. And I will not maybe myself comment about international laws, about difficulties that we met in our ministry when we tried to find out solution what we could offer for international law, for possible ways how to seize, freeze, and finally expropriate or confiscate property of offenders. But maybe you could start and of course to say first of all what you see, what you think, what is most important, how you could frame this discussion, how you could see what is most important issue today for Ukraine, for Ukrainian nation, and for international society. Please, Denis.
Thank you. Well, it's hard to describe everything during a couple of minutes. It will require a couple of days, but just a general overview. During the first days of the full-scale invasion, I felt like I was completely irrelevant, and the whole ministry is irrelevant, since there is a huge power, a country member of UN Security Council, nuclear power, a country with the second powerful army, as was perceived at that time, using only brutal force, and the perception was that the brutal force could be met only with brutal force. So that was a difficult feeling, and understanding that the law could do nothing to address that problem. But after some time, when Russians significantly failed on their military front, and expectations their expectations were not fulfilled, that was a sea change. Then after that, a number of different legal avenues appeared how to address the attack of aggressor, and I became even more optimistic when during negotiations, short, but nevertheless, there were negotiations with Russia. We made several announcements about that. I was a part of it. And it appeared that legal matters, our legal attacks against Russia, mattered even not less than all other issues which were put on the table. So they are afraid of that. And after that, I realized, okay, we really matter. We will need to be even more proactive and move forward. So what we have on the table right now? First, different courts, mostly as international bodies, like, for instance, European Court for Human Rights, or others where there are already applications and claims against Russia. The problem is those litigations are long-term. To litigate there and get any meaningful result will take many years. And by saying meaningful result, I mean something which could be felt and understood only by lawyers, since ordinary citizen won't feel anything when we will win in any European or international court under jurisdiction of UN, except for simple satisfaction that we won the case. Then there are some ways to punish Russian officials as war criminals, which looks more attractive since there will be a tangible result. It would be hard to enforce any possible verdicts until there is a regime change in Russia or they are completely destroyed. So, because we are not talking about the Germany after the Second World War, it's a completely different story. And in that case, we also realize that that will take time, and also that existing framework is not sufficient. For instance, ICC does not cover crime of aggression, the most obvious crime committed by Russia, where there is plenty of evidence everywhere, even online, in order to prove the crime of aggression. There is even no need to collect paper-based documents or evidence. Everything is online. Putin's decrees, his speeches, everything is there, but there is no court. ICC does not have jurisdiction over the case since Russia and nationals committed the crime and their country did not ratify Rome Statute. The only crime requiring ratification of the Rome Statute is aggression, unfortunately. So in order to address that, we will need to create a separate international tribunal with all the difficulties related to that process, particularly given that we would need to create a tribunal without the decision of the Security Council of UN, given that Russia is a member of Security Council. So that would need to be a historical event, first event in the history, when such a tribunal could be and will be created without the decision of major powers. Another avenue, which is most popular and which provides short-term result, fast result, is sanctions. There were many waves of sanctions on the side of EU and other countries. Those sanctions were helpful in terms of communicating the position of our allies, of our partners. They had personal interests of many oligarchs and powerful figures inside Russia, but if we assess whether they were effective and efficient in terms of stopping the war, then we would have mixed feelings. First of all, if we talk about economic dimension, the price of oil and natural gas soared. It's sky high. The revenues of Russia from selling those natural gas and oil increased after the invasion. So that's why sometimes in their media they are joking that this is a self-financing war, a war which brings profits sufficient to cover military expenses, which is a dramatic situation and shows the need to tackle and adapt sanctions so that the economic consequences would be sufficient so that they feel that this is serious. And my understanding that the plans announced by EU about putting some maximum prices for oil, natural gas, and other commodities sold by Russia, this might be a good idea. But still, we need something efficient which could work short term. That's why we asked best lawyers throughout the world. Not all of them, of course, not all best lawyers could be covered, but still there were many volunteers from prominent law firms, major universities, academia, expert community, suggesting their assistance to Ukrainian government. So we asked them, please provide us assessments on each particular jurisdiction, how to get Russian money and how to get access to those funding, how to take those money away from Russia. Since we know that there are hundreds of billions of US dollars on the bank accounts and hundreds of millions of billions of US dollars belonging to Russia state, not private individuals. The answer, the feedback from those lawyers was, well, you know, in each jurisdiction, there are barriers, and given that those assets are protected by sovereign immunity, internal laws, national laws would not suffice to get access to those assets. The only possible solution for all jurisdictions was conclusion of international treaty. International treaty, on one hand, lifting sovereign immunity over the funds of the aggressor state, reserves of the central bank, and on the other hand, creating a framework, a fund for distributing funds. Fund governed internationally by international community, like it happened, or like it's happening in UN Administrative Commission, or framework similar to Iran-US Claims Commission. So that is kind of good solution, but it existed only in the air and did not materialize during the last months until I had a discussion with Yanis. So that, like, good partners of ours, Latvia, Ministry of Justice, suggested that let's start with us. We are ready to support you to negotiate a treaty and show example to other countries that this is doable and worth trying and worth to implement, which is wonderful idea. We announced today that we will start negotiations about the wording, really fast negotiations, to have the treaty signed and offer together the other states, please join. Join this framework which is developed by legal community, which is new, innovative, but at the same time, which could provide real assistance and real result right now. So that is sort of a news from Riga, and tangible result of our meetings and discussions, and tangible results of this forum, which we are grateful for, and we will be even more grateful after we sign and ratify. Our parliaments will ratify this treaty. But anyway, this doesn't change that we shall focus on other tools as well to pursue criminal investigations, both nationally and on international level, by investigating actions of Russian forces by team of ICC prosecutor's office, and by joint investigation team joined by our partners. We are also grateful for those countries who sent us their experts and their forensics experts, for instance, since they show to their governments, international community, that we are not inventing anything on the territory of Ukraine. Bucha really happened. French forensics experts were everywhere. They examined all bodies, all the consequences of torture, of humiliation, of murders there, and we have internationally recognized proof. It's not only our experts, our people, Ukrainian employees of different state bodies confirm that. It is internationally confirmed. That happened, and that shall have consequences. Our people dying each day, not only military, only today, during this event, Russia attacked Vinnytsia, a center of one region which was considered to be peaceful, meaning that it is far from the front. They sent their rockets right in the center of the city. 20 people died, 3 kids died. That happened this morning. It even somehow touched Ministry of Justice, since one of the premises which was destroyed belonged to the local office of the Ministry of Justice of Ukraine. Several our employees shell-shocked, but still it's better than to be dead. So my message and request is, help us please to address that. Lawyers matter. And indeed, we need weapon, we need political and diplomatic support, but also we need legal support, and that matters based on the reaction of Russians. They are afraid of legal intervention and legal consequences. They know that Putin will die sooner or later, and rather sooner, or he will be put in jail. But others who are young, they will face consequences and responsibility. They do care about that. They don't want to end up in Hague. So the message right now that if you do not stop, you will be there, and we already prepared a good cell for you, is a good message. That will work. Thanks. Sorry, I have to excuse myself. I need to go to an urgent phone call with my president, and well, we try to get back to listen to the end of the panel. Sorry.
So thank you, Denis, and say some good words to your president, who is really our hero, and send him our greetings. It was interesting. I know one of my friend has family from Vinnytsia in Lapmešciemš. They are living, and we were in a few weeks ago with them, and there were one pretty good guys, boys, played in the garden. And I asked and helped to work everything. They were very like ready to help and ready to work as usual, as all Ukrainians I know. And they just asked, so where are you from? Which part? And he told Vinnytsia, and now we heard. So this is how close to us is. How close to us are criminals, how close to us and to our families all this happened. But also now I switch to my professional, like to me as to lawyer, and I have in public office I have worked only as minister. I'm sorry to say, all other time I was even attorney at law or just a private lawyer or worked as company lawyer. And what I see is like I feel this like feeling like we have to hunt. So, but situation is you are 100% right. Your client or you are 100% suffered violence, damage, and by all means. But there are no laws and there are no institutions that can help. And thanks to all, governments of many countries, and especially countries who are leading in helping to Ukraine and helping to ourselves. Those countries, I would say, are Baltic countries, United States of America, United Kingdom, and we could say also some other countries. Will not name and I will not shame anybody, but United States Justice Department, our colleagues, immediately after starting the war, created a special task force. United States Justice Department understood, and Attorney General himself understood that existing international rules doesn't help enough to Ukraine and to all people of Ukraine and all to international law, and that we need to look for some special actions, and also as lawyers are looking what we can freeze from the opposite side, how we can act. We just understand that we have to find out reasonable action, we have to find out solution, and that solution must be also legal. And therefore, I turn to our colleague and our panelist, Andrew Adams, who is a director and head of this special task force with excellent, I think, excellent name of this task force, like shot in the 100%. It's a klepto capture task force. Mr. Adams, please.
Thank you, thank you, sir, and thank you to everyone in attendance today. Minister Bogdan, it's a true honor to be invited to this panel and to this forum in Riga today. And to your point just now, action and how to take action has been the theme of our task force since its inception. I'll also say he's stepped out for important business, of course, but it is humbling to share a dais with Minister Malyushka. He and his team, the prosecutors in Ukraine, are working under incredibly difficult circumstances. When we talk to them, they're frequently in far-flung places. They're flying around the world looking for options, looking for assistance, and thinking creatively about the best way to serve their country. And they are a true inspiration for us on the other side of the Atlantic. So to provide a little context for my presence here today, and to give a bit of a preview about what I hope to talk about, I'm going to give a bit of some background on the task force that I'm heading, its scope and its mission, some of the hurdles and challenges, and our approach to meeting those challenges. It's to give a little bit of context to what we're doing in the United States, which at its core is really, in my view, a demonstration of the scope and the power of the US and our partners' sanctions regimes, our export control regimes, a demonstration of the power of nations committed to the rule of law when they work in lockstep, and a demonstration of our strict adherence to the concepts of due process and fundamental rights, which give us the moral authority to take aggressive and robust action in support of Ukraine and in support of the rule of law. So the task force has two essential missions that we talk about. The first is a relatively short-term, immediate mission, and that is to take any criminal action, to take any asset forfeiture theory, and to bring it to bear on the individuals and the entities who are listed on the United States Treasury sanctions list. What I mean by any charge and any theory is literal. We're not limited in this respect to evasion of US sanctions. We're not limited to money laundering in order to evade US sanctions. We are approaching this with an all tools to hand approach. If the charge available is a bank fraud, a wire fraud, a visa fraud, if it's any kind of criminal activity, we will bring the charge and we'll support it through the task force. The idea here is, to the extent possible, to effect the disruption of criminal networks, to effect the disgorgement of tainted property and proceeds, and to effect the discomfort of the individuals who have supported the Kremlin for many years in its illegal activity in Ukraine. The second principal mission for the task force is to take a broader view, a more long-term view of what we in the United States can do to undermine what we refer to as facilitators. We think of money launderers, people who support illegal smuggling networks that will evade export control regimes, procurement networks. And in this task is broader in one sense, insofar as the people that we are looking at go well beyond the specific people and entities listed by our Treasury Department or on the EU sanctions list. And in another sense, it's more narrow. We are, as a task force, focused squarely on evasion of the US-Russian sanctions and evasion of our export control regimes. In the second mission, we are reliant on cooperation And at the same time, we ask some very hard and aggressive questions of people in the private sector. We are looking very closely at the banking sector, insurance companies, key commodities brokers, securities dealers, cryptocurrency exchanges, and the like. And the notion here is really to leave no stone unturned and to not let it be tolerated if a company or if an entity turns a blind eye to the movement, in particular of US dollars, in support of the sanctioned class. In both of these functions, the task force really approaches this problem not through the lens of what we in the United States would call white-collar crime. That is, we do not accept the notion that sanctions evasion and money laundering is a relatively sterile, regulatory, or victimless crime. Rather, the approach that we have taken and that we will continue to take is to view these problem sets through the lens of organized crime. Sophisticated, opaque networks dedicated to the exploitation of democratic principles, the exploitation of democratic societies and the security that they offer, dedicated to violence and attacks on the institutions that undergird our democratic societies. Practically speaking, what does it mean for us to think about this through the lens of organized crime? It means confronting targets directly. It means investigating and confronting employees of these entities, family members and facilitators, meeting them with subpoenas, search warrants in very public ways, and making public statements as quickly and publicly as possible about the findings of our investigation, so that the public will see with the stamp of the United States the work and the investigation that has gone into uncovering otherwise illicit financial networks. To show that work and to show our success and our adherence to due process and the rule of law in meeting those successes. It means thinking critically, and it does mean thinking as prosecutors creatively about the opportunities that exist within our legal code and the opportunities that exist in our partners' legal regimes. These are impossible goals to achieve without international cooperation. It's the case that up until February of this year, the United States had had a sanctions regime in place targeting many of the sanctioned individuals who exist today, but that was a regime that was misaligned with some of our closest partners. There has been, as Minister Belushka said, a sea change in that respect. And in the last 4 months, the alignment of our sanctions regimes has entirely changed what we in the United States are capable of achieving abroad in cooperation with our partners here in the EU, in the UK, and truly around the world, even in pockets of the world that may have previously been viewed as safe havens for illicit money and illicit finance. One way in which we've also met that success is by having a unified task force, the task force that I'm overseeing in the United States, comprised of investigators, comprised of attorneys, and comprised of linguists and analysts who are focused on this problem in a unified way. That is, drawing on resources from disparate parts of the US government. So members of my task force include attorneys from our National Security Division, include attorneys from our Criminal Division, our Money Laundering section. We draw on resources from our Intelligence Division, from our Treasury Department, from our State Department, in ways that in normal days was extremely difficult. That is no small task to corral so many disparate agencies across such a large government. I know that's a challenge in Europe as well. We've met with great success by having a dedicated task force devoted to this issue. And the success has been palpable in both the short term and I think as we will see in the mid to long term. We have at this point made some fairly public seizures of ostentatious wealth in the form of large yachts, airplanes, bank accounts across the world. And none of that would have been possible without our partners across the world, and in particular, our partners in the European Union. It is, I think, fitting that we are here in Riga today, 300 kilometers or so from the Russian border, where the government here, its prosecutor general, its Ministry of Justice, its finance supervisors and the like, have played a vital role in that cooperation and in that demonstration of the power of the rule of law when it's brought to bear on such a massive problem. Without that alignment, without that support, the US cannot act effectively. We rely on partners. We rely on partners for the collection of information, for the collection of records, for the building of our own cases, and ultimately, we rely on our partners for action. And today, with the wind at our back, so to speak, and with an unprecedented unanimity among our international partners across borders at a particularly critical moment in history, it is of the utmost importance, I think, that we take this opportunity to unify, to continue to move forward, and specifically to take action in support of Ukraine. Thank you, Minister.
Thank you, Andrew. So there were mentioned different aspects of our issues and cooperate, and I would just mention a few of them, and you will see how all other speakers on our panelists are connected to some of them, and then I will decide who could talk better as next. But and there were one issue was that was created task force, the form how to address to make address on challenges and to look for solution of challenges is to create special task force. But one task force cannot solve all problems. Task force participants and this personalities has to cooperate, and you have partners, including other United States agencies, international agencies, and other governments. Also, that you need the experts and the specialists who can trace the money flows, and banking experts, insurance experts. So full scale of all of this operation, and also next issue is that professional investigators, and so we can name even more of them. And now I would like to and we have really those experts in our panel. But I would like to hear and give the floor to Lithuanian Vice Minister of Justice of Lithuania, Ms. Gabija Grigaitė-Daugirde, and to see this international aspect of cooperation as international, as a representative of public office and representative of partner of United States and partner Ukraine, and something similar to what Ministry of Justice is doing. And so please, Mr. Grigaitė-Daugirde, how you could respond on it, and also I would like to thank you in your person to all Lithuanians, friends, and Lithuanian Ministry of Justice. I know that you are one of the most active assistant and supporter of Ukraine and in all this situation. You first, together with Ukraine and Poland, created a joint investigation team, which is similar to task force. And I just looking if EU could create also our response of klepto capture task force. But please floor is yours, and how you could respond and how you see that from your experience and your ministry's experience.
Thank you. So, first of all, understanding that on Sunday we have International Criminal Justice Day, I would like really to say a big thank you to organizers and to all the staff that were involved in organizing this extraordinary event in Riga, and of course for the topic of the panel that we have today. Because only by showing constant support to Ukraine and doing all we can truly bring peace, justice and security back to Europe. And answering to the question how we do it or why do we support, because we were not only the ones that established a joint investigation team, we were the first one to refer the situation to the International Criminal Court. And how did we succeed? Because myself, I am international public law lawyer, and together with a motivated minister that I have the honor to work with, we truly believe that actually international law solutions, they do exist. And they will never fail if states and politicians do not allow them to fail. And I think that from the guidelines that were offered for the speakers, there were some truly interesting issues raised. For example, what is the role of Geneva Conventions and how what is the meaning or the influence they have today? Or for example, if non-direct support, there was one of the issue, if non-direct support of the war can be considered as a war crime. And lastly, of course, the most important question, whether actually all the means against the aggressor state Russia are already used or there is something that can be done more. So answering a little bit on the role of the Geneva Convention and trying to come back to the things that I have mentioned is that international law will not fail if the states do not allow it to fail. So the role of Geneva Conventions is very important for two reasons. If we talk about individual criminal responsibility. First, these conventions, they explicitly recognized individual criminal responsibility of persons who commit or order commission of serious international humanitarian law violations. And secondly, what is even more important, they established the possibility of universal jurisdiction. And as you perfectly know, universal jurisdiction is that it means that a state, actually all the states, have a duty to prosecute or punish war criminals, as we call it, without having any jurisdictional link. And the rationale, the legal rationale behind this principle is very clear, is that certain war crimes, for example, the ones that we see now being committed in Ukraine, like deliberately attacking civilian objects with the aim just to spread the terror among civilian population, and they are that harmful to international interest that states even have obligation to start criminal proceedings regardless of the location of the crime and the nationality of the perpetrator or even the victim. So understanding this, Lithuania already on the third day when the war started, we instituted this pretrial investigation on account of war crimes, crimes against humanity, and even crime of aggression. And all these investigations were based on universal jurisdiction. But still, there are EU member states who do not have possibility of universal jurisdiction in the national legal systems. So if we understand that possibility is there in international law, all you need a national political will, a national political effort to make sure that you make an effort towards bringing justice to Ukrainians and actually starting investigations, national investigations, towards the war crimes being committed, because you never know, someday you even can have that person in your hands. But we should bear in mind that all these investigations on the basis of universal jurisdiction, they raise a lot of practical and evidence collection challenges. So that is why the role of Eurojust, with its renewed mandate, plays a very important role, and not only by having ability to collect and store the evidence, to secure them from being damaged and being destroyed. And not only it is important for supporting this joint investigation team, but it is really important for sharing those evidence with national jurisdictions that have started national criminal investigations on the basis of universal jurisdiction. Because only by sharing evidence, only by sharing best practices that we have, and most importantly, what my colleague has said, by acting together on these critically important issues, especially if we understand that the time will come when we have to enforce the judgments being adopted in absentia. And there is also another legal challenge that we have here, because I don't know whether you have heard, but Lithuania had problems in enforcement of judgment that was delivered for the international crime, but was delivered in absentia, and we issued the European arrest warrant, and national court from Greece, they refused to enforce it, saying that if it is in absentia, you have constant right to appeal, so it is not enforceable judgment. So if we understand that we might be very successful in having the judgment, but we also have to think how we are going to enforce it in the future. But at the same time, we should not forget that it is not only about individual criminal responsibility, because in Geneva Conventions, we have very good formulation allowing us to raise the issue of state responsibility also. Because in Common Article 1 of Geneva Convention, it does not only oblige parties to an armed conflict to respect the law, it also imposes a very clear obligation for states to ensure respect for the Geneva Conventions. And if I may quote International Court of Justice, that has stated that it is not just a stylistic clause that is devoid of any real legal weight, but it is a norm firmly anchored in customary law and entailing obligation for every state. So what is the idea that I'm having behind it is that in practice, the obligation to ensure to respect is not limited only to behavior by parties to a conflict, but it includes the requirement that states do all in the power to ensure that international humanitarian law is respected universally. And that means we can talk about spectrum of practical measures that states can adopt individually or collectively. We can have sanctions here, or we can even have establishment of an ad hoc tribunal. And I believe, and I hope that all panelists share the same idea, is that legal obligation to respect and ensure respect for international humanitarian law should go beyond any political considerations. And that is why, this is just my personal opinion, if we talk about financing the aggressor state, while at the same time understanding clearly that it has not only breached the fundamental international law rules related to the prohibition of the use of force, but it is in constant breach of fundamental humanitarian law rules by performing these non-discriminate attacks on civilians and civilian infrastructure, it indeed could be considered as being incompatible with the obligation clearly established in Geneva Conventions. So I will not touch in more details on the special tribunal because I think that Minister Maluska explained very clearly that we do also, Lithuania shares the same idea, that the gap for impunity is still there because in the conference that was organized by Ministry of Justice of Lithuania in the beginning of May, we had outstanding international public lawyers from United Kingdom, from Netherlands, and we all agreed that International Criminal Court could be the best solution, but not for the Russia of today. Because for the Russia of today, the court clearly does not have jurisdiction. And if our generation wants to give hope of peace for future generations, we have to understand that we have to have the mechanism to make sure that Russian political and military leadership that planned and committed the crime of aggression, they should be held accountable under the rules of international law. So being politicians or working with politicians, we should constantly promote establishment of a special tribunal. And the start could be, for example, setting the interim prosecution office that could start working, at least what Minister Maluska also said, on the evidence that are more than obvious. Because to prove a crime of aggression, we do not need that hard, I would say, evidentiary efforts, because we have plenty of public material, we have public statements, we have public different statements in the newspapers and internet, and this is leadership crimes, so the evidentiary level or what is necessary to prove, it's much easier thing than if we talk about war crimes to be proved. So yes, the other possibility, of course, that we still have some challenges about implementing is what do we do with frozen property, and we are still looking for the legal answers or legal mechanism, because we do believe that the fastest and easiest way to do that would be a horizontal EU decision on that, leaving no doubts because we understand that member states, they did freeze these assets implementing sanctions that were imposed by European Union. So we understand that, separate member states would have legal, obstacles in making individual decisions what we do with these assets and property. So that is why we do believe that a clear legal ground adopted by the EU could be the best solution. So to conclude, I also would like to refer to the statement that you, dear Minister, said yesterday during the dinner, that future of justice is uncertain. I do believe that it is certain if we have courage and we have the right people to use the solutions that international law gives us. Because searches for justice, it always takes time, as much as it takes our efforts, but these solutions, they do exist, and we just must use it. And at the same time, if the rules that we have, they protect the aggressor more than they can afford justice to the victim, leaders, because today we talk about what justice leaders should do. So I think that leaders should have always to find courage and motivation to change the law, to have a chance, and to have the new rules. So thank you. I'm sorry I was a little bit too long.
Thank you, Gabi. There is nothing to say sorry. That was great words, and I several times did hear that you mentioned the word courage, fear not. And you need national politician will. And that's is 100% also my opinion. And by the way, I have to offer to all our guests and visitors, and also to Latvians once more, to go to the corner of in Riga, not far away from here, Brīvības Boulevard and Tarbatas Street, in front of Riga's district court, second instance court. With help of our lawyers, judges, and assistance with our ministry, we have created a memorial and let's say statue. I would say memorial to one of the famous our leader during occupation period. The same occupation that are trying to do again Russians in Ukraine, and it is on behalf of Gunārs Astra, and the name of this sculpture who made this memorial, Oleg Glebs Panteleyevs, and he named this informally and formally named this sculpture as "Fear Not." And that is very important. And I know in this hall, maybe not physically and directly, but still, I would say with our technologies physically, there are one of the Latvian justice leader, Ineta Ziemele, who also have helped very, very bravely and helped very much to this period of challenges and changes, and they helped with assistance, with practical promotion of important legal ideas, legal solutions, and all assistance. And I would ask now to say her opinion to Ineta Ziemele, who is a judge at the Court of Justice of the European Union, and just a few months ago, chairman of Constitutional Court of Latvia, and also I would name many the titles, which are all important titles in Latvia and in Europe. Ineta Ziemele, please, floor is yours, and how you could respond to the issue.
Yes, good afternoon, everyone, and greetings from Luxembourg. And my apologies that due to the court schedule, I cannot be with you, although I wished to be there very much. And congratulations to the Latvian Minister of Justice for this very important initiative. Because for the leaders working in the justice field, I think it was a high time, in fact, to come together and to discuss the challenges that we see today for law. And this was high time, even without the difficult situation that we are facing today in Europe. Now, I will indeed make a few points, and I do thank the previous speakers for already sharing the experiences, but also I noted directions in which to go, and some of what I will say will underline and will highlight what has been said before, but I will also try to maybe suggest where one should go forward. Now, the first point that I would like to make is that we should, and as we do, all feel and know the war that the Russian Federation has waged against Ukraine, against its independence, sovereignty, and territorial integrity, has submitted international legal order to a major stress control. And this war has submitted our values, rule of law, democracy, human rights, to a challenge that we have not had since World War II. At the same time, I think today more than ever before, it is very clear that we must stop the violations taking place as we speak in Ukraine, on its territory, against its people. And we simply have no other choice but not to allow impunity. And I will explain why, and pick on some of the points that were mentioned. Now, the next point that I would like to really underline, and the Vice Minister of Lithuania said it very eloquently, but just to really add to that, I think we have to know today that international law has never been as complete as it is today. Now, naturally, there are we live by the concepts such as jurisdiction, such as immunity, such as ratification of a treaty or not. There is a reason for all these concepts, and of course they organize international legal relations. Now, we also should know that there has been, since World War II, since the creation of the United Nations, there has always been a tendency, if one mechanism didn't work, we couldn't agree, then we simply created another almost parallel mechanism. So there are actually plenty of mechanisms of international law available for all sorts of nuances. And I would want to say that we have maybe lost ourselves a little bit as lawyers and as decision makers in lots of legal details and lots of sort of fine-tuning. You see that also within the European Union law, for example. We have also gotten simply used to this comfort of living in rule of law states, in democracies, where in the end of the day, independent courts actually enforce our individual human rights. We have had outside Europe constantly hot points. We have had civil wars and beyond, but somehow for Europeans, at least for many of them, this has been rather far away, and it is therefore that we have not really sought that enforcing responsibility wherever the issue of responsibility around the planet arises, one day will be an important issue for Europe as well. And so it is what we are living right now within the context of the major stress control of our international legal order is that all of our baggage from before is with us today. And those in the ministries and the prosecutors' offices and international institutions working with the matter on how to ensure responsibility, how to stop violations of the UN Charter. Actually, what you are living with every day is also all of the difficulties that we have inherited, in fact, from the 20th century, both the difficulties of political nature, but also some difficulties within the legal instruments that we have. We have to realize that the war against Ukraine actually has brought up what we as international lawyers, we know that there have been any number of ups and downs and achievements and not so great achievements. However, the next point I will make, and that's on the imperative task to ensure responsibility of those leaders of the Russian Federation who actually decided to violate the very core of international legal order. The reason why we must arrive at effective mechanisms is the following. We have, for rule of law states that are gathered today in Riga, it is absolutely impossible and impermissible to allow that a rule of law might happen to be violated. It was already mentioned that it is for this reason, this is a particularly critical moment in the human history. And what is actually put at stake, it is really the credibility of international law, the credibility of international legal order. That's what we are. And it's not just, it's not a question for Ukraine. It's not even a question for Europe only. The credibility of international law is the worldwide matter. And I think that has to be, put forward. And there have to be an engagement with all continents, in fact, who are also suffering because of this war. And so this is the reason why I am saying, and I have been saying it also to the colleagues in Latvia, that we are in an extraordinary situation. And it is this extraordinary situation that actually allows us and requires to look at the legal institutes that we know, such as immunity, such as, the new kind of enforcement mechanisms for state and individual responsibility and for acquiring reparations for rebuilding Ukraine. I mean, the extraordinarity of our situation and what the stakes are, that's the future of the planet, how we are going to live forward. That really requires all of the lawyers in the room to, in fact, depart what we know from the 20th century sort of practice and legal studies, and to look at legal institutes with different eyes. And I'll just remind you, I mean, the Nuremberg Tribunal was created as it worked. And it is unfortunately that we are in that type of situation. Now, and I'm coming to rather quickly to the end of my remarks. Now, I will remind you that the main principle that was the very purpose, the very philosophy, and the very legal basis of the Nuremberg Tribunal was the principle of justice. And the principle of justice is a real principle, and we apply it non-stop in all of the courts that I have worked so far. The principle of justice is the basis and the reason, the paradigm that we use in adjudicating the cases. And I think this is the principle that should be in the center of all of the solutions that are being now put in place and sort of further developed. Now, the idea that I also wanted to propose comes back to what was, and I was very glad to hear that already mentioned before, And that's the need, in fact. It's not just an idea. We absolutely need to have in every state a task force, an interdisciplinary task force that not only has at a national level ministries of justice and foreign affairs and the finance and the prosecutor's office that sort of concretizes the position of each state on the matters of individual and state responsibility, on the matters of confiscation, nationalization of the properties concerned, or the actives and concerned and the passives concerned. But we need these task forces in all of the peace-loving states, and we could hopefully still count 141 as per General Assembly vote. And these task forces actually need to build a global coordination so that we would urgently implement what has been now for 2 months or more already in the air, the mechanisms to hold the aggressor responsible. That is the only reply that a rule of law and peace-loving states of the world can and should offer in these circumstances. Now, the task force in each state, the coordination platform, I think is something that urgently needs to be put in place, because indeed it's a bit dispersed, it's a bit chaotic. Now, the reason I am saying that we are, in my estimate, right now working a little bit against the time, because the time is really a difficult issue. The legal mechanisms, the procedures to be engaged have to be used much more actively. There was a moment at the beginning of the war when taking out the Ukraine question from Security Council was exactly what was needed, and that worked well. And somehow we have not come back to the General Assembly with another look whether the resolution has been implemented, whether we need to go to the International Court of Justice for the advisory opinion, whether General Assembly should pass a resolution supporting the formation of the hybrid tribunal, because we need to ensure the legitimacy, what the scope of the competence should be, because there are several options, and I would think one of the options should also be the matter of reparations for Ukraine. So there are a number of concrete decisions, joint decisions to be taken, which need to be by now pulled together and coordinated and in fact executed. Given the rhetoric that I heard over the last days coming from the state which is engaged in violating international law these days, I could discern that the moves in strengthening the mechanisms against impunity are feared and are not clearly very much appreciated. And that is an indication that this is exactly what needs to be done right now. So I can only invite those justice leaders that are in the position of taking relevant political decisions that it has to be done now, fast and jointly. And I thank you for your attention.
Thank you very much. Thank you. So, indeed, I think if we respond, what could be some remarks after our forum, then one of it would be mentioned that in each country, not in one country, not in only in the European Union, we need to create such a task force on interdisciplinary basis. And that's the fact, because there are not only not tensions, but disputes and divided work between, let's say, Ministry of Justice and Ministry of Foreign Affairs, and who is responsible for that. But generally, in governments, it would be responsible Prime Minister, and also would be responsible also the parliaments as well. Because the issue is very similar to sometimes to other also national challenges. You have laws, but you don't have enforcement implemented, and then is the issue why you don't have such enforcement. And then answers what can be very different. If either the government hasn't created such enforcement agency, either we don't have professionals, either it is technical problems, and so on. But one fact and outcome is, of course, what Ms. Ziemel told us: the principle of justice exists, and principle of justice has been violated. And I just can remind that principle of justice were violated in Latvia since 1940 until 1990, 50 years. Latvia and as well Lithuania and Estonia was occupied, and still until now we don't have received this justification. And if we talk about restoration of truth, restoration of also countries, then I have to say, little bit with the proud, I can say that Latvians and also Lithuanians, we restored our countries, at least we're trying to restore by ourselves. But that's also that's a difference, as with there are kind of difference. Ukraine now, particularly at the war, and this destroy amount of what is destroyed here in Ukraine is huge. And there are if we talk regarding to enforcement, so we need to enforce, we need to get evidences, and we need to trace money of criminals and so on. I think in that moment, with very good input, we could hear from specialist and good lawyer in different aspects. But one of the latest specialization of Edgars Pastars is to be a senior lawyer in Finance Association in Latvia. So finance law and finance practice. So I would say practitioner with great the letter Edgars Pastars. Please, floor is yours, Edgar.
Thank you. So you're hearing me well. First of all, I'd like to praise the organizers for having such a great event. So you will be seeing on the screen, at least I see it on the one screen, as we live in the screen age. I also prepared one slide, so it'd be good to put it on the, I don't know which screen, but at least this, the big screen, thank you. But before going to this topic, is, you know, when you're looking at the PowerPoint slide, people's hearing sense increases at least twofold. So that's why we are like using PowerPoint so to structure discussion. So, but before going to those practical details, I was like looking at this picture there, the man overlooking all of us, Peter the Great. If I'm not mistaken, he looks to me sad and ashamed of what the country he tried to westernize does now in Ukraine. So at least it was my associations looking at the picture right away. So speaking of sanctions, we know that sanctions regime is intended to deter aggressor, in this case Russia. We have also other programs concerning other countries like Iran, Venezuela, and others. But here we talk about Russia. But also sanctions can be considered not only as a deterrent, but also sort of a weapon of war. So this is a way how we, all of us, can fight the war and stop the aggressor. And of course, when it comes to aggressor, he most probably will hide, he will disguise, he will fight back. It means he tries to evade sanctions. And there's several techniques how sanctions can be evaded. So we have to know them all, to be prepared and fight back in order for sanctions to work, deter the aggressor. I think that we have not only legal obligation, also as individuals, but also moral obligation to enforce sanctions in the most strict way. And in my opinion, it also includes applying not only EU sanctions, but US sanctions as well. As you probably know, Latvia is the only EU country written an obligation in our laws that US sanctions, at least partially, are enforceable here by law, not just by a risk-based approach. What Latvia has done in 3 or 4 years, it is getting more resilient to Russian money and influence what comes with that. And we are good at knowing techniques how they evade sanctions and what we should do to make sanctions work. We did our homework. We got rid of those non-resident deposits. So I think at this moment we are ready to fight this war in sanctions front as we have never been ready before. I won't go to sanctions, the birds and the bees, just maybe, as Mr. Minister pointed out, some lawyers are quite confused when the discussion on sanctions starts, especially when you show them, especially the corporate lawyers, when you show how OFAC aggregate or cascade principle works, how you calculate all those numbers, who is controlling what, and how this 50% rule works. Sometimes they look like deer in the headlights, and still they don't understand the thing. And the thing with lawyers, and I urge all of my colleagues, lawyers here, not to apply this lawful but awful approach. We have to see the economic reason, the economic background of some behavior of some rogue actors. And one of the sanctions evasion techniques, I wanted this technique to share my thoughts about this technique, is called sham divestment, and why it is important in my view. Because this method gives you a pretense of legality, of normality. Then the company previously owned by some oligarch with 60% or 70% shares, then this person usually sells those shares to some shell entity, isolation company, or some related person, or some unknown individual, and states, okay, I don't own 50% anymore. And this means this company I own, or a list of companies, a chain of companies, they are not considered sanctions. Please do cooperate with us, transact with us. You know what I see, that in many European countries this actually works. And people say, yeah, this company is not sanctioned anymore. And this is the most dangerous thing. Why? Because those companies are quite huge companies, large corporates, trading in natural resources and even agriculture goods. So therefore, we need clear guidance from our local authorities as well as from the EU that sham divestment is something we won't tolerate, and we will recognize the sanctions evasion. Why some lawyers are so confused when they see something? They see a document, mostly issued in Russia, that this person is not a shareholder anymore or doesn't hold more than 50% of shares. However, control is still there. They're confused because they tend to believe the written document, and they are afraid what the court might say about this, especially when they need to terminate the contract with this entity based on this information. So the guidance from state institutions on this specific sanctions evasion technique should be more detailed and vocal. Now, if you Google it, you won't find a lot, maybe 2 or 3 pages. On OFAC, 4 or 2 questions, I think, and ACAMS materials explaining this, not others. So from my point of view, those should be 3 criteria should be met to say that it is not sham divestment. It's a transparent deal with an entity not related to the sanctioned entity, and this should be supervised by some competent authority outside of Russia. If those criteria aren't met, I would say that's an evasion. The evasion which is punishable by law, criminal law, which my colleague most probably will reflect on later. So some other points on the governance. You mentioned task force, that we need a task force to coordinate efforts. It's not only war crimes we need something like this. For example, in the United States, you have OFAC, single institution responsible for governance and also for doing settlements, imposing fines, and so on. In the EU, every member state is responsible separately for the enforcement of sanctions. And you know, this is something we see as a divergence across the EU. Something which is sanctioned in Estonia won't be in Latvia or vice versa. So we see something like this shouldn't be in place in the EU. We need one institution responsible for sanctions enforcement in the EU. Many people advocate for more criminal liability here when it comes to sanctions evasion or breach of sanctions. I'm not that person. I would say that we need more monetary fines, because now some businesses, they find themselves in breach of sanctions. And they did it in good faith. The regulation says if you acted in good faith, you shall not be held liable. But if there's no clear policy in the particular member state, you don't know that. You disclose that you have breached the sanctions, you are committing to do anything what's necessary for you to become more resilient, to spread culture of compliance. But at some point you find yourself in jail for transporting 3 bottles of champagne to Russia in 300 euros to 900 euros. So it shouldn't be the case where criminal law should apply. It should be applied for more severe cases, but monetary fines and making firms to build their own compliance programs, more resilient programs should be the goal here, not putting someone in jail. No one will gain from this. If you want the best task force in the world, the best task force is private sector. If private sector has enough information and guidance, they will report and stop sanctions evasions at the root when they are born. Training, we need more specific training on sanctions. In Europe, you can't find a lot of them. I think in Latvia it's only ACAMS providing this training course, and it's quite expensive, but worth to take. Others I haven't seen. Access to information is important. So every task force which makes information available to private sector is necessary. For example, beneficial owner registry. Here in Latvia, we have done excellent job, and thanks to the Ministry of Justice, we are one of the leaders of the most transparent beneficial owners registry, available to everyone, but it's not the case with other countries. Try to access, sorry Cyprus for saying this, Cyprus corporate register or British Virgin Islands corporate register. Try this. You won't be able to find the thing but you want there. Even if you try to use ADAS regulation to identify yourself. So we need more information available to businesses, let them work, and require them to build compliance programs. And of course, any task force made by state institutions, investigative journalists, and other enthusiasts, this might help to do proper due diligence. Now we are seeing, in my practice as well, it's quite hard to get information about who is doing what in Russia at the moment. Investigative journalism is dead, effectively dead there. Due to sanctions, they can't even access some information. They are adapting their web pages in a way that if you are visiting them from Latvia or from European Union, some parts of the web page just disappear, especially when it comes to shareholders. And the documents, you can't believe them, because as Vincent pointed out quite correctly, it's a kleptocratic state. Everything can be adjusted if oligarch is benefiting from this. So therefore, my point is more guidance to private sector, more information, and let the private sector to enforce sanctions and be smart. There's no use for some member of the board in jail. It's more use from this person when he builds a resilient compliance program. That's for me. Thank you.
Thank you very much. I think this is one of example how private sector, public sector has to cooperate with private sector and forget about the differences, but use each effectiveness of each sector. And the private sector definitely is very, very effective in implementation of anything that is created by public sector. So that's kind of logically because that's there in the private sector we can see how our laws that we have wrote on public sector, how this effectively or ineffectively works. Because those criminals and war supporters and war creators, so they are hiding their assets, they are using most effective tools, and only all together. So can function, of course, public, which creates, which holds registers, which creates institutions and also regulations, and together with private sector that can also be very effective. And one of example is what Mr. Maluska told us in the very beginning, that they cooperate, that they work with the best lawyers in the world, with private lawyers of international law, and they are creating advice and wise advice for the state, for all of us. And then I would like to turn also to, is it called the sector or not? Maybe I'm mistaken, but Katrina Kaktiņa represents also an institution, international institution, and Ms. Kaktiņa is ambassador of Latvia to the UN, OSCE, and the international organizations in Vienna. I think this opinion and this point of view would be very important and interesting for us. Please, floor is yours.
Thank you, and I can also join others in thanking for organizing this conference. This is actually a very active day internationally for these issues we are discussing, because in addition to this conference in Riga, as you know, there is a meeting in The Hague where experts are discussing on the establishment of the special tribunal. And also in OSCE today, as we speak, exactly as we speak, a new report is being presented on war crimes and crimes against humanity committed in Ukraine this spring. And you mentioned the various organizations in Vienna where I represent Latvia, and of course in all of them, the Russian war against Ukraine is having its place on their agendas, but I will concentrate on OSCE, which is an organization of 57 member states, including Russia. And probably it's the only forum, international forum, where we meet Russian representatives every week without a pause, also since the war escalated in Ukraine, and sometimes even more than once a week. And of course, there is this question on why, what's the point, what is the reason to speaking with them every week, and also saying our positions, obviously. And then the question I asked back is, what if we didn't do anything? What if we kept quiet? What if we didn't say them that we actually know what is going on? in Ukraine, despite their disinformation and propaganda that we obviously also hear every week for hours. I think it's important for all sides that, because first what we see in OSCE is the Russian isolation. They're alone. No one else is speaking for them. When they say their position, their narrative, they are the only ones. And around 40 states every week, not always the same ones, but around 40 states speak for Ukraine and against the Russian narratives. And I think that's maybe one way how we also contribute, which is our step, our drop to stop this war. Because the message that we give, another very important thing, is that there will be no impunity. That there will be accountability for each and everyone involved in war crimes in Ukraine, including the diplomats in Vienna who so ferociously defend those war crimes every week. And since they hear our statements, they will never be able to say, we didn't know. We didn't know what was going on. We were lied to, because they do know. And one of the first statements I gave in the end of February had a sentence in it that some say that Russian war criminals will go to hell, but I believe before they go to hell, they will go to The Hague. And I'm very happy to be today in the audience where everyone believes that, and I still strongly believe that they will go to The Hague, The Hague being the word encompassing accountability in any kind of court or tribunal. And one of the things that OSCE is doing for this to happen is the OSCE's Moscow mechanism. Ironically, it's called Moscow mechanism because it was established in the early 90s in Moscow. But it is a mechanism where internationally recognized experts gather evidence, make a fact-finding mission that will later be used by either existing or any future courts or tribunals. So, as also was mentioned by some other speakers today, while we are discussing some gaps that we might have, that international law might have, and tribunals that we still have to establish, we are already doing our part. We are already using the tools that we have, and the evidence is being gathered as we speak, and it is very, very important. And in this, it's also important for, once again, for the Russian state and their diplomats to see that this is happening, that we, as I also have pointed out to them, we already have much more evidence of what has happened, what you have done in, together with Belarus, let's not forget that as well, in Ukraine than we did in the same circumstances 80, 85 years ago. And it's important for them also to see those comparisons with the 20th century and understand that until anyone involved in Russian war crimes is alive, they will be chased for, because we will not tire until the last Russian war criminal is sentenced. So for the whole of their lives, they will have to fear that or be ready for that. And on the question of whether international rules-based order is destroyed by Russians, also my answer, just like by my colleagues previously, would be it hasn't, it's still there. Russia has violated it, of course. Russia has breached it, but the force does not create new rules. And we know and we hear in international society that there are states, there are representatives who are ready to talk about maybe creating new rules, maybe creating new system, because maybe the one that we had was not working properly. And maybe if we find the right rules, then Russia would abide by them, would it? Because if those rules have worked for us, for the rest of us, and are still working for us, and are still good for the rest of us, the international rules-based order has not been destroyed, it's still there, and we have to protect it. And we very well know that it's not, the problem is not in the rules, the problem is in the will to implement them. And another example of why we obviously believe that international rules are still there is that we are here discussing legal ways to confiscate proceeds of sanctioned persons and the best legal ways to prosecute. As Minister of Justice Bordaan said in the beginning, it has to be legal. So this is another proof that we do believe that international rules-based order is still there. And the question about whether war crimes are the same and whether the law of the 20th century is still valid and still can help us, looking at the Moscow Mechanism report, there have been 2 reports already this spring. One was presented in April, another one presented today. Both of them are a proof that actually the laws of 20th century do work. They're still valid. They're very much useful, meaning Geneva Conventions already mentioned, also Genocide Convention. We can very well already now conclude that genocide is being committed in Ukraine and that international humanitarian law and human rights law is being breached. So these laws are still very much in force. Should we do something else, and what? And of course, it's very difficult, as we also spoke before in this panel, to go with the law against the brutal warfare. Because at some point, as the Minister of Ukraine has said, it might feel that we are not on a level, on the same level in the field. But I do believe that we do use successfully the tools we already have. And if we determine that there are some gaps and we need to do something more, we have to create. And what I usually also comment on this is that these are unprecedented times and we need unprecedented reactions and unprecedented measures, and we just have to look at our Ukrainian colleagues and take their courage and be courageous. I will also repeat the message of courage, because Ukraine is courageous in the battlefield, but we have to be courageous in the legal field. Thank you.
Thank you. Thank you for also that good pointed expressions, as you mentioned now, about different battlefields. Lawyers, of course, we are fighters and we are on battlefields all the way. And one more expression I know from you at the moment. So I knew where Russian warship has to go, but now I know where Russian criminals has to go before they are going to hell. So they have to go to Hague. That's very important. Maybe I would prefer even if they would go directly, but before that we have to seize their assets and restore Ukraine. And how to fight with oligarchs, and how to fight with oligarchs without support of government, without support of heads of prosecutors' office, how to fight with oligarchs without support even state president, and how to support with oligarchs until United States decision about sanctioning of those oligarchs, and until another government is coming to enforce and helping and assisting. All those matters is very well known to, last but not least, our speaker, Juris Juris. And prosecutor Juris Juris were, how to say correctly, decorated maybe by United States State Department and honored as Man of the Year. It was last year, yes, I think, as champion of the world of anti-corruption. And please, Juris, if you could respond about, I suppose so, you would like to say words about enforcement issues, but if you have said and have ideas on any other matters, please, floor is yours.
Thank you, Mr. Minister. I would like to add first express my gratitude for the opportunity to be here, but now I would like to discuss the question related to the types of separate sanctions, their enforcement, their efficiency. And it must be said, this question is important in practical dimension. I just want to say, maybe I would start with a rhetoric question, which is, how do we think, all of us, what is the dimension of the sanctions? What is the character of the sanctions? i.e., is it related to, does it deter, does it force them, or does it, can we avoid the aggression on the sovereign state altogether? But now from the legal dimension, we all think like, probably would all vote that sanctions are a deterrence instrument, deterring from any negative activity directed towards as an aggression against sovereign state. But if we look at the practical dimension, then unfortunately we can also identify that separate sanction framework dimension makes us think that they are just prolonging their activities, like making their activities longer as a duration. And now looking at all the panelists and all the colleagues we have here, and the name of the panel we have, this is like the frame now running around. It is a dynamic frame. You see it behind me on the screen. There's a dynamic frame running around the text. But I want to say that we shouldn't draw or pull the sanctions into the dimension of very narrow, undynamic perspective when we do not know what is the way out anymore. And this is when we speak about sanctions like financial sector sanctions, or another type is, sometimes we call it some everyday life, household sanctions, products, services, and their control. And it is crucially important to understand that the supply, especially especially talking in the context of sanctions, is more like a deterrence, because we do not have the final stage. What happens next when the sanctions are already in place? We legally say they have reached the objective because we have assets being frozen, but what is the final ultimate effect, whether it does prevent completely from the aggression? Then, well, I must say, in separate cases, you just might think, deterring is in a way just interim problem creation or inconvenience, because in the long term there is still hope they have to get their assets back. They say, well, just store it, you will have some expenses related. But I don't think this is the correct way. This is the correct way we should be going. And this is why I think we need to be discussing, and we shouldn't be setting the very tight frame of sanctions, administrative, civil, law, but just quasi-cross justice fields, which allows us to go from one point. We say we have frozen the assets, but let us go further, and now we can confiscate, we can seize, and not once in this forum we have already spoken about the rule of law and restoration of justice, not only by stopping the aggression, but also by actively directing the funds to the needs, to the satisfaction of the needs of Ukraine, for the renewal of Ukraine, and they have a lot of such needs, and we need this war to stop as quickly as possible, and we need to think about renewal, restoration of Ukraine's economy. One more thing I would like to note is, if we are very strict on the framework, on criminal justice, administrative justice, sanctions, we are also talking about the fact that the aggressor state, they would even see it as beneficial to them, because we do restrict ourselves in the activities which we can use regarding the seizure, the confiscation, and then directing the funds to Ukraine. I want to note also that today, as we speak, how to be efficient, how to be more effective with our sanction regimes, how to implement these measures. I think that so many oligarchs currently think that actually they are thinking at the same time how to avoid, how to evade the legally imposed sanctions. And this is why I think that with the help of such, with the mediation of such forum, to send a message to the aggressor state that Latvia, alongside other states, not only the European Union states, has never been and nor will it be tolerant towards the aggression, active, further, not confiscation and not directing of the funds to Ukraine. So, in brief, my message is that the states which I just mentioned are zero tolerance states in relation to funding of aggression. Practically speaking, about the sanction issue, we can look at it in various dimensions, including the financial sector and this everyday life, household dimension. And if we talk about financial sector, then one of the most topical challenges currently we face, not only in the aspect of sanctions, but also in other, like, for example, fiscal violations and criminal activity, it means that they want to go away from the control mechanisms, like the new technologies we just spoke in the other panel. They have gone so far that the persons, including the sanctioned ones, are going away from, ever more, from the traditional finance sector using the traditional means. So now they use alternative platforms, cryptocurrencies, friendly to aggressor legislations. And now it is actually also in classic examples also used. So they choose now ever more sophisticated mechanisms which go further away from our capabilities and our methods, how we can find, identify the assets we want to freeze, and where we're actually heading, we want to seize them. So there are several solutions. Really, I will not invent anything new. International cooperation dimension, especially in financial intelligence, that is very topical. But not only, because there are other types of intelligence too, conducted by institutions we are not talking about loudly and not so much, but this is one of the efficient ways that can help us now in the dynamic times and environment when we see that the technology allows the perpetrators to go away from, or the sanctioned persons to go away from the classic or common, convenient, conventional financial sector. So we keep forgetting that we are going deeper and deeper into financial investigation aspect. And we need those tying this all to the practical things. So one of the examples which, and I mentioned also before, so using the non-friendly legislation. So now, currently the investigation says that even if we tried from the non-friendly jurisdictions to get, for example, information on the ultimate beneficiary, then we would most probably receive a negative response, because in these legislations, in these countries, you can just brutally counterfeit a document on an official level, send to Latvia such evidence that would actually prove that a sanctioned person simply doesn't have any relation to the subject of our interest. And Mr. Pastors also said that, indicated this problem internationally. So such cooperation is actually a dead end, but not a support. And one more addition I would like to say about the practical steps we need to take is that we do need to remember that in the modern technology times, it is ever more difficult to catch a sanctioned active flow, the beginning of this flow, but always we must try to catch the final moment of it, the end of it, because financial assets, other assets, and evasion of sanctions, and in other examples also, if we have some, for example, mixing of legal, illegal assets, we have seen with financial assets that sooner or later they do have a tendency to return to the ultimate beneficiary. And this is why this is the final stage we need to identify. And finally, I would like to draw your attention to when in this context I was talking about the two types of sanctions regarding the financial sector and the household type, then let's say not every entrepreneur which had tried in the territory of Latvia to import a sanctioned product here, it is not actually, not all of them had the intention to do so. So explaining the people about these issues also poses another challenge. How do we explain what kind of scope of products, when the regime starts working, etc.? Because we need to be thinking about those entrepreneurs that even if they make a mistake, we just need to show them, and they will not make them in the future. Thank you.
Thank you, Juris. So one more discovery, that money sooner or later returns to the owner, but I would also add that the justice wins, and it's worth to have this victory during our life. And now I will use an opportunity, and this is a great moment when we could also involve other experts, not only those who are sitting in the panel discussion, but the experts that are participating and sitting in the hall. And I would encourage to ask either questions or provide your comments. We can do it, and we must do it, because we still have more questions than answers. And yeah, I understand that the challenge is great and huge. But the same as the army of Russia is still attacking and killing people, and the lawyers of the world also haven't had the victory in their battlefield. And this battlefield is in each of us, also here in this hall. And this is a challenge for you. So please, your questions and comments. And here you get the mic.
Analysts for your excellent presentations. But I have one question to Minister of Justice from Ukraine. All your friends, Latvia, Baltic states, EU, United States of America, we are doing a lot in order to support you. We have introduced sanctions against Russia, we supply weapons, we cooperate with International Criminal Court, so and so. But you, as said, Minister of Justice of Latvia, still war goes on. So from point of view Ukraine, what still you wait from us? How can you help to stop this war and take war criminals to some international tribunal? What would be your suggestions for us? What could we do better and more?
Thank you. Well, actually, you are doing much more than we even expected. So we are really grateful for that and really appreciate. I do not know really any other country who shared such a huge share of their own military equipment, weapon, other equipment necessary so that we could resist both from military perspective and humanitarian one. So we really appreciate that assistance, and the only major ask on our side would be to keep doing that. So for instance, today we agreed to work on a treaty. Let's continue, let's make it real, let's sign it, let's ratify it, and let's together lobby, have the same tool in other countries, so there is a success at the end of the road. Let's work on other sanctions. You have significant comparative advantage to us. You are a member of EU. You participate in all their bodies with decision-making voice. Of course, our voice is also vocal right now. Zelensky's messages are everywhere. He is everywhere. He is respected and quite influential leader right now. But at the same time, from the view of formal authority and formal decision-making process, you have other benefits. You have the voice, you have the right to vote within the EU, which is important to us. So you help us a lot right now. Please do that further on. That decision, what could be a turning point right now to stop the war? It's not within your powers. Assistance from other countries might help. More weapons from US and other countries, that might help. If you see the results of the last supply of weapons, HIMARS, or HIMARS, I don't know how it reads, they are quite efficient, meaning that we could stop, and we stopped actually for the couple of days Russians advanced. We destroyed their major points of commands and their warehouses with weapons. The result were quite significant. More weapons like that, and they won't have any chance to move further on the ground. We still don't really know what to do with the rockets, since to fight that and destroy them would be a major challenge, since now they moved from simply firing one rocket or two, they now start firing 10 rockets at the same time, which makes it difficult to catch them all. And that's why they are terrorizing our country and our cities throughout the country without any exceptions. And they are ready to continue that and do that in decades further on. So the recipe to continue doing that, to push for further actions, the road ahead is simple and well discussed. The major challenge is that international community is becoming more braver and more prepared for radical moves only within, but requires some time to do that. It's like gradual support, increasing support. But if such a level of the support was from the very beginning of invasion or even before the invasion, that would be a game changer. If we have such weapons as we have right now, I doubt that, or rather not doubt, but Putin would have thought twice before starting such an invasion. He wasn't that sure like he started the first time in the first place. So please continue, please help us as you do. You are great partners of ours. Thanks.
Paldies. Vēl jautājumi, lūdzu.
Some more questions?
Both ministers, you mentioned the eventual mutual agreement between Latvia and Ukraine in order to create some legal framework to confiscate frozen Russian assets as a main goal. How could it work, and do you believe it could come some kind of common ground or common basis for common approach of European Union and other countries?
Yes, so as we discussed, as also was discussed there, that there exist different tools and different international laws and principles how to get restitution of violated international rights. And one of the tool, one of the vehicle is if we create mutual system of mutual agreements, countries each by other, and then through those agreement system we can restore first of all the violation, and also we can reach and we can get the assets, because as we discussed here, the main assets, those are billions of dollars and euros, are allocated somewhere in Europe. And the governments can freeze and can also act and seize those assets. That's with assistance of that kind of agreement system. But, and somebody has to be first to initiate, because those discussions about a possible solution of concluding agreements with Ukraine, there were existed quite long time, but there we need to have courage to somehow start to go and for this. That would be my comment, and maybe a colleague could add as well.
Thanks for your question. I would like to emphasize two major parts of the future mechanism. First one is that how that will look like. The answer is it's going to be a bit similar to what happened with reserves of Afghanistan and Venezuela, which have been firstly blocked by US and then transferred not to other countries, so this is quite different story, but the access to those money from so-called governments of those countries was blocked, and the money became administered in the other way. In case of Afghanistan, in the interests of Afghan people, but not as a money of the government. So those cases were when the government lost control and could not spend, and someone else was spending those money, but those money remained within the interests of that particular country. In our case, we propose to move further and not to keep the money for Russia, but to pay compensation instead of Russia. So that is a technical difference. It moves, it's a more advanced tool, but similar to already existing events in two countries and administration of reserves in the US. And the mechanism, most probably, if we agree, would have also another more significant part. We are not asking only to lift sovereign immunity over the assets, but we also suggest how the money will be distributed, which is an important part. We show the way. Of course, it's not that significant topic right now, but before the war, it was on the agenda of EU and other countries, the issue of corruption in Ukraine. We do not hide anything. There was an issue, maybe there is an issue right now. That's why from the very beginning, to escape from any accusations, any even hints on any sort of possible corruption or whatever misuse of funds, from the very beginning, we want to include in the treaty provision that the fund will be internationally governed by international organizations and our foreign partners, countries who will send those money and lift immunity and create the fund. So Ukraine is not willing to control the fund or distribute those funds. Those shall be internationally recognized instruments and mechanisms to distribute money to those who suffered, got damages, lost families, houses, apartments, whatever. So there is a trust to that mechanism from the very beginning. So those are two major parts of future framework. We will develop it in more detail, and the idea is to make the instrument multilateral. So the start with Latvia would be only to show the example, to offer others to join, whether with another bilateral agreement or to join existing agreement with Latvia to make it multilateral. We'll discuss that further, but that is also important technical detail. But the message is important. You ask what to do, also just one detail more. Please let this initiative be known to other countries within the EU. That is important. If we have counterparts, partners, lawyers within the local legal community, please share this idea, this concept, because on the political level, our president, our prime minister, they keep repeating this idea to other heads of the government and countries, but what those other heads of countries and governments do, they ask their own ministers of justice or other trusted lawyers. And my task would be also, so when they ask, those ministers are in the loop. They know what we are talking about, what are the tools, what are the consequences, and what are the messages. Since now in the world, there are two types of ministers of finance. There are ministers of finance who support this idea, and there are ministers of finance who say, well, you know, we would like to do that, but there is no legal mechanism for that. We suggest this legal mechanism. Here the proposal, it shall be known to anyone, and we shall have substantive discussions, but not just answers, there is no legal mechanisms. Thanks.
Thank you. Do you have anything to add? Other panelists for this issue? If no, yep.
Dear panelists, today, so far I have heard like a couple of news that even deserve the title of breaking news. And I'm very happy to be part and witnessing how it happens. First is this bilateral treaty that literally opens the door and invites other European countries to follow. And I believe all the peace-loving citizens of Europe are really looking forward when it actually happens and frozen assets get liquefied into money and money goes to Ukraine. But there was a second also idea, and Judge Ziemel even mentioned it 3 times, and Minister Bordans, and of course our honored guest, Mr. Adams. It's about task force. And regarding the task force, we all know that the power of United States already lets it to implement sanctions and chasing criminals without any specific task force. Its legal system and institutions are already in place. And yet, government of the United States decided to create a special task force and assign a very prolific and with high results prosecutor to lead it. And here we heard that there should be similar task forces around Europe. But my question to you, and it's first of all to Mr. Adams and then to Minister and the Judge Ziemele, perhaps in the European Union also there should be a unified body of a task force, perhaps a task force supreme that would coordinate the individual efforts of each European country. So therefore there could be a possibility of, for instance, at the beginning, two equal task forces, one in the United States, one in European Union. It brings a lot of perspective and ease of coordination and effective and fast application of these investigation procedures and actual capturing of things. And would it actually be possible to have a unified task force in European Union, and what would be the benefits or risks? And could you please, Mr. Adams, start with your opinion?
Thank you. It's hard for me, certainly, as an outsider, to comment on what's possible under European law, and I won't even attempt it. But what I will speak to is the benefit that we in the United States have had, and to the extent that we can provide some sort of analog to think about how this these procedures and these bodies might be structured. I can offer some thoughts on that. In the United States, keep in mind, it is a single federal government, but the way that our prosecutions work are actually distributed across all 50 states. There are, in the United States, roughly 96 U.S. attorneys' offices who, for the last many years, have been working relatively independently on this problem set. The major benefit from having a single point of contact and a single task force has been to funnel information, to funnel efforts and resources, to help prioritize cases across 96 different U.S. attorneys' offices. And it's simply not a possibility without having some sort of dedicated task force to hand. That has been a major point of success from the U.S. perspective in our own country.
My response would be, I have seen in public offices sometimes there are like tendency to rely on existing regulations and dividing of functions of different institutions. Let's say, look on the Ministry of Foreign Affairs is written down this responsibility, Ministry of Justice the another. Partially they are cover each other. And then there are Prosecutor General and then Prosecutor Office, which has some ties with the Ministry of Justice, but generally, according to our dividing of powers, it's a very separate institution. And what we finally got, if there is just ordinary life, it's functioning. But my opinion is when there are the crises and when there are existing just one very special issue, which is so out of order issue first priority, highest priority, issue of catastrophe solving issues, then there are two solutions. If we want not to fail, there are two solutions. Either Prime Minister takes the responsibility and say, I am responsible for that, I'm taking on myself that responsibility, and so working with all institutions, regulates them, supervises, giving orders, and controlling and waiting for responses. And then everybody also knows that to whom to turn in any questions, so Prime Minister. That's one issue. It's not typically in Latvia. We still are working like in peace times. Ministry of Defense is working with obtaining the weapons. Ministry of Foreign Affairs with sanction issues. In some stage, Ministry of Justice doing their responsibility with registers and different. And then it's my opinion, we lost focus. So who is one responsible? And I would suggest to create a task force. It could be the decision of a cabinet of ministers or prime minister. So and just decide there is one who is directly responsible. That could work better. Because I'm not like positive that for each and any project, each and any issue, we will need to create different task force, because then we have our ministries. Yes, correct question would be. But this is the war against all the world. And this is the special issue. And the same, it would be also on European Union level as well. That would be one of decision and issue. I think, therefore, we would reach solutions and options for solutions faster, and we would act faster. And the question of time during the war, in wartime, it's very essential one. It's the one of priority, timing. Thank you.
Thank you. Ineta Ziemele.
Yeah, thank you. Many thanks for the question, because I think we have been losing a momentum a little bit. And in view of the fact, what I just already said, we have actually many opportunities, I mean, many roads to go in countering this aggression. And it is for this reason, because there are so many mechanisms and choices to make, and each state would have its own sort of, because of the traditions, because of the available competence, would have its own maybe preferences in order not to lose time and in order to really have focused joint decisions within the European Union. I think it is extremely important now that, for example, Latvia and the Minister of Justice of Ukraine, in fact, invited, exactly in answering to Professor Gras's question, invited to do so. And Latvia can be the country, the member of the European Union, who actually, with its own example, as Minister just suggested, invites the relevant institutions of the European Union to actually, form such a common. It's a coordination mechanism. It's a policy mechanism, and European Union has plenty of institutions and plenty of experience of cooperation, coordination. We have a new prosecutor's office. Eurojust was just mentioned, and not to mention the council meetings, etc. The fact is that, as the minister just said, we are still in a peacetime thinking, slightly unfortunately. But we really need to realize that the challenge to the world order is huge, which requires also extraordinary organizational sort of measures at the EU level, and we see that. And there is one state, one vote, like it is in international law, and Latvia can indeed, and Lithuania as well, could be the states that put forward this initiative to have a more mobile, more operative coordination center exactly for the best choices to be pursued, either on the bilateral agreement, hopefully to become multilateral agreement. By the way, I can say, I can tell quickly, it is a very valid idea to pursue. And you can also get inspiration from UN Claims Commission, which in fact addressed Iraq's invasion into Kuwait, where the funds were collected from Iraq for the civilians, Kuwaiti civilians and legal persons who were ruined by that invasion. So there are many examples in state practice that can inspire the solutions, but what really needs to be done is to bring together, at least at the regional level and then hopefully at the broader level, to bring together these states that, let's say 27, say, yes, that's exactly what we're going to pursue. And in that way, it is much more powerful and much more effective, and we don't lose time. So it is absolutely doable at an EU level, and Latvia could be the initiator.
Paldies, thank you. More questions, remarks? Lūdzu.
If I may add to what I already told, we need to brace for another impact, which will probably take place in autumn. Those are companies controlled by sanctioned persons, registered here locally in Latvia. They are employing hundreds, or employed hundreds of people, so they most probably will go insolvent. We need some guidance of how this insolvency procedure, liquidation procedure, will take place. What will we do with assets? What kind of authorizations from competent authorities we need to obtain? Because we have like 10 or more competent authorities who, honestly speaking, don't know what they are competent of. So that's why I'm advocating for one single authority. So we have a lot of housekeeping work to do locally, and the task force should not only be about what you speak about. It's important, war crimes, confiscating the frozen assets, but also about stopping Russia's economic enhancement, what is taking place now. And it is helping businesses to understand who is the bad guy and who is the good guy, who is hiding, who is playing hide and seek, and help to find this person who is hiding. And then you will gain more assets to freeze and most probably confiscate later on. The autumn most probably will bring some news about a way of solvency for those companies, and we need to know how to do this properly, because we haven't been there yet. Maybe some other countries have been there, we haven't.
Okay, thank you. We have 5 minutes left in this forum. So, Mr. Bordans, maybe you will be the one who will say the last words and make some conclusion of all what we heard. And
thank you. Yes, I'd like to say, maybe if you may allow me to say conclusion both to this panel and general our forum regarding this panel discussion. So that the war can be won by the one who is prepared and who is active, and who acts, not by those who are afraid of actions or doing it slowly. So this is the one, and we have to be brave. I mean those who personally have been involved, so decided to go to work to government, or those who decided to go to work to public institutions, to task forces. So world is looking on us, and I see also that the hope, because we have bright and effective ideas, and everybody, so no doubt about this panel, but also about those institutions behind our positions are willing to work, to do. Of course, we can say, but you know, we are just small nation, Latvians or sorry, Lithuanians. They are bigger than us, and also with brighter and with much stronger history and as state and past, or any other institution can say so. But we together are the force. We are together with all international society, and everybody wants to do it. We are together with United States Department, United States Justice Department, and other departments of United States. We met in Riga with head of State Department, and Riga and Baltics are now, well, we are again on the stage of history, I would say. Don't be afraid, fear not from and don't run from your responsibility to play the role in a historical moment. This is what I would say to all of us, and I believe that together we will win. And what regards to generally about forum, I really want to thank everybody, each of you who attended this, both who participated in panel discussions, who were in front of us now, who joined us, and those who maybe see in online or afterwards will follow to us and to this work. I know that in our ministry we will collect all the ideas and we will work further. Thank you, all of us. I also want to thank special thank to organizers of this forum, because all good words that I received, that is just like you told my name, but in fact we must to say thank you to Ministry of Justice, Ministry of Justice of Court Administration, a team of Court Administration who organized that, and personally to Anna Skriabina, to Elina Šķipare, to Liva Matuzale, and also I would like to thank to team of Ministry of Justice and in personal to Christine Pommere, Deputy State Secretary of international in response to international affairs, and Anders Miltana. Thank you also for because the department that and part of departments that are heading by Deputy State Secretary Ms. Miltana. They are working with elaborating those offers and ideas about sanctioning. And thank you, Michal Popsuyevich, the State Secretary of Ministry of Justice. So thank you, all of you, and we'll see. So see you soon next year. We are starting to prepare Riga's Justice Leader Forum 2023. Thank you.
Paldies!